house the other day in the hallway. You're singing "Oh Happy Day."
One word prayer. Justice, where are you?
Well, I'm not sure you can tell where I am, but can you kind of see that right over my shoulder there?
Is that one of the bars that we've been talking about?
I think it says Waterfall. I'm not positive. I don't read backwards very well. I don't read forwards.
Well, good evening, Michael
Hello there,
Bryant.
Baden. How are you?
In Dedham, Massachusetts. Dedham.
I'm in Canton today. Now I'm in Canton.
And now you moved over to Canton? Yes, because you're at the bars. You're in Canton now.
Yes.
So if I had guessed where in the world is justice, Michael Bryant, I would have said. I would have been wrong.
You've been wrong. You know, it's funny. Somebody commented earlier, "Hey, how can you say you're live in Canton when you're at the courthouse?" And,
Because you're
okay, fine.
Yeah.
That's right. That's technically correct, but people kind of associate Canton with this case, even though the courthouse is in Dedham. So we were there earlier, and now we're in
there. And you're right there, right?
It's 5 minutes, 5 minutes across town. No big deal.
Yeah, and you've been there now. This is what, your third or fourth trip up there already?
My 23rd trip. No, yeah, it's been third or fourth. I can't remember now.
Yeah,
so I'm over here eating at the Waterfall, and kind of getting a feel for what's going on there and chatting with the folks who work there. And let's just say they're not excited about another trial coming their way, because it's become sort of, I'm kind of out here, I guess. It's been sort of a tourist stop, as it were, for the true crime aficionados who are following the Karen Reed case. Up the road there, McCarthy's right here, and it's about a 3-minute walk or 4-minute stumble, depending on how many drinks you've had. And then here at the Waterfall, of course, is the last place that Karen Reed and John O'Keefe and a number of others from that night's activities were before they headed to 34 Fairview. So it is a very well-known place, but not necessarily, according to the folks who work here, for the reason they would prefer it becomes known. I'll tell you this, unbiased opinion, an amazing hamburger, an amazing Angus beef hamburger. It was massive. I couldn't finish it. It was massive and very good, very well done.
I know you took a photograph of it so you can annoy all my vegan friends.
Is that what that is? I don't know if Missy has access to that or not. No, she does. Oh, she says she does. So we're going to be debuting. This would be the Waterfall hamburger. Does she have it? She does not have it. She's looking.
But let me say what she's looking. Hi, Shy Gal 8. Nice to have you back again. Hey, Kay Schmidt. Nice seeing you, Brooklyn. It's Michael. He pronounces it Michael. Although, as you know, my series says Michel Bryant, like a Bryant ham. Oh, I think we're going to see something. Here it is. There it is. This is the Waterfall.
Instead of vertically.
And we're not getting any promotion from this. We're not getting any money. You're just showing what you ate.
The bill. Yeah.
Just paid the bill.
So it's a massive hamburger. There's no real point of reference there because it's got those big thick fries, home fries, I think they call them. But that's a GI bomb, and it was very good.
I'm Prince Lover. Well, I have a surprise for you later on in the show, but because of that. But yeah, you're kind of like, have you ever tried a vegan hamburger while we're on the subject?
What did they call them? What they call them? Something, the mystery.
Well, there's an Impossible Burger. There's Beyond. Yeah. There's Tubi barking.
Tubi, you just started talking about hamburger in the dog.
Tubi said, "I want one." But anyhow, no. There's been a lot of people there. You've been there all day, and you talk to people, as you mentioned. I know a lot of us want to know. A lot of people want to know what happened today in the courtroom, and we have a new motion to talk about.
What a surprise!
Why don't I turn this over to you to kind of narrate what you did and the people you spoke to? And you can only do that if you're on the ground. And only Justice Serve TV was on the ground. We were there, even though I will mention again, according to Canton, according to the state of Massachusetts, we are not real journalists. We're journalists, but we're not the kind that gets into a courtroom.
Yes, not media. YouTube is not media. So whenever the participants enter the courthouse and the courtroom, and there's nothing else to wait for all their supporters outside. This is the Karen Reed contingent.
Right.
Then they go across the street, which is the county clerk's office. Get your marriage license, file a civil claim, whatever. And they have this great setup down in it's the basement technically, but it's kind of the cafeteria. And these folks just take it over in a nice way. They're just staying out of the cold. They watch the trial in there, or the hearings that are unfolding. So they watch. And during one of the breaks, while you were busy, I was able to, I wouldn't want to interrupt them during proceedings because they will
Right.
shout me down, I'm sure. So I just stopped in and chatted with them for a few minutes during one of the breaks, not the lunch, not the end of day, but just one of those, Bev, let's watch the rotating fan for what seems like, an eternity, one of those breaks. And so we had a chance to talk for a few minutes. I think we're going to play that. Do we want to do that now, or you want to do that later? What do you want?
Why don't we play some of it now, and so we can get a feel for what's happening there?
Okay. And because Missy and I were like, hey, I don't know, let's see how to do this. She's going to run it. So let me just ask generally what you guys think about what's happened so far. And what do you think in particular about the investigation, the federal investigation now, at least it's been represented that it's ended?
No, it's not.
So
Yeah. Well, why do you think that representation was made?
they may, it hasn't been officially announced. Just because Hank Brennan says stuff doesn't mean it's completely true. We don't completely know. And the feds just don't go around randomly calling a chief of police or anyone else saying the investigation's over. And with this investigation, even if per se they're saying that it's over, that doesn't mean that this first investigation didn't lead to 3 other investigations off of this. This case is also connected to the Sandra Birchmore case. We well know that the Sandra Birchmore case is not closed. So just, if it is true, which we really don't know just because Spanky says that doesn't mean that if they close one door, 3 other doors don't open.
Okay, so other than your suspicion that Hank Brennan might be just saying things to make himself look good and maybe close the door, what do you have it?
The office had no
He
comment.
lies a lot.
Well, that's why I'm asking. What's your source for the
media-
information?
When the feds come out and they do a press conference, then I'll believe it.
The
But like
defendant-
I said, just because one door closes doesn't mean 3 other doors don't open up off this investigation. As I said, Sandra Birchmore's case is still open, that's still ongoing, and that does have connection to the Karen Reed case, and the players are the same players in it.
So you're saying Karen Reed personally, or the
No,
team
no,
suggested that it's still ongoing?
Well, they had no comment. So the media called the office in Boston, they had no comment. Why?
They're
they-
saying it
How
on
often do you see
sources.
a trial? How often do you see a trial where the prosecutor or the DA don't make press conferences discussing what takes place? The defendant's attorneys are the ones speaking to the press. That tells you something. It
Well,
tells you.
I will tell you, in my experience, quite often the prosecution says nothing during the course of the trial. That's not unusual.
Well, I think it's unusual because I follow a lot of trials, and I've always seen a prosecutor, whenever there's a big change in the case, there will be some sort of press conference that takes place when there's going to be a second trial. They will discuss in some way, they'll say, we won't discuss the details of an ongoing investigation, but we will tell you we plan on moving forward with this and we plan on moving forward with that. That happens almost every time, especially in a high-profile case, especially if they're trying to win the public trust. But that doesn't seem to be the case right now, and I wonder why.
And you're talking about Hank Brennan, who represented Whitey Bulger. We here in Massachusetts know how crooked the stuff rolls around in this place. And everybody is covering for anybody. So Hank Brennan is on his knees and he's saying whatever he wants to say. We've watched it in open court, him just spill whatever he wants to spill out. And Bev Cannone doesn't say anything to stop him. But yet when the defense gets up to say one thing, they're interrupted 1,000,000 times and the flow of things. So Hank Brennan can get up there and literally do whatever he wants to do, and there's no repercussion. So he can say whatever he wants to say. Nobody here is going to take what Hank Brennan says at 100% because he can do and say whatever he wants.
Does anybody have any thoughts about the fact that Brennan's a defense attorney now?
I want to know how Brennan
No,
came
it's
up
just
with
an
signing a thing saying he's doing this trial for $75,000 and it's already up to $225,000. Us, the taxpayers of Massachusetts that work, we have this weasel piece of shit up there paying him more than what he even signed on for. Everything that he has said so far just rolls off and there's other stories to it. There's no trust. We don't trust Hank Brennan. We don't trust the prosecution. In the state of Massachusetts, you're innocent until proven guilty. And right now, no matter how you feel about Karen Reed, you should be disgusted at the investigation into this, because there's no way they should be convicting her on what they have. There's tainted evidence. The investigation has been foul since day one. And all the police officers here, you take an oath of what your job is, and they've broken so many oaths in here. So nothing that they did, Karen Reed, we shouldn't even be here. We shouldn't have to fight like this, because she should have been let off a long time ago.
Amen.
And they're backed up against the wall, because they know if one thing, they should have had lesser charges on her. They're the ones that overcharged her. And right now they're scrambling. They're scrambling so hard because they don't want any of this to go on the police officers. They're being protected right now.
Let me ask this generally. How many folks are here, and you don't have to raise your hand if you don't want to, but how many folks are here because of Karen Reed? How many are here, let me start with, because of the process that's concerning you? Yeah, so everybody's kind of in concert there, that it's both because of her and because of the process.
And it also rolls into Sandra Birchmore, because we're all here for Sandra Birchmore too. And we're even here even more because of Enrique Delgado Garcia.
Yes.
So it's rolling into one after the other after the other.
And a common misconception is that people who support Karen Reed don't want justice for John O'Keefe. It's actually not true. The fact of the matter is understanding the fact that Karen Reed is innocent. We understand that in order to get justice for John O'Keefe, you must acquit Karen Reed first.
Would you agree, though, that John O'Keefe is kind of getting lost in the shuffle?
Boston police officer John O'Keefe won.
Right.
And we shouldn't forget that.
He's never lost. That's a false statement. The Massachusetts State Police failed John O'Keefe when they didn't bother to do their investigation following any protocol or procedure. They didn't do anything according to what they should have in order to get him justice. So no matter who did it, who knows if they'll ever find who did it? Who knows if he'll ever get justice?
Well, what I would,
Karen Reed didn't do it.
Sure.
Karen Reed is innocent.
When you go around with your program and you have involved yourself in other police departments, other cases and stuff like that, interviewing, where have you ever seen that a police department collects blood evidence with no photos and puts them in red solo cups into a stop and shop bag?
yeah,
This case should have been gone right then and there.
yeah, there's no doubt when we first covered this, and that was when I was with Law and Crime, the red Solo cup was a joke that we talked about, and the snow blower or the leaf blower to blow the snow away.
These are drops in the bucket.
Yeah.
There is no denying.
But aren't they indications of something bigger?
The fact is, yes, the fact of the matter is that there's more things wrong with this investigation than done right. And I'm not gonna hear negligence. I don't want to hear that. Because you look at the contrast difference between the way Michael Proctor conducted the Brian Walsh investigation to the way he conducted the Karen Reed investigation. And that tells you alone that Michael Proctor knows how to do his job.
All of them became incompetent in the same day with 20 years
Look at all the
service.
lies and
They all became incompetent in the same day.
Let me ask you one phrase that seems to resonate with folks. Grave concerns.
Beth Cannone's job is a grave concern to her.
Great concerns for her. And try to get it in Commonwealth so that the public can't see it, can't know what's going on. That way there, the Commonwealth can, control the narrative to mainstream media, but yet the public is blocked out because of the injustice that's going on.
The last trial, they tried to set up the 200-foot buffer zone. That didn't stop us.
We're not stopping, because we want change. And they're actually, before this gets any farther, we support the blue, but we support the good blue, not the ones that are corrupt. And what also should resonate is, you don't see the Boston police down here in court all the time, sitting in there for their brother officers. That speaks volumes.
What's the vibe you get from, 'cause there are a lot of officers outside protecting crowd control and all that.
Right now.
Yeah, but what's your vibe from them? Are they?
There's a respect among it down here. There's a respect between the people, the officers that are working down here, the Dedham police. the Massachusetts State Police. During the trial, we had the Quincy Bicycle Police. We had tons of law enforcement down here. And there was a mutual respect as far as not getting in each other's faces. But yet in the beginning of the trial, you had an innocent woman trying to walk into court because you're innocent until proven guilty. And they wouldn't even protect her up there. That's a disgrace when you take it correct.
Still don't.
You know, I've been here a number of times, and the support for Karen Reed or the objections to what the prosecution and the state has done, obvious, very obvious. Has anybody you've seen come down here been pro-prosecution? And what would happen if somebody showed up with a big sign that said, one came last week?
Only when it's not too hot, it's not too rainy, it's not too cold. Sometimes they hold their signs upside down. They don't even know what's going on.
They hide their face.
And they usually don't stay the whole day.
I'd also like to point out that it's okay for them to be inside of the buffer zone with their signs and bullhorns and nothing gets done.
What about the music inside the courtroom?
Yeah.
Or him recording live inside the courtroom?
We have stood out in the front of the courthouse steps in rain, snow, freezing sleet, 90-degree days, and stood in line to wait to get into court. And they have literally walked there, 5-6 people, and were able to enter the court before anybody else. Well, we stood out like that.
What about Google, him checking Karen Reed, and he's not allowed in there, but now he's allowed in there.
Yeah, because it's in a trial, because it's in a trial.
Or what about Boston police officer John O'Keefe's mother flipping the bird on camera in the court?
Or what about their walk-in, right? They have a detective that's the Boston police officer that walks the family in. I don't understand that part, right? Why is there a Boston police officer walking the family in? He should, right?
Why is it that the O'Keefe family can roll up in front of the courthouse, park in front of the courthouse, get out of their car and enter court, and Karen's gotta go down the street and walk all the way up? Thank God she has supporters like she does, because she's protected because other people have not protected. Remind you, an innocent woman until proven guilty.
Right, but not in this.
Anybody that enters a courthouse is innocent until proven guilty, and people forget that in the world.
Massachusetts forgets that.
It might have started with
Massachusetts in general
but it's
forgets
not gonna
that.
end there. We're not gonna go away, even when this ends.
The train didn't
It's
stop, the
disgusting.
train
It's
didn't
not
stop,
going
yeah.
Right now, all the supporters down here are all walks
can
of
do what they
life,
want to.
race, color, and creed. Yet we all band together despite all our differences to back, because we want to see Karen rid of these bogus charges. We want to see justice for Boston police officer John O'Keefe. We want answers into what happened. We want answers for Enrique Delgado Garcia. We want answers for Sandra Birchmore. And we're banding together to do the right thing.
Amen.
But the police are banding.
We've never
together
been
for us
violent.
not to find out.
We've never been violent. We've accepted everybody as they've come.
One incident, not
Never
one.
once. Not one incident.
I
No
traveled
police.
here from Tennessee
Right.
just to be with these people.
Because
They inspire me, because
Yeah,
they're
where
out
you
here,
from?
every hearing, these people are out here. Rain, snow, doesn't matter, the cold, they're out
14
here.
degrees.
That has to tell you something, that has to tell you, and it's
Every
always,
Saturday,
there's no
every Sunday,
That's what I'm
incidents.
saying. Yep, stand out.
There's no incidents that take place, nobody's getting arrested, nobody's getting into fights, it's nothing, I've never met a more kind, generous, sweet, hospitable group of people in my life. And every time I come here, this is my fifth trip here, and every time I have never had a negative experience with any of these people.
Got to be here for the trial?
I'll come for some of the dates of the trial, sure.
That was when he said that too about standing out too. That was always my point is, I want, regardless if there's one person out there, if there's all of us out there, and like they said, rain, snow, sleet, hail, I want people to see that we're outraged enough to be out there. That's the problem. People aren't understanding that. That's the issue, right? Is we are taking time out of our days. We all work. We all have children.
We're not all jobless.
We're not all jobless. We have normal things, going on in our daily lives that we sacrifice to be here because we believe in this movement, because we built this movement. And movements grow, they shrink, they change, people fall, things happen, but we've had nothing but, thank God, positive experiences throughout this whole thing.
And the world wonders, like, how can this be such a big corruption and all this, and if there's no way that's gonna happen. Here in Massachusetts, we remember the archdiocese stuff.
Let's be real.
Let's be real. That went all the way up to the Pope. I mean, they hit priests everywhere that molested little boy. That was here.
One question, why wouldn't Bev just recuse herself? Knowing that we're all front.
Thank you, guys. I appreciate it. Justice Serve TV. It'll run.
Wow.
All right, then.
Wow. I have to say,
As you
first
just
of all,
heard, House.
So a couple of things I want to throw out there before I forget.
yeah, and
This
throw out
Enrique-
who these people are again.
Yeah, first of all, that was we're in the basement of the county clerk's building, which is right across the street from the courthouse. And this is where they go to, seek shelter and just kind of hang out and watch whatever's happening in court until people come or go and they can, put themselves back on the street to create that presence and support that they want to do. You may have heard Enrique Garcia's name. You may not be as familiar with that as you are the Birchmore case, or obviously Karen Reed. He was a recruit trainee in the police department, in the Massachusetts State Police, and apparently died in the midst of some sort of training exercise. Perhaps it was a boxing match within the recruits. And there's some suggestion that because he was one of the few Latin Americans on the force or training to be on the force, there was some sort of racial discrimination that manifested itself in this match or event that was likely to cause him injury, and he ultimately died. So they've heard nothing about that. It happened more than 3 months ago, and they're still wondering what the hell happened.
Well, I tell you, it brings back to me. I love Massachusetts juries. I loved the Hernandez jury. They gave Aaron Hernandez a fair trial, knowing he had been convicted of a murder case beforehand. They gave him a fair trial because, you see them. They stand up for, the Constitution. The state must prove their case beyond a reasonable doubt and all. And I just think that be interesting to check back in with him. And I threw out to you earlier that maybe we can try to get some kind of mock jury going here on Justice Served every night that Karen Reed is there, that we can get some kind of on trial. We can get some kind of mock jury. But I do want to point out again, because of the issue. My husband is in the Sandra Birchmore case, Dr. Michael Baden. He's on the civil. He was hired by the civil attorneys when it was still being called a suicide. And he took a look at it. There's a Boston Globe article on it, I believe, and said, no, it is a homicide. And thereafter, the rest of the story that you can fill it in. I think Michael even better than I.
Yeah, we talked about it earlier about how she was allegedly, involved with this defendant officer and killed herself as a result of becoming pregnant by him. That was the original finding until one Dr. Michael Baden, for the civil side of the matter, did his own evaluation and said, no, this was homicide. Therefore, the feds brought in their own expert rather than just say, well, whatever Dr. Baden said, it's good enough for me. They brought in their own expert who happened to agree with Dr. Baden. And so charges have been filed. That case is plodding along in the federal system. Hey, Brooklyn not only says, who are these people, which we think we've answered, but he points out that my mic cue is upside down here. Or am I upside down?
I thought that was a great pickup.
There we go. Okay. So.
There we go. And then we will get to this Prince lover. What happened to them? I'm a bit confused about what's really going on in Massachusetts. We'll get to that because there's a lot going on. But I wanted to show you. Now, I'm not going to have this. Tubi's going to have a really wonderful dinner, and his dog walker is going to have a very interesting morning tomorrow. Because you had a waterfall burger, I decided to show you as a prop. This is in New York City, a smash burger with French fries and all. So we'll have to compare notes on this. But in any event,
such a different treat. I used to take my son there all the time before he went away to college, and he just loved that place. I like it because it's a very interesting mix. If you can get a great milkshake there, or you can get a beer, and they do make it's a solid hamburger. I will say this: it's half the size of the waterfall burger.
Oh my goodness gracious! Because this is a good, 5 inches
Yeah,
long.
well, this is
I mean,
8
it's
ounces
big.
or more. It's more than a half
Wow.
a pound of meat.
Wow. So anyhow, that's my prop for you. Yeah,
I'm
Prince
full, but
Lover.
thanks anyway. Yeah.
Yeah, thank you, Prince Lover. We'll get to that. So anyhow, I'm moving that over here. So again, all my vegan friends do not get upset when they think that that's about to be consumed on national streaming TV. Okay, so we had a lot happen today while you were out talking, and these people I thought they were just wonderful. I mean, I think they're wonderful.
They're legit. They're just honest, regular folks who are very passionate about what they think is happening in their community, and not just the Karen Reed case.
Yeah, and I didn't even know about the additional bills. I thought that the Hank Brennan was getting $75,000 and was being renegotiated.
Well, yeah,
in
and
June.
again, I take a lot of what they're blurting out with a grain of salt because it comes from various sources, and maybe it's not double sourced. But the original plan, as I understand it, was $75,000 max up to June. And if things carried on beyond June, it would be renegotiated. So whether or not he's actually run the bill up past $200,000 or not, I really don't know.
Yeah, but anyhow, so I'd like you to continue following them when you go. You seem to have made friends, but you make friends.
Yeah, I'll see them again tomorrow. Yeah, they'll be there.
Yeah. Maybe we'll get their names. Maybe they can be our mock jurors every night.
I'm sure we can round up a few because, as I mentioned earlier, at first they were like, I go in, tell them who I am, and I don't just start rolling, right?
Right.
And I ask if it's okay, and if anybody doesn't want to be on camera or say anything, I understand. And so one or two start talking, and then, as you could tell, it kind of erupts, and everybody has some opinion and some perspective that they want to share.
Yeah, no, listening to them was just, to me, was fabulous because, everyone says when you try a case, you shouldn't look at social media. Let me tell you that when we try cases and I have teams that try cases, I suggest they look at social media because you can get a pretty good idea of what people are thinking. And you get some pretty good lines. I mean, I know we borrowed a few lines from social media and thank people because, you're trying the case as a lawyer, but they're watching the case as jurors, people on social media. So it's a very, very interesting situation. Speaking about interesting situation, did you see what people coming out of the courtroom today? How was it? What was it like when you were there?
Yeah, pretty. It was actually going on live as we were on later. This is what was that, like 1-ish or so when they left? It was a pretty early day. We could talk about what was planned for today versus what actually happened, but they broke up early and just as usual, and it was funny the other day. Karen Reed came out with Mr. Yanetti, and they went, left. And as I followed Mr. Jackson and Mr. Alessi, they went right. They split, and that was unusual. I hadn't seen that before. Well, today it was Karen Reed and Mr. Jackson, and more as a group that they've normally come and gone as. So I didn't get a chance to yell at them, or I did yell at them. I didn't get a chance to talk to them as I was across the street doing this. But it looked more. I just felt a real seriousness last time as a result of remember what was going on. It was the whole follow-up to the grave concerns. Which
she still hasn't ruled on, which Judge Beverly Cannone still hasn't ruled on after taking it back. Right.
Of course. Yeah. So I don't know if her grave concerns are better now or worse, but no real decision on that front. She did rule on one thing today. Should we get into what happened today?
Yeah, let's get into what happened because there were 6 things on the motion. There's also a 7th motion that was filed later this afternoon.
Yeah, so I'll talk about what was going to happen. You tell us what really did happen.
Okay.
We knew the fully throated motion to dismiss was on the calendar. We thought it might be first thing this morning because it's the beefiest of the things on the docket. But no, they went with some of these lesser items, and then they called it short. They ended it in part, I think, because they have a few more issues hanging out there that the court wanted better prepared, so that when they do argue them, they'll have all of the information they need and it'll be in front of them and she can hopefully rule. And also because they'll be in federal court tomorrow on the double jeopardy civil rights portion of the case that most will remember was brought in at the state level, saying that these jurors who anonymously said we found her not guilty unanimously on counts 1 and 3, it went up to the highest court and was sent back down, thumbs down. Basically the court saying that you just can't do this after the fact. If something had happened at the time a non-verdict was rendered, at the time the hung jury,
yeah,
missed trial, happened. If you'd done something then, maybe we got something to talk about. But these affidavits coming back willy-nilly, weeks, days plus after, it's just too late, which was not a surprise to anybody. So now they're basically pursuing that same argument, but on the federal level as a civil rights matter for double jeopardy. That's going to be first thing in the morning. So they really didn't get to as much today as we anticipated. And the motion to dismiss went back and forth from being tomorrow, well, no, let's do it Friday. And then it ultimately came back at Alan Jackson's request to tomorrow. He says, I'll be ready.
Right.
He was concerned at first, and they had asked for extra time because the Commonwealth has been providing new information. Last Friday, a chunk, and then yesterday, a chunk. And it turns out, according to Jackson, based on representations by the Commonwealth, he hasn't had time to look at everything himself. They say it's primarily the same material you've already got, but perhaps from a different source.
Right. That's what was saying. Right.
So based on that representation, Alan Jackson said, okay, I'll be ready for tomorrow. He did also qualify it by saying, I might ask the court for a little extra time to provide supplemental materials if once we've actually looked at everything that the Commonwealth has provided so recently, if something new in there, I want to at least hedge my bets and give me a little more time to provide that before you rule on the motion to dismiss.
And what happened was there was 400 pages of new discovery, 4 new reports from officers, and 15 videos of the Sally Port, and 9 videos of them downloading the videos of the Sally Port, apparently.
Yeah, and we know the whole history of the Sally Port video. It existed. It didn't exist. It didn't exist. It was taped over. It was then, of course, I'm calling him, what was his name? Was he a detective? D. Giamonti. He apparently
Detective
was
D.
a retired sergeant.
Yes.
Sergeant. He was a sergeant. Sergeant D. He apparently bumped off the videos onto another drive. What's that drive called?
The detective drive.
The detective drive. Of course, it's the detective drive. So that's where this stuff lived and was supposedly now it's been given to the defense.
Right. But not after the first trial's finished, and after the jury went home, and after the judge didn't do what they did in ASAP Rocky and charge the jury. If you find a verdict, then you know on any count, but you can't find verdicts on another count, you can tell me, and we'll take the partial verdict. Okay.
Yep.
Never seen that done before, but apparently in Massachusetts it wasn't done. So touche. Thank you very much for your donation. Brennan's misrepresentations are a strategic method of obtaining the jury and communicating with the media by providing clickbait and harmful headlines. I was concerned last week, and I expressed this, that all of this stuff, because remember, it was the defense that provided this email and the billing records to the Commonwealth that happened in July, well after the verdict had come in. And he initially represented to the court that they had gotten them from, I guess, the federal government. They hadn't been provided by the defense, which was untrue. He corrected that misrepresentation, but you know that lie flew around all over. And I was concerned that if you were going to allege that, you could have asked for an in-camera hearing. The judge could have granted it, released the transcript afterwards if you had to. But in the meantime, Karen Reed, in my opinion, suffers from the taint right now that possibly the defense was doing something wrong. And one of the things I think Hank Brennan has done, whether you like it or not, he is kind of leveling that media playing field that he thought was against him by doing this. Now, is that purposeful? I can't say, but you all can draw your own conclusions.
And remember, one of the things they talked about today, right off the top, was sanctions, right? The Commonwealth wants sanctions because the defense has been talking. You know, we know the whole Karen Reed interview, Boston 25 did that. It was half an hour, and they trickled it out in 5-minute dribs and drabs here and there, and then the whole thing. She's clearly not been shy about talking to the press. And the requested gag order, almost as a sanction, requested was not going to be directed at her, only her attorneys. And so we looked into 3.6, which is the protective order under the code. And there are exceptions that really seem to cover most of anything that Yanetti said or that any of the other attorneys said. Things that are said in court, which would include up through and including the entire first trial. You can't really claim that if you talk about that again, that it's somehow subject to another protective order. It's public record.
Yeah.
So we didn't hear any sanctions leveled. We didn't hear any gag order. So she didn't. I don't know. Again, is it pocket veto time for Judge Bev? Stuff just kind of lingers, and then I guess it's over. So she hasn't really ruled on any of that.
Right. Interesting, though, there was a sidebar dealing with the grand jury transcripts, but let's go into this, because Afton asked, what did you think about the way she made the defense team stand up like they were in kindergarten? So this is what happened first. For those who weren't there, it was Mr. Alessi, Mr. Jackson, Mr. Yanetti, and attorney Ms. Little, Attorney Alessi, Jackson, Attorney Yanetti, and Attorney Little that were there, right? And there were 6 things on the calendar. And she started out by saying, lecturing everybody, that she says that all of you understand that whatever you say, okay, by one is said by the other. You have adopted the other person's admission. And she made everybody stand up in the defense team and say that. And yes, I understand. Yes, I understand. Yes, I understand. Yes, I understand. And then she went into the invoice billing with Mr. Alessi, who the Commonwealth calls Alessi, but Mr. Alessi, and happened to, my reaction, and I wrote actually in my notes, judge is pissed, okay? That was what that's a legal term. It was a legal term, because she said, why did you tell Alessi, well, you mentioned the invoice, but why didn't you tell me the invoice had been paid? And he said, because you asked me a question, Your Honor, after I said that, and that was the next on my list, because I told you I was doing everything in chronological order. All right. And so the feeling I got is she thinks that there's some kind of a hiding by the defense team about what really went on, because Alessi then says, you can infer by that, Your Honor, that there was no communications after there was a Paul's memo. Remember, there was a email from the ARCA people saying, here's our retainer agreement, or Jackson, I forget which way it went. And it said, send your retainer agreement over and we'll sign it. And then the ARCA people, there was a pause. They'd spoken to the federal government. They can't do that. And so Alessi says you can infer by that nothing happened until Mr. Jackson got the bill back in July, well after the trial ended. And the judge stopped him and said, are you just saying you can infer? Are you telling me there were no conversations? And he says, I can infer, you can infer that. So to me, she wants an affidavit, right? She wants something from Alan Jackson and Yanetti to say they never spoke thereafter to ARCA.
Some sort of affirmative representation. She's, Judge Bev and I are kind of on the same page with this one issue, because I do think there's some gaps in this period of time between, hey, we were going to retain them, then we weren't, and then, wow, an invoice showed up. And we talked about that the other day. Was that just last night? The 0.75 that was
just
billed
last night. Yes, right.
So long ago. That 0.75 that was billed by the ACA experts, and I'm saying, 45 minutes. Come on. All you did was talk about what day we need you in court, how you get here. Tell me a little about your background. I just think it raises questions, and it seems to me Judge Bev had similar questions. And Alessi is kind of the buffer on this whole thing. He's not lying and saying, no, I know for a fact. He's saying, I'm inferring it. Well, if you're inferring it, let's get the folks up here who have the firsthand knowledge of it. So the judge has not gone that far, but at some point she might.
So that's where we were at. And then it kind of stopped and everything kind of calmed down a little bit. There was a little detente in the courtroom. And then Mr. Alessi started with the motion to exclude, and he wanted to exclude first a biomechanical engineer named Dr. Crosby on the issue of dog bites. The issue of dog bites.
And he also studied dog behavior, canine behavior.
Right. And apparently he is a former police officer who retired, went to Florida, and has testified a lot about canine behavior. Now, we don't need a dog expert to tell us that Chloe, if she's bitten 2 other people in the past, may have some canine behavior issues. I mean, as I keep quoting Bob Dylan, having seen the movie just recently, you don't need an expert there to know which way the wind blows in terms of Chloe.
Let me take an off ramp here to talk about something very interesting that happens in most people's lives. People have dogs; they occasionally bite people, right? Some states have what's called the 1 bite rule.
Right.
Before you're responsible for what your dog might do, that means every dog kind of gets the benefit of innocent until proven guilty. But if your dog bites somebody one time, no matter what the circumstance, and then it happens again, you're doomed, because the 1 bite rule takes away any protection that you might have. So in this case, Chloe is
wait. Your dog is doomed.
Well, they don't necessarily put the dog out of its misery, but you will be liable as the dog owner for damages caused by that bite after the first bite. So Chloe was, if you believe Chloe was the one who attacked John O'Keefe, that was bite number 3, I think.
Yeah. So there was a lot going on with that motion, because it had also to do with molds and whether or not dog forensic odontology. Can you match a dog bite? And all, because the Commonwealth apparently took a mold that they haven't showed the defense, but you're going to show the defense, and they're going to say the mold doesn't match the dog teeth. But as Mr. Lussey points out, he got the same issues as human forensic odontology. Your skin moves,
and the body's moving. Nobody stands like a statue and lets the dog bite them.
Right.
Especially if you're not sober, it's freezing cold, the weather's weird. Yeah, this is, to me, that's the least of the issues, is the puncture wound patterns. If they're determined to be a dog, I'm sorry, Chloe, I don't care what you were doing. If it was Chloe, we don't know if it was Chloe, and we may never know for sure because it's not that relevant. It's a dog. If a dog caused those wounds, then it may not have been from any impact with the car.
Right, and I don't think those wounds, when we saw pictures of them, just as a layperson, it didn't look like it was impacted.
Well, I always go off on this whole damn tail light thing, which I didn't bring with me. I had to limit it somewhere. What I'm bringing, my stuff. I do have the little baby SUV in the car somewhere, but I think of that tail light just exploding on impact. 45 pieces found over a number of days and weeks. Those shards are the kinds of things that maybe could inflict some scratches, some punctures, some cuts in an arm, but the speed with which that car would have to hit somebody in the arm, I think exceeds logic in this case, if it happened at all.
Yeah, and the judge kind of took an off ramp with him too here in terms of whether or not, because the defense was asking for him to be excluded without even having a Dahlberg-Lanigan hearing. Lanigan is the Massachusetts case that deals with basically Dahlberg in Massachusetts, and she asked the Commonwealth at the end, "Are you planning to call him in your case in chief?" And Hank Brennan said no, he wasn't, and she said okay. So to me, that sounds like she's not planning to deal with this issue unless she needs to. Because she doesn't want to spend another day of Dahlberg hearings going to the trial, because as she mentioned today, hey, you all have to get ready for trial. And that's what they've been saying. The attorneys have been saying that, Yeah,
with all of these things, all these gymnastics taking place, that April 1st trial date has not moved.
No, and it doesn't look like it's going to.
No, this thing is just chock-a-block right up until that date. And that'll be the date when they begin jury selection. That's when a trial officially begins, is the first day of jury selection. I don't know, could take a couple days, could take longer. Hard to tell. Hard
to tell, right. And given this, Nancy, thank you for becoming a brand new YouTube member. We truly appreciate it. Then there was a second motion. That came out. All right. By the way, Mary Lara says, wow, what a great report. Thank you. We appreciate. We'd like to send Michael Bryant out in the cold.
As soon as it warms up to like 50, I'm out of here. That's it. It's just not challenging enough if it's not in the 30s or 40s.
He's such a good reporter. The second motion was to exclude a meteorologist named Gilman to testify about two things. One is that the ground was hard as a rock, and the second thing was how grounds become hard. And I think Hank Brennan said he agreed not to let Gilman say that. But I have to tell you, Michael, I was thinking about that all day. I'm brought into cases a lot of times to say, okay, what is this trial team doing? What are the theories? Where are we going? If I'm the defense, I'm not sure I want that out, because if indeed a fall from being drunk and slipping is the mechanism of death, having nothing to do with the car, I want that ground to be as hard as a rock.
Yeah, I don't disagree with you. I think give them something else to think about that was the cause of the fatal injury, whether he stumbled drunkenly and hit his head, or even if he was bumped by the car, if you believe that, and then ultimately stumbled and hit his head. I don't think it's bad.
Right, or running away from Chloe and stumbled and hit his head.
Poor Chloe.
Or just was drunk, got up, and fell down again, and and hit his head over again. I mean,
on the rock hard ground.
On the rock hard ground. So I mean, the defense is fighting to keep that out. I'm not sure They want that out. I mean, if they think about it, but maybe they have. I mean, obviously, I'm not part of the case, so I have no
They
idea.
may have something going on that ties into that doesn't help them. But bottom line is, they sort of kind of agreed the phrase "the ground was rock hard" is not going to be elicited from the jury,
Right.
from the witness, and also, I guess, his interpretation of how the ground becomes hard
Right.
is also going to be avoided.
I'm not sure why that's, how ground becomes hard, it gets cold,
Well, I mean, unless he would be testifying that after a certain number of hours at a certain temperature, this is what happens,
Right.
cause and effect based on, to me, it's pretty common sense. Anybody who's lived in an area that's somewhat cold knows over a period of time in the winter, and we're talking January 29th, that's a long time in the cold, the ground gets hard. Some would say hard as a rock. Objection.
Yeah,
So,
I don't know. I don't know.
I don't even know that he brings a lot to the mix, really. He's going to say that there was weather and this was going to, ultimately it was going to be a big storm. But remember, most of the storm had not occurred.
Right.
At or about
Right.
the time John O'Keefe collapsed on that front yard at 34
Right.
Fairview. It came after that, which at 5:30 in the morning, when Karen Reed and her friends were looking for John O'Keefe, it made it harder to find him.
Right.
But at or about the time he fell, pushed, collapsed, whatever happened, not much snow at that point, which is why a lot of people say, how come all these people coming and going from 34 Fairview, you didn't see anything? And there was one witness who thought they saw a dark shape over, across the lawn near the flagpole.
Right.
And I've been there. It's not that far. It's really not that far from where you'd walk out the front door. It's not a massive front yard. It's more like a normal neighborhood. I just do find it odd that all that, and that's what leads some people to that conspiracy theory, right? They would have seen him because they knew he was there, and that's why they pretended not to see him. They knew he was there.
You also had this snow cleaner person,
I always like the snowplow guy. Yeah.
The snowplow guy who didn't see anybody. It's the most amazing thing, because in Hernandez we had a street cleaner that became important. Came through. I don't know. Maybe it's just Massachusetts. There's a dog in every case. There's a street cleaner. I don't know. So that was that. Then there was a Commonwealth motions for sanctions against the defense team, mostly Yanetti, because he wrote a brief, and apparently he had put in, he said it was accidental, something that there was something that was privileged or private and protected. It was not supposed to begin. It was under the protective order. And he said, look, I did it unintentionally because, look, I put initials in for juveniles. I was aware of that. And then when Hank Brennan called me, I said, oh my gosh, I did. I mean, he owned up to it in regard to that. Then they went to sidebar on then there was an email. Apparently that was released, and it was Proctor from Proctor, the Proctor Factor, talking about how his opinion and how he felt about Alan Jackson. Well, my feeling is, so what? I think we all can surmise how Mr. Proctor feels about Alan Jackson.
Yep, and it probably wasn't very nice.
I imagine that there's some words in there that we can't say even on this show. And
we probably could, but we wouldn't.
Well, you never know. You never know what can come out of our mouths, right?
Hey, look at M. Crott. Why is the judge so locked on this April 1st date? Makes me wonder. I'm just assuming, based on understanding court dockets and calendars, and you keep pushing one thing, it pushes. It's like a domino series, right? So This is the second trial. That means they've already used it in a way that's clogged up the system, and some would say that's Judge Bev's fault. But I think there's other stuff that needs to be done. And you believe maybe she won't be on the bench all that much longer. Is that you think she's going to get elevated to something?
I think she's going to get elevated. I believe she's going to be elevated. Okay. She's one of the stars. I mean, people don't like her, but she's one of the stars. She was the head of the rules committee, and you just don't do that. If you're not getting appointed by the Commonwealth, the head court, unless you're considered a rising star to one of those committees of which she had for discovery. And she changed the discovery rules, which are very beneficial to defendants going forward, just so you all know on this. So then we had the final thing was a motion for sanctions. They actually went to sidebar for about 20 minutes. And apparently because Yanetti had quoted some grand jury testimony, which is a big no in Massachusetts. And that was
and really anywhere. It's totally sealed in most cases and never released. And if so, it's years later. It's pretty sacrosanct. And so if that was used in paperwork, oopsie. I probably shouldn't have done that.
But it didn't. They didn't come out and say, "Look, there's any sanctions against him," which was good. So I don't know whether she imposed it or, he's like Yanetti is like the guy. He's the local guy. He's the guy everybody likes. He's a good lawyer. We don't want to hurt him. All of these pro-hoc people. They're the boogie people that have come in here that have created the out-of-towners, right? Who created this. And then there was the motion for the scheduling order, which we already talked about, to amend the scheduling order, to move the motion to dismiss argument up until the 17th. The judge said, we're not hearing it on the 17th. That's, the neighboring county, it's a holiday.
We're back over here at the waterfall.
Yeah, well, if you're
right. at McCarthy's.
Yeah, in Suffolk County, it's actually a holiday. It's actually a holiday in Suffolk County, not, which is the neighboring county. Right. And then there was a motion about the video cameras to reconsider the motion to get the metadata. And there was some back and forth with attorney Elizabeth Little about whether she could look at it or whether they come back on Friday. And I guess they decided to try to look at all the metadata tonight and see if there was any supplemental arguments. That was kind of unclear what happened there.
Yeah. And so then the newest thing that happened, because again, they left court at 1-ish, somewhere in there. And then there was a filing after that.
Right.
Now, I think, Missy, we have that handy. If we don't, I definitely made some notes about it somewhere. Let me reach in my pocket here and get my official.
I have it right here. I have it right here. You have it right there too. I know. I've been going through. We're going to need more of these books because I'm going through Justice Serve TV. We better get our merch store up one of these days.
I know.
Because I'm going through these like there's no tomorrow, dealing with this.
Okay, so this was a motion by the defense to exclude the expert Dr. Wolf, the neurosurgeon. Okay. Now, I hope we have at least a couple of those pages to look at because there was one quote that I thought was very interesting, and that as a defense attorney, I'm not sure I want it out, but they're trying to exclude him. Basically, here are the reasons. Because number one, he's a neurosurgeon. He's not a forensic pathologist like some of our friends are.
Who are board certified. And let's explain what board certification is, because a lot of people don't realize the importance of that. When you are an expert witness, there's an independent board of medical specialties for doctors that has a certain amount of medical specialties, not that many, and there's subspecialties. And you have to practice a while. You have to go through testing. You have to do all sorts of stuff. You just can't come out of medical school and say, oh, hi, I'm an expert in such and such. You have to be declared an expert. And there's various areas. There's forensic pathology, like my husband is involved in. That's usually what a medical examiner is. There's anatomic pathology. There's clinical pathology. My husband has all three board certifications. But it's an independent certification, and it shows you have an expertise. I mean, I was once in a trial that a co-counsel got up and said, oh, put on a glove. And I almost went under the table because you can never tell what a co-counsel is going to do, and said, put on one of these gloves and said, and he's not a proctologist. And I'm like, oh, dear me. But you get the point. You just can't get out. You can practice, but if you practice and hang up that shingle and says you're an expert, you're really not.
No, you can't just on your own say, I'm an expert because I'm an expert.
Right.
So this guy's a neurosurgeon. Great. I mean, good for him. He is truly a brain surgeon, right?
Right.
But that's not what is required to be qualified to give an opinion as to the cause of death, the mechanism of injury, or, interestingly enough, the ground conditions. Why is everybody so concerned about the ground conditions? But those are the three opinions that are being elicited by this from this expert, and the defense is saying, well, no, not a pathologist, not qualified to do any of this mechanical study, and he's a treating doctor.
Yeah,
he's
and in Massachusetts. And in Massachusetts, like most other states that have a medical examiner system, Massachusetts does, you have to be, and one of the things they require is that only a medical examiner can do cause and manner of death and how this person died in terms of state certificate, a death certificate, right? You can't just hire the local person.
This guy can't even sign a death certificate.
For a suspicious death. If it's just somebody who died of heart disease and they're your patient, then you can do it. But if it's a suspicious death, you can't do it. It's got to be a medical examiner case.
So here's something. I'm going to pull this up here. I think I've got it figured out here. This is the newest filing, and it was filed. You can barely see it there at 1 something this afternoon. So, the day was not even cold. Oh, I can't seem to advance it with my system here. Doggone it. I apologize. Yeah, somewhere down below this document. Is there a way for me to do anything with it here? Bear with me here while I'm trying to figure it out on the fly. Nope, doesn't look like I can advance it, but I will tell you, I can see it, and I'm going to read it to you.
Right.
There is a quote in here as they're talking about the lack of qualification. There is a quote, and it is from the prior testimony, I guess it is. And he's basically saying, among other things, that the cause of the injuries did not come from, let's say, a blow from a blunt object, and even says, or likely from the impact with a vehicle. Now, seems to me that might be something I would want the jury to hear from this expert. And if you're going to exclude his testimony, you're going to exclude pretty much everything. I'm a little confused as to why they would.
Well, I think we just lost Michael here, and what he's talking about is this motion I have in my hand. I'm sure he's going to pop right back, and there he is. He popped right back on.
I'm not sure why they would not want. I guess they got to get rid of all of it, but they quoted in that document what I thought was pretty beneficial information for the defense. So well, we'll see. Maybe there's other. We don't tomorrow,
have the
maybe
report.
Not.
We don't have the report. So tomorrow, I assume they're going to get to this motion, or maybe not. I don't know. They're going to do the motion to dismiss. Mr. Jackson said it would take him about an hour and a half, I think, to argue, and then Mr. Reed said. Mr. Brennan said, I'm sorry, Hank Brennan said something about maybe a half an hour. I take these lightly, shall I say?
Yeah. Yeah. Well, there's time and there's attorney time. So, every attorney ever, it's almost like you learn this in law school. Ms. Kenney Baden, do you have anything extra? Yeah, just briefly, Your Honor. Yeah, just briefly. Yeah. No, nobody's just briefly, right? Just a few questions.
I don't know why they call it a brief even.
When you're right, they call them briefs. They're not brief. Alan Jackson said what? He said about an hour. About an hour? Is that what he said?
Yeah, about an hour. I think he's about an hour. But because she said, because remember, there's that federal court hearing, which is at 9 a.m. if I recall, right, in federal court. And so she said, be here at 11, but you could, if you're here
earlier.
Right. We don't know. The federal court may have moved it up for them to move to 8:30. I've had that happen, and we don't know.
That would be helpful. It is, from here and from the Dedham court, it's about 45 minutes on a good day. It's only 24 miles, but we're talking about, Boston rush hour. It's right in the heart of Boston.
Right.
So that can't be an easy slog. So that's going to take a while getting there. Maybe it's a little quicker coming back, but we'll be at the Dedham courthouse.
I think she was trying to try to see when her day would end tomorrow with all these motions, right?
Yeah, and I know in her mind it's 4:00, but I'm pretty sure if they got close and, they could squeeze in one last, because most of them, after the fully throated motion to dismiss, most of them are pretty short and quick, I would think. So that's the goal, get them all in tomorrow, and we'll be there.
And I hope we've answered all your questions, although I will put this back up. Nancy says you need a scarf and a hat. I think she thinks we're abusing you.
Yeah. I haven't gotten the California out of me. I've only been on the East Coast 20 years. I still think I'm in California. There was a note from, Prince Lover said that I was kidnapped by Starlink. and we do have the Starlink up and running tonight, and it's flawless, works great. Operator error is a problem, but Starlink.
It was like pilot error. You don't want to know why.
I was looking for that document, and I took myself off the air. All right.
Yeah. Anyhow, now I know that a lot of you are watching, and there's a lot of you chatting. We have to tell you, and we have to ask you to please, while you're chatting right now, could you hit that like button for us? That gets us into, and the reason why we're pressing on it, we're supposed to ask you constantly, but we don't do that. Michael and I forget because we really like to talk about the substance. But that gets us into the YouTube algorithm to get shared, because we're a pretty young streaming TV station. Okay, so it gets us in the algorithm, and you can subscribe, and you can like us, and you can share us, and you can hit that notify button. And guess what? It's free. It doesn't cost you any money at all, at all. But it does help us, and it helps you. Some of you have found us through that. And also, we have volunteers who are moderating the stream, who work extremely, extremely hard here. Missy is on tonight. She is prepared thumbnails. She is leaving. She's tweeting. She's doing all sorts of things and all. And so and to honor her, please hit that like button for Missy. Even if you hate us, hit the like button.
Where's the don't like button? That's what I'm going to hit. All right. Well, I'm going to get out of here, and we'll see you first thing in the morning. Right?
We're going to plan to start streaming at 10 a.m.
At 10-ish,
we'll probably,
see what happens.
And if it's not there, we'll just replay from today until they go live. And then we will jump on the air as soon as they go live, and we'll be here to talk about it all tomorrow. And tomorrow night, you may have to ride home if we have an hour after court. We'll see.
Yeah, we'll see how it goes.
We'll see how it goes. And then also, we want to get your questions in. There's a lot of questions we don't answer from the last 3 or 4 shows. Missy's trying to compile a list so that maybe we can do a show where we answer all the questions that you may want to have and didn't get a chance for us to answer. And we'll try to run through them like a comment show.
Yeah,
so,
well, like a little Karen Reed catch-up. Karen Reed comment catch-up. How about that?
Yeah, Karen Reed comment catch-up. Yeah, I like that for alliteration. Yeah, so, of course, we'll be on the air on Wednesday, and we'll be on the air on Thursday. But anyhow, we will see you tomorrow. Thank you very much. Michael Bryant, I know you have some words of wisdom.
Oh, yeah. So until then, I'm Michael Bryant. Try to do the right thing.
And I'm Linda Kenney Baden. And if you like us, hit that like, subscribe, share, and notify button, and we will see you tomorrow.
Justice, where are you?
So anyway, there you
Good
are.
morning, Michael.
Such drama. So anyway, there you are.
Good morning, Michael.
Such drama. So anyway, there you are.
Good morning, Michael.
And I'm getting a little reverb here.
Yeah, a little reverb.
Yeah. I don't know if that's something that needs a button switched. I think that's better. Yeah, you very dramatic entrance you made, because I wasn't sure if you were going to be there or not. It was just.
I told you, but it's a trade secret. I had to get my hair done this morning. I had to look at because I knew you'd all be watching. All right. Plus, every once in a while, I try to look as good as my streaming partner, Michael Bryant, the Emmy Award-winning Michael Bryant. But we have over 300 people watching already, and 7-star questions. Missy's been on doing a fabulous job as usual, and I want to thank her before we ever start. Good morning, everybody. Good morning, Dee. Good morning, everyone. Good morning, good morning, good morning. Yes, and also I had to get dressed. I have a shoe of the day. I've been told that I have to do this, okay? Look at the shoe of the day, Michael. I know you don't.
Those look about as uncomfortable as they could possibly be.
No, they're fabulous. They're very comfortable. Mold to your feet. They're laced. They're fabulous. I don't know if I'd run around the courthouse with them, but I'd certainly run in front of a jury with them.
All right. Okay. Let me give you an update on where we are here. I have no idea.
Yeah.
Obviously, the defense team is in Boston proper now in federal court. Trying to get a sense of when they hit the road and come this way. We know there's a soft 11 o'clock start. Could be before that. Could be after that. And there's just a slate of motions for today, including, of course, the full-throated motion to dismiss. What I'm going to try to do, this is my plan, is if I get a heads up or I get some rumblings that there's some arrivals, I'm going to just try and, unplug, and I'll leave this feed up and running, and I'll just try to head on over and see if I can get some comments from some folks before the hearing. I did run into Hank Brennan this morning. He was, totally by himself coming up the sidewalk here.
As a prosecutor in the case they're recovering?
Yes, or either that or it's a guy with the same name. I'm not sure, and looked a lot like him. So I just wanted to introduce myself. Very nice. Shook hands. I said, "How are you enjoying the adventure?" And he just said, "Nice to meet you." So
does he know that we've been we haven't been repping him?
Well, we're just covering the case and reporting what we're reporting.
The problem is we had a group on last night of people who were really after Ed Brennan, and I actually love them all. I mean, I love them. They were great.
Yeah. And in fact, I was talking to Dina earlier. She's the one. She's become known as the woman in the glasses.
Right.
She was very outspoken, and we're working on something with her to kind of gather I'll call it the alternate. Yes, thank you. The alternate jurors. we'll call, we'll Justice Serve TV alternate jurors. And so when this thing rolls into trial, it'll be so nice to get some feedback from folks about how the day went, how certain evidence may have played out, good, bad, or otherwise. So I think she'll be in that mix.
How do you like that? We decided that last night. If they're willing to do it, we try to get an alternate jury, sometimes called a mock jury, to cover the case with us when we're covering the trial, the actual trial, and to see how they're reacting to people and have them on the show. As you know, we love having everyone on the show. As a matter of fact, Missy, our great producer, started by being one of our first guests on the show.
That's right. That's right. And now look what happened to her. So don't use that. Don't use that as a detractor. Okay.
But we have a lot of questions going on. Shall we start answering some of the questions that people have asked already? As
Sure.
we're waiting to start. And this is from Buckdale Joe. Can you discuss Judge Beverly's rotation as a judge and her immunity as judges are awarded? I'm not sure what you mean by her rotation. I mean, the judges are assigned to different counties in the Superior Court of Massachusetts. I forget for how long. I did know this once upon a time. But in terms of immunity, she has immunity from any type of lawsuit that she does as a judge, any type of decision, anything she makes. She could make the worst wrong decision. She could even take money under the table and she can't be sued for it. She could be criminally charged for it if that were the case. I'm not suggesting that's the case. I'm just saying it as an example. But you cannot sue judges. They have what's called absolute immunity. Is that about right?
And I think it has to be that way. There was some discussion, and again, I was talking with some folks here this morning about the apparent rush to get this thing done, or at least begun April 1st, and whether that suggests that Judge Bev has other things to do and wants to get this out of the way. Nobody's sure, but they think there was a rotational issue where she was going to be, if not elevated, rotated out of this department so that her being on this case would have been more difficult. It would delay other things. It's a little vague and a little speculative, but it wouldn't surprise me because that's the way it works. And when a case goes on as long as this has, from preparation through trial number 1, through more preparation, and now trial number 2, it can mess with the schedule.
Yeah. All right. So D has a question. D's been with us for a long time. Has anyone reported Hank to the bar yet? He does not have an ounce of ethics. Outright lies to the court. Smear defense with no proof. Interesting. If anybody decided to report Mr. Brennan to the bar, and I'm not suggesting that he did anything unethical, but anyone can make a bar complaint. But they're private. We would never know if that happened. I think what Dee's talking about is something that you and I have discussed, that the whole thing of suggesting that the defense was unethical and did something underhanded in order to the worst benefit, not the benefit, in order worse to the client, right? And therefore, it was very, 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 to me, that should have all been done in private. I mean, because I think that when you start saying people are unethical, and that's why I'm not even going to say Hank is unethical, it has a certain pull in the courtroom. And I thought that was something that should have been done privately. Your thoughts?
Yeah, and there is, there's a record of anything that is confirmed in terms of complaints or violations, not just the reporting of them. That's generally, innocent until proven guilty. But if there is a reported incident and it is investigated and it is proven to be legitimate, whether it's an ethics violation or something else that is inappropriate, as an attorney, the bar records will reflect that. So you should be able to go into any bar, any state bar registry, pull up Attorney Joe Blow and see what their record is and whether they've had any issues in the past.
Yeah, if it's been adjudicated, if there's been a problem. And I don't think that that's the case with him. It's certainly not the case with Alan Jackson either. But if it's not adjudicated, it's just a complaint, they don't put them in there just as a complaint, because people make complaints all the time. I hate to tell you out there.
Of course.
I hate to tell you out there, except for our viewers, there are a lot of people who can be a little cray-cray sometimes, and they don't like the client you're representing. They don't like anything about you. They don't like your hair. They don't like, the fact that you're using Starlink.
Your shoes. They don't like your shoes.
They don't like my shoes, right? But not our viewers, because our viewers are watching this trial and are very, very, extremely, extremely involved in it. Okay, geniality, I think if I see this rightly, if John was exposed to below freezing temperatures over 4 hours, would his extremities have shown evidence of frostbite? Michael, that's a medical question I don't know the answer to.
Nope, not my expertise, and I'm not sure we heard a whole lot about that, the question became, how long was he in the snow? And at what point, because remember, he was still technically alive. Remember, he was alive when they found him at 5:30-ish in the morning, and they tried resuscitation and other life-saving efforts. So there could have been some frostbite to the extremities. Not going to contribute to the death, unlikely, in my opinion. But I don't know. He was there at the very least, right? At the very least, about 5 hours.
Right. All right. Let's go to this. Betty Swallox, question. And by the way, I asked people, I know that you don't usually like to use caps when you're commenting, but I said, to help Missy sometimes, we know you're not shouting. You can put your questions in caps or put QQ as you have before so that she can see them, because she's doing so much. She started so early. She was up late last night, and she's doing so much. She's just not just monitoring it and running on the feed here. She's tweeting. She's doing other things. So we know you're not shouting, and I see that that we do have some, questions that I will get to. Back to Dee has another question. Betty Swallows, question. Hank said yesterday lay witnesses would testify to how hard ground was. How on earth would any lay witness know how hard the ground was 6 hours before they all arrived? Michael.
That's interesting. It is an issue of time, but who's going to testify and what time period are they testifying to? It has to be the people who arrived to find the victim, at that time still alive, Mr. O'Keefe, or those that were there during the investigation with their solo cups and leaf blowers. Those are the folks that could testify as to how hard the ground was. I do think it is a lay perspective. I do not think you need to be an expert in soil compaction or frozen tundra to just have an opinion as the ground was super hard. But what's it? So what? Again, we've talked about before. Maybe it impacts whether or not there was some concussive problem. If John O'Keefe falls down, for whatever reason he falls down, maybe the hard ground, causes some sort of injury. That's possible. But other than that, other than the just kind of the common sense analysis that, hey, this is late January in winter in the Boston area, yeah, the ground is frozen hard as a rock.
Well, or frozen, or it could be hard. And you and I talked about it, that the defense should try to keep that out, but we think that ignores the benefit of the defense because it gives an alternative theory about falling and hurting himself in some way. So be interested to see where this really is going, because they're all concentrating on it, and there has to be more to it than we're seeing. Or, they don't work.
To that point, it was interesting. We were talking about the expert, Dr. Wolf, who his testimony is going to be attempted, at least, to be excluded by the defense. He's a prosecution expert. And one of his opinions is going to be the ground. The ground. This guy's a neurosurgeon. Smart dude.
Two Dr. Wolf, by the way. Two Dr. Wolfs in this case.
Yes, Dr. Wolf. And, he's the one who the prosecution wants to use to determine manner and cause of death, mechanism of injury, and a third thing is the impact of the firmness of the ground. So everybody's a hard surface expert.
Ground expert, including us. Well, no, we're deferring. We're deferring. You're not.
It's more. I think I could give a lay opinion that the ground is hard. Mm-hmm.
DS, if jury instructions were changed and no further instructions were given to the jury, is that a big problem worth dismissal? If the jury instructions were changed and no further instructions were given to the jury. Okay, you're talking about the previous case. Here's what I think. I really had a problem with the jury instructions in this regard. Every case I've ever tried, and we saw it, ASAP Rocky's a perfect example. It'd be great, and maybe if we can go back and find that clip where the judge in that case, Judge Arnold, told the jury that, by the way, if you can't come to a verdict on every count, but you have a verdict on some counts, and a verdict on some counts means not guilty, could be a not guilty, come and tell the court, and we'll let you report on those other verdicts. I've seen jurors actually do that when they're still deliberating on other verdicts. They say to the judge, "Oh, we have a verdict on some counts, and it was be not guilty." And the judge would say, "No, go back and let me know. If you're gonna if you're still deliberating, continue those deliberations." But I've seen that happen. I think that's an issue also, but I'm not sure it's a federal court issue. Do you see it as that?
Oh, that's interesting. I hadn't really thought about it on the federal court context. Certainly, I hope things change from a state perspective here in Massachusetts when they see what such a simple fix could have remedied in this case. If you just ask the jury, instruct them first, and then ask them when they come out and say they're hopelessly deadlocked. If the instruction says you may come to a unanimous decision on any or all of the separate counts, okay, that sets the framework for it. Then when they come back and say, oh, Judge, we're hopelessly deadlocked, we'll have you come to a unanimous decision on any of the counts. Oh, yeah, we did on 1 and 3. Well, then go back and, memorialize that on the verdict form. Or what do they call it here? I can't remember myself. It's not the verdict slip. It's the verdict slip. The verdict slip.
The slip,
Verdict
right,
slip.
the slip.
Yeah.
Just like demonstrative exhibits are called chalk here. So things that are demonstrative, but they don't get entered into the jury room as evidence are called chalk. And when I first heard that, I was like, we all like looking at each other because we're supposed to know what we're doing. Chalk? What the heck is chalk? Writing on the blackboard like the kids.
Yeah. Not that chalk. No. So again, I hope they fix that. I hope they don't just rely on well, that's the way we do it in Massachusetts. Well, that's a problem.
Yeah, I agree with you. All right. So Pokemon. Oh, look at me. I put the R on because me and Pokemon. Oh my gosh, I did it again. Pokemon says if the ground was rock hard, where was all the blood? It would be frozen on top. Except there was a leaf blower.
Yeah, that's the first question is, well, was there bleeding to the level of drip drip drip? Right. I'm not sure that was ever really verified.
Right. I don't remember.
But if you look at the photos of the arm, you look at it and think, well, those certainly should be bleeding. But we don't know where he was in that process at the time. If he was nearer death or soon thereafter was nearer death, you're going to have less circulation, you're going to have less blood flow, and you're going to have... Is Tubi okay with that? Tubi's okay with that?
Tubi's okay with that.
Tubi's, yes,
Tubi's
that is correct.
For those who don't know, Tubi's the poodle. If you go to my Instagram page, he's all over it. Tubi is my dog. He's very vocal.
So that's what I think. I mean, I'm not sure there's evidence that there was a lot of flow, but I understand the point. Yeah, it would have been easy to see frozen blood on the ground.
Yeah, well, except for that, I've never heard of a leaf blower being used before at a crime scene, but maybe that's just me, and I haven't been out very much. I don't know. DS, if the correct video can't be produced or metadata, can the taillight be excluded because the evidence can't be disputed properly by the defense? I'll take that one. The defense is obviously the defense is trying to do that, to exclude all sorts of things. But what do they really don't want the taillight excluded because the taillight they believe helps them, and that's the problem. Is that oh my God, another one commenting on our comments. That's the problem. Is they think that the Sally Port video shows that the taillight wasn't broken. That somehow it was played with by the police. Do I have that right, Michael?
Yeah, no, I agree, and that's why they're so insistent on getting that metadata because it'll help clear up that confusion. It also could, in theory, help the prosecution, who looks like lying sacks of manure because they put forth this inverted video and never admitted it until on cross-examination. Oh yeah, I guess it is inverted.
Yeah, and I remember that point too. I remember when that happened. I was actually on the air on crime, and I was like, whoa! I mean, here I was saying the day before that Sergeant Buchanan was a great witness, and then all of a sudden, Alan Jackson said, that it was inverted, and we all looked at it, and he said to him, and Sergeant Buchanan, you sat here for 2 days before the jury, and unless I just brought this out to you, you weren't going to tell the jury that video is on the wrong side, were you? And I was like, wow, that was like one of those Matlock moments, right?
Yeah. And when you see the video again and again and again, as we will again and again and again, even though the date stamp and all might be appropriate in terms of the orientation, look at there's a cruiser parked in the foreground, and you can see that the name on the hood of the cruiser, police, is backwards.
Yeah. It's backwards,
Yeah, and it's right there, front and center.
But you don't, somehow your eye didn't go to it because you're just so involved in the testimony. And yes, this is how it is. This is what we saw. This is an exact replica. Is this a careful replica? Duplication. Is this how all those words? So interesting. All right. So next question we're going to go to. Pokemon 0730 says, why is Bev hanging on so hard to this case? Thoughts?
You know, it depends on who you talk to. Some would suggest she's invested in it because she's been here since the beginning. Others would suggest she's, let's just say, so pro-prosecution that she's doing everything she can to try to convict Karen Reed.
Michael, I hear that I have a problem with my mic, okay?
I mean, I'm hearing you okay, but it sounds more like you're on computer.
Yeah, I
mic.
hear I have a problem with my mic. So you know what? Yes, and I see what the problem is. In my
now I hear you.
rush, hold on.
You've dropped your microphone down your
Yes,
cloud.
it dropped down to places that on the air I couldn't really go to. But now I think we're going to have it. Is that better, Missy?
Oh, that is so
is
much better.
Oh my gosh. I am so sorry, everybody.
Would you just repeat everything you said up to this point? So we'll know. No? Okay.
I don't know. I am sorry, but in my rush, I dropped my mic down.
But your hair looks amazing.
But my hair looks good.
So it's all worth it.
Thank you. So bear with me, everyone. And thank you, Missy, for telling me. Okay. Alert One Systems. I love the thought of you two arguing opposing sides of this case in a mock trial. Well, we could do that.
That'd be fun.
Yeah, we'd have a blast. And as a matter of fact, you know what would be a great blast is we take each side again. So we have two mock trials and we argue the opposing sides.
And the thing is, you know, as those who have gone through the law school process know, even if they haven't done mock court or moot court, that's part of the training. You learn, you know, love it or hate it, you've got a side with facts and evidence you've got to argue, and you learn to go both ways. And what it helps you do, of course, is anticipate what the other side is going to do. You know, if I'm on the defense, I need to know what the prosecution is thinking. And so that exercise as part of law school is part of the manipulation of your brain to make you think like a lawyer, for better or worse. Yeah.
And also, you know, you have to know what the other side is thinking because you have to know how to deal with it. Yeah. You know, you have to know how to deal. You have to know how to deal with it. And also, you know, a lot of times we will mock cross-exam our clients, right? If they're out of jail, and to mock cross-exam there, we have to know the other side of the case. So we put them through a cross-examination. I once had a client actually that after I did that, I was, you know, the pretend prosecutor, who absolutely loved me and we're still very good friends. And he was found not guilty, who said, I hated you after that mock cross-examination. For a brief moment, I hated you because I was acting as the prosecutor and I knew what the prosecutor was going to do when and if he got on the stand. So,
yeah, witness prep. It's key, and you got to be in your witness's eyes the bad guy, you know, to properly prep them.
So, Missy, we should put that on the list of things we should do. Maybe when we're waiting for a verdict.
On the list, Missy, you got nothing.
Yeah, Missy, you've got so many. So it's not you don't have enough to do. But other things that we should do when waiting. Maybe we'll do a taped mock examination of us arguing each side of the case or arguing our closing argument for maybe 5-6 minutes. What we would say.
Yeah, you know? That'd be fun.
It'd be fun. And then Michael Bryant will hate me. Okay. No. Actually, I actually had the next question. Sorry about that.
Wait, before we move on, here's how I suggest we set that up. Coin flip. We would do a coin flip to determine who does what side. Okay.
Oh, that's okay. That's good. I like that. Can we play a poker game and who?
No, that would be unfair to me. No.
Wendy, thanks for putting the 3 cues there so we can see them. Question. Falling from being sideswiped, as CW says, does not create enough force to create that injury at back head. Make it make sense, please. Surely it doesn't free Karen and justice for TB and JOK. Can I just say something before you answer that question? Because I'm going to let you answer that question. What I think that what's getting lost in a lot of this, and we've said this, is that justice for John O'Keefe is the truth coming out, right? And he's been kind of forgotten in all this stuff that's going on. Even last night, the viewers or the people that you talked to that we showed that were at lunch at the clerk's office there in the basement mentioned that they want justice for John O'Keefe too. They want what really happened and what, you know, to be brought out. So when we argue or we say that we think Karen Reed is right on some issue, we're not saying that we in any way demean the life of John O'Keefe, and vice versa. When we say that we think the prosecution is right, we're not demeaning in any way Karen Reed's rights. So with that, we're going to let you go.
Yeah, we just want to, we want justice. Justice needs to be served, and if the prosecution can't carry their burden, justice is not served, and Karen Reed should not be convicted. If they do carry their burden, they convince a jury, then she will be convicted. So let me address this question here about the falling and the head injury. First of all, we got to start with one of two possibilities: either John O'Keefe was hit by the car driven by Karen Reed, or he was not. Okay, if he was not. Right. Then you've got to find another way for that head injury: stumbling, intoxicated, falling on the hard ground, something else. Okay, let's assume she did hit him with the vehicle. Now we're into the question about where she might have hit him. If he was, and I've gone through this before, he's apparently holding a glass with what's left of a drink. If he was so inebriated that he's kind of losing his footing, stumbling, and actually is almost bent over at the waist at the time the car backs into him, if that happened, that would account for the car hitting his head. If he's standing upright, it makes no sense that the car, if it did hit him, would hit him in the head. It would seem that injury came as a result of whatever put him on the ground: stumbling, hit by the car, tripping over the curb, whatever. So that's how I think the head injury more likely happened that way than from a direct impact with the car, if that happened at all.
Right. And that's why you and I said perhaps maybe the ground being hard is not bad for the defense, because if he's stumbling and he's drunk and he falls down, or he's trying to get away from a dog, or whatever the theory is that's going to be advanced out there, if he falls and hits his head and on the back, the ground being hard could cause whatever injuries were behind there. Maybe the defense is going down the wrong path. I don't know. But we'll see. They know their case, as I said, better than I know their case, obviously. I just know what you all know. Betty Swallows, question, is it normal for a prosecutor, prosector? I love it because the word prosector was used a couple of times. Maybe in Massachusetts they call them that. Usually it's usually a prosecutor. Normal for the prosecutor not to have a theory of the murder.
Not have a theory of the murder. Well, I think they have a theory. The theory is that Karen Reed backed into John O'Keefe, injuring him to the degree that he fell down in the snow and died from hypothermia. That's their theory.
Right. The theory is and the theory has to be that she hit him because they're relying on that taillight, as opposed to she scared him.
Because exactly. If she didn't hit him, then they have no case. What's the case then? Making him mad? Is that a felony?
Well, I guess you could say. I guess you could say, well, he got scared. He fell backwards because the car was heading back towards him, even though she wasn't going to hit him. And therefore it was reckless, or negligent homicide, negligent manslaughter, or whatever. I mean, I guess they could say that. But then why is the issue of the taillight so important?
We're back. I lost you a second there. I lost you for a second there. But yeah, that backup position, literally the car backing up but not hitting him, has not been thrown out there by the prosecution. It's kind of an alternative they don't want to address, I think, because then that puts them in a position of admitting she may not have hit him, and there falls to the wall that she hit him.
Yeah, that's a good way of saying it. All right.
Yes.
Pokemon 0730. Behind you, Michael, where the crowds are starting to gather, there is a flag. What does the flag say?
Well, I see 1, 2, 3. I see 4 just American flags.
The green one. Is there a green flag right there?
Green flag? There's a sign.
Right. Maybe that's it.
There's a Free Turtle Boy sign. There's a Free Karen Reed sign. There's a lot of T-shirts with Free Karen Reed.
How about above you? How about on the lamppost there? Is that a sign?
Yeah. That's from the town. Kind of I can't read it myself, but it's sort of a town of Dedham. I see one across the road. Yeah, it says town of Dedham, and then it has a picture of the dome to the courthouse, which is right behind it. It's just it's a little wrapped up in that pole, but that is not Free Karen Reed propaganda. That is just the town of Dedham's celebration flag.
Okay, and the signs that you see there with the people that are starting to gather with various signs.
Yes.
It's hard for me to see. It's interesting when you were parked where we could see the dome. The courthouse looks so much bigger here right in front of it than it does when you like move back just a little bit.
Yeah,
And you see the
yeah.
dome
I mean,
and the
I'm ready to press.
courthouse.
I'll tip up here just so you can see. There's the dome. There it is.
There it is. There it is. Yeah, you
And
can't miss it.
there is one sign that I can see that says the whole world is watching.
And we are. The whole world is watching. We're
We know
absolutely
folks
watching.
watching us from Poland and Australia and the UK.
Right.
So,
Right.
yeah.
Canada. People that used to be our friends. But I won't go there. Okay. Just a little morning humor. D, how can the court allow witness intimidation charges that were dismissed against Karen Reed and pending against Aiden when prior convictions aren't normally allowed? Aiden, you're talking about Aiden Kenney, who's got a hearing on today to dismiss his case. He was arrested. He is known as Dr. Turtle Boy, I believe, on his Twitter. We have asked him to come on the show, and there has been contact with Missy and him trying to arrange.
He's been a little busy prepping for his, today at 2:00. And I see Mary Murphy. I think it was Mary Murphy. Somebody asked when it went zooming by when he goes to court. It is 2:00 today, and there's he may be in the big courtroom. We're not sure. Those are decisions made at the administrative level here, so it might be possible to sneak in there. We're going to kind of play it by ear and see what happens.
Yeah, that'd be great. And if we could find out and cover that, and if the Karen Reed hearing is finished, to see what happens with his hearing too, because he actually gets a seat given by the Karen Reed people, I believe, in the courtroom, right?
Right. He does. Right. Yeah, he's part of that in the baby courtroom, the Zacco and Vincetti courtroom. They get 10 per side, and so he is one of the 10 from the Karen Reed side. The prosecution side, it's mostly government types. It's not like people. I talked to the Karen Reed supporters yesterday, and if you haven't seen that video, it's on our channel here.
It's a great video. Please watch it if you haven't seen it. It's about 14 minutes long. It's absolutely fabulous.
There ain't many wandering around with flags saying, go Hank Brennan. So that's not a lot of support. So their 10 people are, government folks, other attorneys, law enforcement, that kind of thing.
And Mark Betterow, who is Dr. Turtleboy's attorney, who's from New York, has been moved pro hoc vice into this case. Attempted to be moved. I think the court initially denied it because he had to file more paperwork, if I recall. I don't know where that stands, if that ever came to pass.
Yeah, there was that the court had said we need more, and I think almost immediately Alan Jackson filed a supplemental affidavit to support Betterow's being admitted pro hac vice, and again, there's not been a pronouncement of it. I guess if we see Betterow show up and sit at the table today, we'll know.
No,
but at this point, it's a little unclear.
Okay. All right. Let me continue on here. You see, everyone has been thinking about their questions. It's so great. Blessed Mom in Texas. Why wouldn't any of the Alberts come out of their home? No law enforcement going to search it. So much wrong with this case.
But what do you think about that? We talked about it, and as we listened to each witness last time, so many folks at 34 Fairview, and again, as I've mentioned, it's just like a normal neighborhood home. It's not a massive sprawling property. You've seen the pictures. I've been there. It's just what you would expect in driving through a normal, neighborhood and adjacent to a big city. So if you're walking from the front porch to the curb, I don't know how you don't see a lump the size of a human being on the lawn, not more than 15, 20 feet from you. And only one witness mentioned seeing some sort of dark shape on the lawn. And again, remember, it wasn't like 6 inches of snow had fallen at that point. At the time these people were leaving the home, again, assuming their testimony is legit, there might have been an inch or two, maybe at the most. It is. It seems bizarre that nobody saw John O'Keefe's body.
Yeah. And including the snowplower guy who came by in the morning and said it was clear, just starting out, said there was no body there. Now we also know that eyewitness identification sometimes can be unreliable, but that it's a pretty big. When there's a big case, you kind of remember if you see a body on the snow. I would think you would notice that, but. That's something that the prosecution has to get over because they never interviewed. My recollection is they never went out and interviewed the snow plowing people. The defense had to do it and to find out that indeed. And then he went traveling, I think, with one of the defense to look to show the route that he went. and said there was simply no body, where the state says there should have been a body if he had fallen at that time that Karen Reed hit.
Hey, let me clarify the family situation from the John O'Keefe side. And the Canton Chronicles, I think, just went by, pointed out that yes, there are obviously John O'Keefe's family members are there as part of that contingent. It's just it's not as overwhelming. I'll leave it at that.
Okay. All right, but it's tough. It's a small courtroom. Then we'll do a sack on Vanzetti's at some point when we have some time to talk about what happened in that courtroom, because it's of historical importance. And this is every case is important, not just the historical ones. Every case is important. All right, Just Me Gaming. How is a screenshot of a text message admissible in court when it's clearly not the original text and the source and the authentication cannot be proven?
Well, it says can be proven, and I think that's
can be proven. I'm sorry.
Either there's going to be an agreement between the parties that, look, this is legit, we're going to use it, and it makes things so much quicker and easier to do that rather than bring in people for foundational purposes. Depends on the nature of the text, who wrote it, who received it. You can go through that process of bringing these people in to establish the foundation and therefore admissibility. But do you really have to? Is this going to be something you're going to, a hill you're going to die on? Sometimes, luckily, efficiency and reasonableness will win the day, and the attorneys and the court will get together and say, look, we're not going to fight about that one item. We're going to agree it's admissible. Let's just get it in and move on.
Yeah. So we'll see what happens there. Okay, from Wendy, question. But wouldn't he hit his arm on the taillight if he hit his head, or what you think? In other words, she's saying that if the impact happened, wouldn't his arm be hit, like you almost like a defensive wound that you're trying to push the car away? I guess that's Wendy's theory. Interesting theory.
Yeah, I mean, the fact that is a question really makes the point that is the prosecution proving its case. We don't know what happened. We don't know if his arm was hit and then somehow his head was hit, or vice versa, or if neither was hit. That's the prosecution's biggest hurdle, proving the nature of any injuries and the fact that Karen Reed caused them. That's the case.
Yeah. Let me just blessed mom from Texas, member for 1 month. Thank you so much. Love this show. Free Karen Reed and Aiden. Thank you so much for watching, Blessed Mom. And we see that you're involved in the chat. We love that you're involved in the chat. And we want you to keep it coming. Tell all your friends. As you see, we try to answer, Michael and I try to answer what we think as is normal. We call it as we see it. And we're not inside any of these cases, but we're watching just like you. But as attorneys, we call it when we see it. When somebody has a problem or somebody doesn't have a problem, we'll say it. And we've talked about the problems we think Karen Reed case has. We talked about the problems we think the prosecution has. So we try to be fair and then answer your questions. And all of your questions, no matter what side they're coming from, are all very, very, very good. But that's an interesting theory, again, that I'm not sure the prosecution has gone there. But that's why I guess the issue of what caused those scratches or those marks on John O'Keefe's arm, are they dog bites or are they dog scratches, become important.
Yep.
All right.
Sorry, I'm not trying to be rude here, just trying to look around and see what
see what's happening.
May or might not be happening. So maybe in about 10 minutes or so, unless I see something sooner, I'll just bail out on you and wander over and see if I can get some comments from the participants as they head to the court.
Yeah, absolutely. Michael, we'll be taking a peek into Aiden's hearing in the big courtroom today. It is in the big courtroom. Aiden, I think, had published a schedule as to what the courtroom things were in, and it was in the big courtroom. So you're going to try to do that unless,
Definitely.
Yeah.
Yep. I'll find out more during lunch about accessibility, because see these folks out here, and they're usually more, and there probably will be. They all want to go in there too, so we'll see how that shakes out.
Yep. Yeah. Lisa Small, Linda, what does your husband think about this case? Hi from Idaho. Just found you too. Love you too. Thank you very much. I haven't talked to him about it. I tell a funny story about the Birchmore case that we were in the small cabin up in the Catskills, and I'm downstairs in my office, where my office and studios, and he was upstairs in his office, and like his phone starts ringing, and then I asked what it's all about. He said, "Oh, there's this case in Massachusetts, and the reporters are calling. Blah blah blah." And then I guess the attorneys and him had an interview with the newspaper, and I read about Birchmore on the internet. Okay, that's what happens when you have a husband who who's very secretive about his work. So when I get a chance, I'll ask him and see what he thinks. But he's so busy on his own stuff, I'm sure. But yes, thank you. And I know he's been on TV a lot on Gene Hackman's death. What could have caused that? Because I see him. I see him pop up on my Twitter feed. Okay. So I haven't had a chance. So hopefully I'll get a chance in the future to talk to him about it. All right. D, the prosecution and its witnesses are the ones constantly bringing up the intimidation, but Bev won't allow the information garnered in the intimidation investigation. How is that allowed? In other words, how is that not coming in? Michael?
Oh,
do you
yeah.
know?
Do you have any thoughts on that? I mean, go ahead.
I guess she's trying to keep this like clean and not go on side, what she considers side issues is all I can see.
She has to make the old 352 in California anyway. The 352 analysis, I think it's 403 or 404 under the federal rules in most states.
Right.
Is it probative? Could be. It could go to bias, but is it more prejudicial than probative? I think it's a matter of degree. And so if the court decides that it's less helpful than harmful, it's not going to come in. I don't know enough about the details of this alleged intimidation, so I couldn't rule on it without knowing more. But I think that's the decision the court is making, is that if it is helpful at all, it is overwhelmingly prejudicial.
All right. So let's do 2 more questions, and let me let you go interview some people behind the courthouse because it is 10:40 already. Question: the defense filed a motion last case for Cannone to recuse herself. Could the defense file it again, or is it just one and done? Or yes, because it's a new trial? I can answer that. They can file the motion to recuse her at any time they want or for any reason if they have good reason to recuse her. I think once you've done that, it hasn't been done. They're not going to file it again because the one thing you have to do is if you want to get a judge off the case, you really got to get, your motion has to be successful or else, judges are human and you never know who the judge is going to be replaced by. Judge Kenney has a very good reputation, right?
And they could technically, they got options. They could bring a motion for reconsideration, which we do know has worked, as it did in the case of the reporter's notes. Right, she got to keep them through a motion for reconsideration, or they could take it up on an interlocutory appeal or a writ. While the case proceeds. They decided not to do either.
Right. And they decide obviously not to make a new motion unless there's something egregious that occurs. I think they won't do that here either at this point.
Yeah.
And then we have one final question. Do you think the defense will rely more on the science proving innocence or lean heavy on the frame, I guess the time frame? What are your thoughts here, Michael?
I think they're going to do exactly what they did the first time, and that is plant the seeds. Remember, they don't have to prove a damn thing. Plant the seeds that there's a reason the prosecution is having trouble proving their case. It's because all of these other players were involved in something. You don't have to prove a conspiracy. You just have to create the doubt in the minds of the jurors by giving them questions that make them wonder, what did happen? Who did that? Who was at the house? Who left the house? What happened at the house? Did John O'Keefe go in the house? Every question they're asking creates reasonable doubt and should defeat the prosecution's case. And I think the defense is going to stick with that. Kind of worked.
Yep, kind of worked. I'm going to let you go. I'm going to continue to answer questions because we want you to get in front of that courthaus trying to get some interviews, especially if the defense team
Okay, see you later.
Shows up. Talk to you later. All right, so I had to let Michael go. He's been out there, obviously, well before because while I was getting my hair blown out, Michael was already at the courthouse early this morning, and Misty was already streaming. And as you know, he was up late last night getting interviews. And even when we finished our show last night, a couple of people came over and talked to him about the case. So there's nothing more important when you're covering a case than trying to be on the ground when you can. In many cases, we can't, because we can't go back and forth, for instance, to California on the ASAP Rocky case. But we worked our sources there, and as you know, we had the breaking information that no one else had on that because of our buildup of our sources over the years. But so let me go on. Let me answer this. This is from Watcher of Trials. I'm pro Karen Reed. What do you think about AJ Alan Jackson supposedly lying to the court in sidebar about not paying for ARCA? I don't think I think that in the scheme of things, what they were asking when you look at that conversation was, did he hire and retain them? not that he pay a bill afterwards. And that's what they're trying to make clear. And it was about all the information, the way the conversation went. They have everything I have. They have everything I have because it was everything from the federal government. And that was true because it was the federal government who actually hired ARCA. They came to their opinions under being paid by the federal government and all. So whether or not, if indeed, and I thought about this with regard to attorney-client privilege, right? If you're trying to hire somebody, and if you've actually hired them, then even what your conversations, you would say, you can't disclose that. You give a log and say that's attorney-client privilege. It's not disclosable. But there was no reason to do that because he had never retained them and all. And I do believe that he got that bill out of the blue from the ARCA people who said, hey, wait a second. Our contract with the federal government's ending. They're not paying for us. We spent all this time. This is a big corporation. They want the people, if they're going to spend time, to bring the money in, right? We don't know what the total bill was, but I think in that conversation, what he was saying, they have everything I have, meaning they have everything from the federal government I have. And then when the new trial comes, and this stuff is now clearly disclosable on the new trial because they didn't have the bill, they didn't have the money beforehand, then the defense disclosed it. And what happened is the prosecution told the judge that defense they had gotten from the federal government, leading to the inference that Jackson had not disclosed it then. And that's when everything blew up because he had. And so that's where we are. So I think when I looked at that conversation, it was clearly they were talking about them having everything I have from the federal government on what the federal government had given us, because everyone was waiting. Remember, we have a timeline. Maybe we'll pull it up at lunchtime and go through the timeline again on that ARCA. We do have that timeline on that ARCA thing. So, that's where I think that we are. So some of you are joining now. Do you want, what do you feel about me going through what happened yesterday as I take a sip of my coffee this morning? What do you feel about me going through what happened yesterday to catch you all up and what's going to happen today, right? Put your comments in here. Let me say, come on, let me know. All right. The court feed is not live yet. No. So I don't know who's tweeting from live inside a federal courthouse, but somebody's going to find that out, and that person's going to be in trouble, because the one thing you cannot do inside a federal courthouse, unless they have set up in the front of it just before you enter, before security, and sometimes they'll do that. They'll set up a location just in the front of the courthouse inside that you can, media can do their thing, but it's before security, or they can set up a location outside. But if you're inside and you're past that security and you're running a TV show, you may be in big, big trouble, as they say. All right. As a matter of fact, it was really interesting when I saw the pictures going back to ASAP Rocky, of the ASAP Rocky team in the courtroom, and the judge is there right behind them, kind of smiling, because there's all these rules in courthouses that you can't take photographs from even on your cell phone, especially on your cell phone, inside a courthouse, right? There's all these absolute rules on it. And I said, well, they're not getting in trouble there. Why? Because the judge probably made an exception to the rules. Since he was in the picture, he probably said, sure, I'll let you do it. So let me go through my notes from yesterday, because there were 6 things that the judge wanted to get through. And when she started out, and I am looking for where they start. We had so much yesterday going on, as you know. And the first thing was the judge actually, here it is, the judge first having everyone mention their appearances, and she wanted to make sure they're on the record, and that was Mr. Alessi, Mr. Jackson, Mr. Yanetti, and Ms. Little, all right? And she wanted to deal with 6 things. Are the ARCA issue, Dr. Crosby's opinion, the motion to exclude Robert Gilman's opinion, the Commonwealth's motions for sanction against the defense against Mr. Yanetti is basically, and the motion to amend the scheduling order, and the new videos that had been turned over, and the motion for reconsideration regarding the data, the metadata that we're now all familiar with. I can kind of tell you the original when a picture has been taken. All right. So the first thing that we started was, and I had said that she came, the judge yesterday was, and I had put in my notes, the judge is pissed because she came with, it was clearly a warning in her attitude towards the defense. And she told the defense that everything that one of them says has to be attributed to the other, right? So that if Mr. Alessi makes a representation, all of you are adopting that representation, and it's attributing to your veracity. And she wanted to make sure the defense understood that, right? So what happened? That she said, do you understand that? And by each one of them, they had to answer that they understood that, right? Each one of them had to answer that. So that told me that she believes that that perhaps maybe there were some representations made by Alessi that weren't true, some representations made by Yanetti or Jackson, whatever it was. She wouldn't say what it was, but she wanted to make sure going forward, everybody understood that, right? Every person understood that, right? And so that told me that she was sending a message to them to be careful what you represent to this court. And then she started with the emails, what we just finished discussing. And that was the emails from AJ to Dr. Wolf. That was in July after the trial ended, and about that he would get the retainer agreement out to them, which tells me if he's getting a retainer agreement out to them, they had not been retained prior, because you're not getting a retainer agreement out to an expert to retain them from your case until afterwards, right? And then 2 days later, there's an email from to Alan Jackson that there's a pause letter because the federal government has said you can't do anything right now because we're still in the case. So put that on pause, any retention privately by Alan Jackson for the second trial. And that's what we're talking about, retention for the second trial. And there's no issue of the bill right now. But then we went right from there. We jumped from there to the bill, which actually was submitted after the trial, right? And Jackson had told the court, Alan Jackson represented the court, that they called the U.S. attorney, the first assistant U.S. attorney involved, and said, can we pay this? And he said, yes, you can pay this, because the federal contract was ending, and told them they could pay this. And then 2 days later, that bill was paid. And so then Mr. Alessi said words to the effect, and you can infer, Your Honor, that there were no communications between Alan Jackson and, since he was handling the ARCA people, and the ARCA people, the ARCA experts, between that time and the time of when they were officially came to trial, right? When they were coming to trial. And here's where the conversation got interesting, because the judge said, Mr. Alessi, are you inferring that Mr. Jackson had no communications with ARCA, or are you representing to this court that he had no communications with ARCA? Do you know that? And Mr. Alessi said, and he's a very good lawyer, he said, I'm inferring that, Your Honor. So Michael Bryant and I have discussed this, and we said, we think the judge wants more. We think that she wants an affidavit or something from Alan Jackson to say he had no discussions. That's what she seems to want. That's what she seems to be missing. So we kind of left it at that. And as I said, when the judge was talking to this, she sounded, for lack of a better legal term, annoyed. Pissed is what I wrote on my legal pad here, my little book, because what she's trying to indicate is she wants to make sure that there's no misrepresentations with regard to that for her, since now, obviously, when we go to trial, all this is going to be free game about whether or not there was a retainer agreement sent, whether there was a pause, and then later there was a payment, there was an invoice and a billing, as to the bias of the ARC experts, who I think clearly, though, were hired by the federal government. Clearly, they had hired and issued by the federal government and issued their opinion. So that's where that left, and nothing actually happened on that at that point. Then we got to motions in limine. And before I answer that, I see we do have another question here from one of our viewers, from Katie. Why is the prosecution not focusing on justice, using Karen as a scapegoat instead of looking within the police government? Seems to show where their priorities are. It's interesting you say that, because obviously there had been an investigation into the Canton Police Department, which the Canton Police Department, which Hank Brennan said yesterday, is now over, right? He said that it's gone. It's simply, you know, it's over. And then the Canton Police Department issued some statements saying that there's no further investigation into them. So I guess that's where we are. That if the federal government said that there's nothing untoward in Canton relating to the death of John O'Keefe, where's the defense going here? Although I'm not quite sure that that whole statement said exactly what everyone wants to infer, because you don't know whether there's other investigations going on. We have no idea that may surround, but not necessarily be related to Karen Reed. So with that question being answered, let's go to the motions that continued yesterday. It was Mr. Alessi then, and he tried to have Dr. Crosby, who the prosecution wants to call nixed from the case, that they don't even need what is called a Daubert Lanigan hearing to see whether his methodology or his opinions are scientifically sound, that on the face of what he has submitted already, the court should, based on their ability to keep evidence away from the jury that is misleading, shall I say, or not probative, the court could rule on the papers and find Dr. Crosby's not qualified. Now, who is Dr. Crosby? He's a biomechanical engineer, right? Biomechanical engineer. Now, there's this whole area now of how injuries are caused, that biomechanical people were weighing in on it and all. It's kind of an interesting area because it really had to do with force in cars and how much force you need, you know, when you have your seatbelt, you know, you don't have your seatbelt on or your airbag hits, and they have now morphed over into a lot of different areas. And what Alessi said is that he is not a forensic scientist, right? And therefore he should be excluded because he cannot, he's not a doctor. He's not a forensic scientist doctor. He's not a medical doctor. How can he opine on the cause, the manner, and the mechanism of death when he is not a medical doctor? And so Alessi said, therefore, the court should limit him. I'm shorthanding this because obviously this went a lot longer but I'm shorthanding it. And so that's what the defense wants to exclude Dr. Cosby with regard to that. He said that, you know, there's no treatment here, right? There's no treatment. So he shouldn't be able to testify with regard to that. You also had the issue of Cosby talking about the dog bites, right? That he's not a forensic odontologist either. And so how can he talk about dog bites? And a forensic odontology is a fancy word for a dentist, right? They're a board certified dentist. They deal with forensic dentistry. There's been a lot of controversy in the scientific community about whether they're accurate or not, because a lot of times they've testified in the past that a bite mark on a person matches a specific person. And now the feeling is in the industry that you can't do that. You can't match a bite mark to a specific person, and that bite mark matching in itself is bad science. And so many cases have had convictions overturned based on it. And why is that? Well, you know, if you're just dealing with a person, I'm not talking yet the dog, if you're dealing with a person, and I don't have a short sleeve shirt on, but you know, your skin moves, your skin's pliable. And then also as you die and your skin may dry out, the pattern changes, right? It can change by a millimeter, but that can make a difference in terms of a bite mark on somebody. And so this pattern matching is what we call very soft science, because it relies on a pattern and relies on somebody else coming in and saying, I'm an expert, and it's my opinion that that's a match. And here apparently there was a mold created of Chloe, the dog, that the defense had not seen. And what Alessi said, even if you're assuming that you're going to get him to that point, he never overlaid the mold on any of the wounds. When he took the mold, he didn't have any pictures. He didn't have the defense there. He simply didn't do what you need to do to make it a valid scientific methodology to begin with, right? And he said that even, and unless he did point out that even forensic odontologists, if they use that mold on mold, have been proven to show that that's not really a valid science, because the skin is so pliable, because you're just not getting, it's not like DNA, right? All the stuff is that when you have these, what we call comparative sciences, they're not DNA. You know, you're not going to your doctor's office, they take blood, they get a hard scientific proof of what your blood is in your blood, and then they have scales they can measure whether it's normal, abnormal, or not. That none of this is that. It's all relying on somebody saying, well, you know, I looked at this and this is what I see. And it can be very, very important in front of a jury, because they say, well, here's a scientist, right? Here's somebody who's saying that they're reasonably certain within the scientific community or the medical community. And it has an effect on a jury that it shouldn't have, because it's not really good science. So there was a lot mentioned on that. Alessi actually read this man's thesis. He read Alessi read basically everything with regard to him and all. So, you know, there we are with regard to that. And then there was another expert. There was the geologist. By the way, there's two Dr. Wolfs in this case. There was the geologist that the prosecution wants to put in to say the ground. He's actually not a geologist, he's a meteorologist, but they want him to testify as a geology to talk about the ground. And Alessi pointed out that I spoke to a geologist. I spoke to the head of the National Academies of Sciences. A meteorologist is not a geologist, and he should not be able to testify as to geology type things, like how hard the ground is, how ground becomes hard. That he could testify as to the weather, just like Bob Dylan, which way the wind blows. We could probably all testify as to the weather. We just look outside and see what the weather is, right? But he can't testify the ground is rock hard, solid. And they kind of agreed upon that. Michael and I just discussed that, and when he was on the air, they kind of agreed on that you were going to stop that. And by the way, his name is Dr. Gilman. So that happened yesterday. And it was almost kind of after all the other arguments, kind of both sides had kind of lost steam here, right on that. So whether or not when the snow came in is important in this case, I don't know. I think what is important is that a snowblower was used to blow snow away, eliminating any evidence that may have been in that snow. I mean, that seemed to me to be a lot more important than when snow came in. We know snow came in, right? All right. And then the third thing after was Dr. Crosby on the dog bite and Robert Gilman, the meteorologist. It was the Commonwealth's motions for sanctions, and that was based on three things, and that Mr. Yanetti argued. It turns out there was a protective order that you couldn't identify certain things. I don't know what the first thing was, but apparently it was violated. It was quickly remedied, but it was violated. The second was apparently an email that was attached to a motion an email was by Robert Proctor, apparently, and it talked about his feelings about Alan Jackson, and that was subject to the protective order, and it shouldn't have been disclosed. Now, on the first one, Mr. Yanetti said, look, Your Honor, I went back. I didn't even think this was under the protective order, because I was trying to be careful. Look, I even put the teenagers' kids' initials in as initials, not as names. So I was very sensitive. And I'm sorry, he kind of fell on his sword. The second one with Alan Jackson, he said, yes, that was subject to protective order. But quite frankly, I'm thinking here, hey, he should have said, we all know, and I think he did say how Alan Jackson is viewed by Proctor. I'm sure Mr. Proctor, I could probably write the email, probably didn't have nice things to say about Alan Jackson. So even though that was a violation, so what? The third thing is when they went to sidebar for a very long time, because apparently there was some part of a grand jury transcript attached. We went back to try to find it. We couldn't find it. Maybe you all can. And that was subject to a protective order because unless you have a court's permission to release a grand jury transcript, everything a grand jury does is secret. Sometimes it is released in different states. Us attorneys get them when we ask for them in certain states, not the deliberation. For instance, in New Jersey, when somebody's been indicted as part of discovery, if I ask for the grand jury transcript because I want to impeach somebody based on testimony they presented before the grand jury, I'll be able to get that grand jury transcript. But here there was a protective order, so we don't exactly know what it was that shouldn't have been released, except that they were at sidebar for a very long period of time. And when Mr. Yanetti came back to his seat, nothing was done. I mean, we had no rulings on anything yesterday. And we've had no rulings even on last week's motion regarding Alan Jackson and the defense team about whether they violated Rule 14 discovery or whether there was an ethics violation. So we've had no rulings on that. The next thing they addressed yesterday, and this is, again, I'm shorthanding what happened, was the amendment to the scheduling order. And this turned out to be moot because the defense wanted the scheduling order be moved so that the motion to dismiss, which is going to be heard right today, instead be moved to the future. And there was kind of a funny thing in court because the court said, we're not moving this to March 17th. Now, March 17th, in case you all don't know, is St. Patrick's Day. Here in New York City, it's a big day. Everyone works, but there's a big parade going on, and you can imagine a lot of drinking, all right? And when I was in the Hernandez trial, we were actually in Suffolk County. This is Norwalk County here we're in now, in the Karen Reed, but Suffolk County. And in Suffolk County, it's one of the 2 counties in the United States that actually has made it a holiday, a complete holiday. People don't work in Suffolk County on St. Patrick's Day because it's a holiday. But even though it's not a holiday in Norwalk County, I'm sure that it's being treated as such. I'm sure that the Waterfall Bar and Clark's are going to be pretty busy on that day. So there was kind of a chuckle about that. And then there was a question about whether it would be put on for this Friday. And Alan Jackson said initially that he wanted it moved, especially since there had just been discovery, 400 pages of discovery that was given the night before by the prosecution with 4 new reports and a number of new videos, download videos from the Sally Port, which apparently the prosecution represented were the same videos they already have, just different copies coming from the detective drive and all. So Alan Jackson initially wanted more time, said, look, no, I'll tell you what, I'll argue today since I'm here. He was saying, I'll argue tomorrow since I'm here. And if I need to, Your Honor, if I can submit a supplemental brief on that after I review discovery, that would be fine. And the judge agreed to that. So that's why we back into court today to take up whatever leftovers there are and to argue the motion to dismiss the Karen Reed case, or as Alan Reed said, fully throated motion to dismiss. I think I can tell you, I don't think the court's going to dismiss it, but it's a motion that's there, especially for the record. And then finally came the issue of the video cameras yesterday. That was the 6th thing that they addressed. Actually, the hearing became a little bit more, as I said, more of a détente. People seem to be not fighting as much and all when they got to this. And that had to do with the fact that Ms. Little got 9 video downloads and 15 videos of the videos, 9 video downloads of the video of 15 videos being downloaded. Does that make sense to you? In other words, they were taking videos of downloading videos from this new detective drive, apparently. And it came to pass that we learned that there was a supposed backup by a detective who has since retired, who kept it on what they called the detective drive, which no one ever heard of before, right? Until this happened. But the prosecution's representative, nothing more than the videos that the defense has already seen. And so there was a motion for reconsideration to get the metadata based on that. Apparently that metadata may not exist because the way they copied them may have been, from what we're reading on the affidavits, by dragging and dropping instead of actually copying them in a forensically sound way. And when you drag and drop something, you lose any metadata you have. So we'll see. The judge was very respectful to Ms. Little. I think she thinks that she's doing the best she can on discovery. and said to her, well, if you need Friday to argue, because she thought maybe she'd need Friday to argue, we can do it on Friday. But I don't think that was clear at the end. It kind of got kind of a mishmash whether she needed it or whether she would just look at it and see whether she would need to file something supplemental or just rely on the brief that they already had. So that was a shorthand of what happened. Then there was a discussion of scheduling for today, besides the motion to dismiss, because the prosecution had to be in a federal court this morning at 9 o'clock. And she said, then we should start at 11. Obviously, we had the feed up. It's how we're watching it. It hasn't started. And she asked them also if indeed they could, if they finished early, could they get there early? And they were in a federal court on the motion for double jeopardy. Excuse me while I take a sip of my coffee as you're all doing this and all asking questions, because I'm going to go to some of your questions again. Okay, let me see. All right. Blessed Mom for Texas. Again, thank you for joining us. Thank you for becoming a member. And by the way, I have to say this, could you all hit that like button if you're watching? Every single one of you, like on 1, 2, 3, hit that like button, because that gets us into the algorithm. And although Afton, who's not on yet last night, had a little funny, he said the dislike button also gets you into it. But please don't hit the dislike. Hit that like button and subscribe. It's free. And what do you get in life these days that are free? And share, please. So hit that like button, subscribe, share, and also notify, because when you see that notify, you have to hit notify and all, because or else it defaults back to whatever you had, which is not notify all. So you may miss us if we come on live because there's some breaking news and you don't know about it. But hit that like button right now. Please, 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 pretty please. Okay, Blessed Mom from Texas. I still don't understand if defense pays Crash Daddies is go around. I love it, Crash Daddies. Why can't they say who they are? Because last jury thought it was Karen Reed Insurance, especially. Yeah, it was really funny last time. But they did say that they were independent and they were hired by the federal government. I don't think there's a problem with saying, look, after you testified, you billed us for your time. They're in the business to make money. They were not hired by the federal government to testify. They were hired by the federal government to give a conclusion and a report as to whether Karen Reed's SUV had hit John O'Keefe. And their conclusion was that it had not hit Karen Reed's SUV. I have a lot going on outside my office today. I hope you can hear that. If you please excuse it, that it was not. And they came to that conclusion for the federal government. And 2 of the witnesses testified there. So if Alan Jackson has to call him back, he's going to have to say, yes, they're independent, but we paid for your time. And then, of course, well, here's what the prosecution's going to do. The prosecution's going to do. But you knew that if you testified in this case, you would be paid, and you knew that you'd be coming back, and if you had a different opinion, you wouldn't be changing it because you're going to get money, and it's going to be the same stuff we always hear about experts. Oh, you're paid hired guns. It's such garbage, quite frankly. I think that if you do that, sometimes we found in mock juries that actually gets jurors mad. They want to hear all the evidence and decide for themselves who is telling the story or which evidence they wish to accept. So why can't they say who they are? Last time, I think they will say who. I mean, they're going to say who they are, because you're going to get into this invoicing this time. So it's going to become very, very clear. Absolutely, very, very clear. And so Katie has a question. All right, Katie. Question. Sorry for all these questions. Don't be sorry for any questions. These are all important. Don't you think that jurors, when they get into cases, have questions all the time? But how do you think they will divide up who will question who this time with all the alleged new attorneys? Interesting. I don't think Alessi could be doing some of the forensic work, because you saw that he did the forensic on the dog bite. So he could be doing some of the forensic work, the dog bite experts here. And, when I get into a case now, I try to limit what I do to the forensic work, because cases are just too big anymore to do everything. So, yeah, Alessi could be doing some of the forensic work. I don't know. Miss Little did some witnesses last time. They were small witnesses. Obviously, Alan Jackson's going to do the ones that are most important, and then Yanetti, the second most important, it seems to me. And then you have Alessi, who may do some of the forensic witnesses. I don't know which forensic witnesses, except that he seems to definitely be into the dog bite one. And remember, he was hired, it said, because his firm was the one who had the largest case in the country about dog bite experts. All right. And you can see that, but in front of a jury, I know he's going to be very good, but in front of a jury, sometimes people that argue, like in appellate work, are not necessarily great in front of a jury. That's why they become appellate attorneys. So I think that he's got, shall we say, this dog bite evidence, and he knows it. He's got his mouth around it, so to speak. He kind of knows what it is. So I think that he will be doing more of that with regard to the dog bites, and maybe with regard to the geologists also, because he's handling the motions, these motions right now. By the way, there are going to be next Monday. They will have motions in limine. They have to all be filed by Friday, I think the judge ruled, and then she's going to take them on Monday. And the motion is limine is a motion to keep things in and out of court. And depending on who argues those, which I have a feeling is going to be Alessi also, since he seems to be more of the appellate type lawyer here, we'll get to see what becomes important for the prosecution and the defense in terms of what they want to keep in and what they want to keep out. All right. Blessed Mom from Texas also. Why isn't defense going after prosecutor for Brady violation, inverted videos? I think they have. They've gone after it, and the court said no, because it's the same thing. Last week, Neil Rockheim was on our show when Michael couldn't be here as a special guest, and he said, this is what always happens in a trial. The prosecution always hands things over late. We saw it in ASAP Rocky, the day of the trial, 25-page report done a year ago, that's handed over. And the judge always says, well, you know what? You'll have time to deal with it. You don't have to deal with it today. Pat on the back. You're such a good attorney, Miss Kenney Baden. I know that you'll be able to deal with it, even though it's a shortened time period. And the judges don't find Brady violations. That's why all of us in the defense bar were so amazed in the Alec Baldwin case when the judge said, wait a second, you hid evidence intentionally under another number with a different case name, so it wouldn't be attributed to this case. That is the epitome of a Brady violation. And for that, the case is going to be dismissed, because our justice system has to run on fairness and due process, and that is simply wrong. So, but on giving like these, we didn't hear anything about a detective drive in the first trial, right? None of you heard anything about that. We didn't know anything about that. We didn't know anything about the retired sergeant with this detective drive. And yet the judge is going to allow it in because, well, you have time to deal with it. Your trial is April 1st, and you have time to deal with it, and you have the basic evidence, and you have most of the case. And that's what they do. So it's something that's really unfair, and it's not getting a remedy. But when the defense seems to have it, it's like a double standard. Oh my God, the defense didn't turn over a page, or the defense didn't turn over an email. And that's what us from the defense bar, and I've been a prosecutor. I turned everything over. I never had any allegations. I never turned anything over, because I turned everything over. I said, here's the conference room. Here's my file. Go through it. Knock yourself out. That way you have everything I have. But so it becomes this terrible thing that you have grave concerns when a defense does something. But when the prosecution does it, well, they're representing the state, and therefore it's okay. So I'm with you, Blessed Mom, but they've been trying on this. Oasis Cat, let me just say, anyone else have a burger craving, says Michael, and they showed their burgers last night? I don't know. In fairness, Tubi actually had most of the burger, because mine wasn't a veggie burger last night. But boy, I know, I was sitting here with that thing in front of me, and I'm looking at the French fries and saying to myself, I wonder if they were cooked in beef tallow. I wonder if they were actually fried in beef, or whether I could eat them and all. So I had to tell you, I did cheat. I did have some French fries, but Tubi actually got most of the burger, and I think he's going to get some more of it today as a treat. Yeah, I know. Isn't it amazing how ads work? We're not sponsored by anybody, so we don't have any ads, but yeah, it was kind of amazing how that is. And you can get something and try to feel like you need it. Okay, so yeah. All right, let's see. Blessed Mom from Texas. Does anyone feel like the defense kind of put their tail between their legs yesterday, like they're scared a bit? I hate that for them. All right, so I think I actually touched upon this. Interesting, Blessed Mom, because I had kind of the same feeling that not so much maybe the tail between the legs, but I thought that Hank Brennan, in all that he's done, whether you like him or not, remember, he's got a client to represent, that's the Commonwealth. He has kind of leveled that playing field in there, right? The defense was kind of took over everything that Lally did, but Hank Brennan, and I think he did it wrongly. Okay, I don't like the fact that he represented to the court that he got the retainer agreement, and he got not only retainer agreement and the invoice emails from the government. He did not. He got them from the defense in discovery this time over. All right. Sorry, that's my office, and I can't turn off the lines. I apologize. So he got them this time over, but because it was Judge Bev who said grave concerns and made you go through that hearing that day, which I think again was unfairly inured to the non-benefit or improperly to the client, because now everyone thinks like you do. Well, maybe the defense did something wrong. They kind of had their tail between the legs. I think it's totally wrong. And I think it was wrong. It was wrong to do it. It was wrong for Judge Bev to do it in open court. My feeling is, and I think she may, I don't think she regrets it, because yesterday she came at the defense, right? She came at them. That's why she had them all stand up to say they understood that a representation of one is a representation of the other. So yeah, it felt a little bit like detente, but it also felt a little bit like Mr. Brennan had achieved what he wanted to achieve, and then Mr. Yanetti also then had to kind of like take his whatever licks he was for violating the protective order. But I think he kind of got a pass, because what did they say in the courtroom? Mr. Yanetti, he's a great Boston attorney. He knows everything. He knows what does he need? All these people with pro hoc vicis, all these out-of-staters, coming in here. So I think that was a real, I was not, if I'm Karen Reed, I was not happy, but I think the defense is going to bounce back from that. Okay. Saber, thank you for your coverage. Question. Someone from the district attorney's office representing Judge Bev in federal court. Is that a problem? Is she represented in the federal court? Because she can't be sued. I don't, on this double jeopardy, what they do is they on the double jeopardy issue, they go against the state. They go against the state prosecutors individually. They have to name them, because you can't sue a state entity in federal court. The state itself can be sued. So they go against the prosecutors for bringing it. Now, if they have named her in federal court, then she would be represented by, it could be the district attorneys. Usually it's the attorney general's office here. But it's an interesting issue, because most people don't ever go into federal court to say your case is barred by double jeopardy. But if it's barred by double jeopardy, it has to be to prevent the prosecutor from then bringing the case, not the judge from sitting on the case. It has to be the prosecutor from bringing the case. And so you have to name the prosecutors individually by name, and not the office. You can get injunctive relief against the state, against an office in federal court, but the actual naming of to get that relief, you have to actually name the prosecutors. So we'll have to see. I haven't seen the federal court pleadings to see how they've actually phrased it out, but in their capacity as individually, or in their capacity as blah blah blah, is how it normally goes in some way. So no, it's not really a conflict, because it has to do with even if she were represented, if she were named, it's not really a conflict, because she made the ruling. It's simple as that. So. All right. So, Katie, question: how can an appellate court make a decision when the grounds aren't stated to know if the objections are legal? How can the appellate court make a decision? I believe you must be talking about the Supreme Court making a decision on the issue of, I assume, and correct me if I'm wrong, on the issue of whether or not the jury was polled properly, right? Is that where we are on that, Katie? Maybe could you itemize that a little more? Because what the Supreme Court said in terms of that appeal was that too much had gone on. The jurors had been exposed to too much. By the time it got to us, to send it back for a rehearing to see whether the jurors had made a decision in that jury room, whether all 12 of them had, because the affidavits weren't from all 12 jurors. I believe there was 5 or 6 or 7, depending contacts, but depending on who you're talking to, because the prosecutor wasn't as clear to me as to how many jurors had contacted them and whether they were duplicative of any of the jurors that had contacted the defense. I think that's quite frankly a hard decision on the defense. Again, defense has no control over when the case gets to the higher court in Massachusetts, right? They have no control over that. So they made their argument. They came back and they made their argument right before Judge Cannone, who ruled no, she's not going to call them in. She's not going to do a hearing on it. Unlike the hearing in Murdoch. Remember Alec Murdoch had a hearing with the jurors about whether they were improperly influenced by the court clerk. That wasn't really well done either. But so I just think that the Massachusetts court just is not going to go into breaching the jury sanctity in the jury room. They just weren't going to go there no matter what. Okay. Let's see. Hold on a second. Message from Michael. Our courthouse hearing, the federal wrapped up at 11:05. So 11:45 or so, they will be here. So that's the update, that the hearing has wrapped up in the courthouse at 11:05. It's going to take them about that long to get back from downtown Boston, where the federal courthouse is, to luckily they're not in rush hour right now. If they were in rush hour, it could take them 2 hours. It's rush hour in Boston is really bad, and I assume they're not taking public transportation part of the way. They're probably they have their cars, they have their SUVs and all. So about 11:45 or so here, which probably means about noon. Then the question is, how long do they and what do they argue? Do they start with the motion to dismiss right away and argue that and then take a lunch break, or does the court wait to start with them? I think she's going to start with them right away. So anyhow, so that's where we are with regard to that. We're already at 11:25. So, okay, Katie, I'm sorry. I meant, how can you just say objection and Judge Bev just rule? Okay, that's a really good question. All right. So every court has their own rules about how they want you to do objections. All right. And the best we heard was Judge Arnold, okay, let's go back to ASAP Rocky. I said no speaking objections. The courts, and if you're a lawyer and you practice in federal court law, you will learn this very quickly. You object, you cite to the rule that you're objecting to, or if you can't remember the rule, and sometimes under pressure you can say objection, hearsay. The court does not want you, and most courts do not want you to do a speaking objection. She's supposed to know by your objecting, just objection. Usually judges can discern why you're objecting. They kind of know, or they just want you to say the rule or the word that says it. Speculative, hearsay, outside the scope of the direct examination. Something that's small. They don't want you to argue why you feel something is hearsay. They don't want you to put all that. And so the judges, even in Hernandez, they just wanted you to say objection. If there was that you had to say something, you could say, may we come to sidebar? And then you can go to sidebar and you can argue it. So that's exactly why she may have them do that. And judges, judges been through, in fairness to all judges, Judge Cannone and everything, they kind of know why you're objecting. They kind of know, they have a feeling for it. And if they need more, they may say grounds, as we heard Judge Arnold and ASAP Rocky, grounds, so that it's on the record for the grounds. But everyone kind of knows what the objection is and all. But the better part is to make your objection if you're an attorney and state your grounds. And that can be a citation to the court rule, or it can be, especially for us who come in pro hoc vice, means into a new state, out of state for a case. It can be the reason, objection, hearsay, a reason 403. It's more probative. 404 is more probative. It's more prejudicial than probative, or something like that. So and all. So, well, Katie, what you just said, doesn't the appellate court only read transcripts of an objection is made? How can the appellate court know what they're ruling on? Again, they kind of know, especially in most times, it may not be relevant, because when you argue in your appellate brief and your transcript, you're arguing a point. And you can say what that point is. And so you can say what there was an objection made and was preserved here was the objection. And this is why the objection should have been sustained or overruled or whatever it is that you're complaining about. And the appellate courts kind of get it. But usually, because you're focusing on it in your briefs, right? You're stating why the objection was made. And you're saying this is why it was clearly made. We preserved it, and we preserved it for this reason, and this reason the case should be overturned for this reason. So it's really, attorneys kind of have that. The problem with most attorneys, right, is that they don't know the rule. They don't know why they're objecting. They don't want to set someone in there, and they can't think of the rule. And if you can't think of the rule, especially in federal courts, I'm not sure you can't think of the rule. You all judges say, no, you don't think of the rule. I'm not going to hear the objection. And most rules, as I said, most states are, the objections are pretty similar. The evidence code is similar. It's just that the numbers of the rules change. Many states have now gone to having the same numbering that the federal courts have in their evidence rules, so that it becomes easier for attorneys can always have the same rules in their head and all. But I've been there where I've forgotten. You're like, oh my God, objection. What's the rule? I mean, I know it's this. I know what's the rule number. And all that goes on very quickly because you got to do it very, very, very quickly, right? Extremely quickly. Okay, I hope that answered it. So, Blessed Mom from Texas, is it recorded for appellate issues? Is it recorded? Well, there's a transcript of it because the court reporter is speaking into that cone. The court reporter here is, most of it's Nancy King has been the court reporter for most of this, and she has that cone, and she's actually speaking what's happening into the in the trial in that cone, and then it gets transcribed from there. In appellate arguments, by the way, there is a federal court. There is you can get a tape of your arguments. I've done that. You actually. They can download it for you now, but they used to give you a tape of the arguments you paid for $15 because everything was recorded. In appellate courts, there's no court reporter usually in appellate courts unless you're having a trial, and then there can be a court reporter. But if you're doing just an oral argument, a lot of time it's just a tape. In most states, by the way, it's a tape. And in many states, they've gone to tapes with criminal trials, and there's been a big fight on that because your transcripts are not accurate. You can't get them right at the end of the day that quickly. You may want readbacks in court, and it's been a big fight to keep them in criminal trials. So in some states, certain criminal trials may have a court reporter, certain criminal trials may just have a voice recorder that takes things in. So in any event, it does get transcribed, and only in a deposition in certain states where you get a chance to review a transcript to say it's accurate and sign off on it. If a witness has a deposition, and you can give, in some states, you're allowed to give the witness the deposition transcript, and the witness can look at, you can make corrections because maybe the court reporter heard you wrong, or the court reporter didn't get my New Jersey accent, or the court reporter didn't get the Massachusetts, Boston, Harvard, or park my car in Harvard Yard accent. So and things can be changed with regard to that. So it varies, but here you do have they're speaking Nancy King, who's, by the way, a very, very good. She was excellent. We had her in hand. She was excellent. She's like the top. I think she may be the senior court reporter in the system. And she really is like the top of the line. And I always give her a shout out because she was very quiet in court. You never heard her. Like some courts, how we've covered them, and you can hear the court reporter. You're hearing like the transcription. You never heard her. She got everything. If you needed something overnight, she got it to you. If you needed something quickly, and my experience with her is that it was pretty accurate. Okay. Very, very accurate. And they have to sit there and they have to take, especially when attorneys are talking over one another. You see how hard it is with Michael Bryant and I. What's the comment that most people make? Stop talking over each other. Well, I can't right now talk over him because he's not here. But in our normal conversation patterns, when we're out to dinner with somebody or you're sitting at home and you're talking, you tend to talk over people, right? And yet the court reporter has to get everyone. They have to get everyone in there, and it is truly amazing. It's truly interesting. an old time court reporting, if you look at old time historical documents, when they say they have been recorded, it was somebody with a pen writing down things, and they were writing down high points. They weren't writing down actual transcriptions. So I tend to collect old cases, and you can actually go back, you're probably online now, and get some of these old transcripts, but they're not transcripts. It's like, and Mr. such and such, it was always a Mr., it was never a lady lawyer, okay? Such and such asked the witness if X, and the witness replied something, and all. So the old time transcription from cases is not the same as a modern transcription from cases, but there's still that fight to replace court reporters, and it's been pretty successful in civil cases now, to replace court reporters with court tape recorders, voice recorders, and all. They have the court clerk who starts it to save money, because paying a certified court reporter is expensive to have them online, and then they get paid by the court for doing that. And then if you buy a transcript, you also then you pay by the page, which is different in every single state, but it can become very, 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 very expensive. One of the things that we talk about with transcripts. And just imagine with a transcript of the Karen Reed case, if this went up on appeal, the transcript of that first hearing. And then, you have to have a transcript of the second hearing, right? If you have to get transcripts at all. And I'll guarantee you that the defense has gotten transcripts of probably every single witness that testified in the first hearing. Because why? You all know why. They want to impeach the witness if they come up on trial and say anything different. So every witness is going to take, in my opinion, a lot longer, because a good attorney can take one word that's different that somebody has said from the first trial and really go after that one word and really cross-examine for a long time. And Alan Jackson tends to do that. Yeah, let's separate. Let's all of you separate what you saw from the prosecution in ASAP Rocky, that's John Lewin, from Alan Jackson, right? Both tough examiners, but Lewin, the feeling was when somebody would give an answer, and if he didn't like it, he said, "But my question was," or "Answer my question." And he'd have these statements that were kind of like a tell that he didn't get what he wanted, and he'd go back at the witness constantly. What Alan Jackson does is take what the witness says, and then goes on from there. And he listens, and you watch him, you'll see him there, he's standing there, he's listening, he's not working off notes, he's listening to what the answer is. And if the answer is something different, he actually, cross-examines very well. Now, I expect that Hank Brennan is not going to be Mr. Lally. I expect that Hank Brennan is going to be a very good cross-examiner. Why? Because defense attorneys are known not to be so great doing direct examinations. Why? Because they don't, they haven't been, when I was a prosecutor, I had to do a direct. What happened next? You have to know how to frame your questions so that you get the story out and the witness tells the story. But defense attorneys, what do? We get to cross-examine all the time. That's our bread and butter. So we are very good at cross-examining, and all of us have our style of cross-examining, right? As defense attorneys, I do expect that since Hank Brennan is really a defense attorney, and again, whether you like him or dislike him, he's a very good attorney. He's very good in court. He had to be good in court to represent someone like Whitey Bulger, okay? And he is going to have, his cross-examinations are going to be more biting, more sharp. They're not going to be John Lewin type cross-examinations, but they will be biting, really sharp, and he will be prepared, okay? Because he is a defense attorney. So you're going to see a lot more of a dogfight here, I believe, when Hank Brennan starts to cross-examine witnesses. Now, so far, interestingly enough, he has everybody sitting next to him from the first team, right? And I don't mean the first team in terms of how important they are. I mean the team that tried the case to begin with, right? He has really taken all the arguments, right? He's the one. He's been up there. He's been the Alan Jackson of the prosecution now. He's up there almost all the time, and he's doing every single argument. And by doing every single argument, what's happening is he's also learning the case, all right? Because you come into a case, you don't know necessarily the nitty-gritty of the case. But now he's been in this, and by taking all these motions and by filing these motions and by arguing these motions, he has learned the case, and he is, I think he has learned the case pretty well. And I do not expect, again, this is going to be much more of a dogfight this time than it was when the first trial happened, which means that if you think Karen Reed is innocent, that it's going to be much more of an issue. Because remember, let's assume the first jury did acquit her on the murder and the first count, the third count, but on the second count, the motor vehicle, the manslaughter didn't acquit her, that they were split. All right. That could be where he's going to go. I mean, quite frankly, I've always said on this case that if I were the prosecutor on this case, I think it's overcharged. I think you go with the second and third count that you have. You charge it, and you say, if anything, it was reckless or it was negligent, but that she wanted to kill him, or that. I think that's a problem for the prosecution, because they did overcharge here. And yes, Alert One Systems, I'm just seeing you come across the screen because I know all these questions are coming fast and furious. I do think he does want to win this case. I mean, he took the case, and as an attorney who's known as a defense attorney, he took the case, right? So, could this hurt his defense attorney abilities? Well, people can say, well, you can argue anything, right? He can look at this, you got this conviction. But for some reason, he as a defense attorney decided to be special prosecutor in this case. Some may say, and I've heard people say, well, that's because look at all the publicity. Who ever heard of Hank Brennan before this case, even though he represented Whitey Bulger? But everyone's going to know who he is after this case, especially if he gets a conviction and all. And then that may not hurt his defense attorney abilities. Blessed Mom in Texas, thank you. Again, thank you for becoming a member and joining us and speaking out and having all these questions today. Oh, speaking of attorneys, speaking of why does defense have to turn over impeachment evidence? It's a real interesting issue. It's something that's gone on for years, because us lawyers don't like to turn over impeachment issue as any side, because we want to set that trap, right? But most courts now have ruled, all right, and in federal court this has been this way for a long time. You have to turn over your impeachment, all right? Yeah, they have to know beforehand, and if something new comes up that was not anticipated, well, then, and you need to use something as impeachment, then you can do that. But for instance, and I'm going to say federal court because Massachusetts now has basically has adopted the federal court rules in terms of numbering and all. In federal court, for instance, we have to do a pretrial memo. And what that is both sides have to get together. It's something that attorneys hate, and if it's a civil case, these civil cases and usually settle because of this. All of everything that's going in the trial goes in that memo. Okay, if it's not in that memo, it doesn't get into trial, and the memo ends up being like this because it has a list of all your exhibits. It has all your exhibits. They're all pre-numbered, pre-marked, and all. So turning over impeachment materials now has been a thing for a while. Massachusetts has just ordered that impeachment material has to be turned over. And that means both for the prosecution and the defense, except if something new happens in trial that you need to use something that no one had anticipated to impeach somebody. And then you can use it with the permission of the court. But there's this whole idea of trial by ambush. I think there's this whole idea, like if somebody were going to get up and lie, why should you tell them? Did you have something that shows that they were lying so they can get up and say, oh, excuse me, I'm sorry. Oh, I apologize. I didn't mean that to happen. But that's the way the courts are ruling, and you have to follow the rules of the court. All right. Oasis Cat LL, what do Lewin and Brennan have in common? The crybaby meme. I don't have that. Michael Bryant has that on his computer. I think Missy has it, but yeah, that was Michael Bryant. Oh no. There it is. There it is. There was the crybaby. I actually think Mr. Brennan is, in my opinion, if I had to rank them, I think that he is a better attorney. I mean, he is. I just think he's a tough attorney. I think that the defense has met their match in him on this, and so that really is funny. I have to say, but I can see how you all feel about that way. I'm just telling you from an attorney point of view. And I'll guarantee you the defense is not looking at him as a walkover, shall we say. All right. Alert One Systems not to create a conspiracy. Why not? We all love conspiracies. Create. But Whitey Bulger's brother was a state rep at the same time Morrissey was. A possible tie of HB to Morrissey. Could be. I mean, the Massachusetts, everybody knows everybody, but that's the case in a lot of cases. When I went down to Tennessee, and we met somebody last night, Michael Bryant met somebody in the group that we interviewed. If you haven't seen them, the group that he interviewed at the clerk's office, you should watch that 14 minutes. Even if you have to get off and watch it and then come back here. Is that in Tennessee? Everyone knew each other in that courtroom. Hi, hey, how's your brother? Hey, brother, my sister-in-law. They all know each other, and here I am from New York, dressed like this, So so you find that, yes, it's possible that's the case, and also I'm sure Hank Brennan's been very active in the bar associations and all, and the top people in various areas know the top people, and sometimes it can be because of politics. Let's not forget politics. We try not to go there on the show, although one of these days we're going to go there, because I keep making allusions that one of these days we have to go there, because I think that the prosecution and funding of prosecutors and how people run and how prosecutors run to get higher office, that's political, right? They want to win. Prosecutors want to win. Now, do we know if Hank Brennan wants to run for office? Well, I don't know. But like, if you have a prosecutor, we had the prosecutor in Massachusetts. I think she was in Suffolk County. She ended up being attorney general, right? She wanted to run for higher office. That's political, all right? In some states, the judges are not, by the way. In some states, judges are elected. That's all political. In New York State, many of the lower court judges are elected. In New Jersey, judges are not elected. Judges are appointed by the governor, and it kind of changes. And in New Jersey has a very interesting constitution, one of the best there is. Our Supreme Court, it has to the two parties, they have to alternate who's going to be appointed. If it's a Republican opening one time, then the next one's a Democratic opening. So it keeps the court in balance. Very interesting process, and it's built into our New Jersey Constitution. That's why I'm from New Jersey, even though obviously I'm living in New York, because it was a choice of living in New Jersey or when I got married, to live with my husband, and we lived together in New York. So he didn't want to come to New Jersey. I'd rather come to be in New York. So here I am, but still New Jersey's where I have a lot of my practice. My law firm that I'm of counsel to, Crinkell is in New Jersey, and my heart is as a Jersey girl, as Bruce Springsteen would sort of say. So, and you've all seen Bob Bianchi. We kind of get attached to I guess we get attached to our roots, in some way. So all that is happening right now. Any update, Missy, on Michael about what he's hearing or seeing in terms of whether they should be there right now? Because it's 11:47. All right. I do see. I'm just looking at some of your comments. Yeah, I see a lot of prosecutors who want to win, and that's why we talked last week about that Richard Glossip opinion. Okay, he hasn't responded yet. Just ignoring us, Missy. Michael Bryant is ignoring us. We have to just razz him on that. But that's why that Richard Glossip case is so important. And as Neil Rockheim said, everyone should have it in their toolbox if you're trying a case, every defense attorney, because if your witness as a prosecutor lies on the stand, you have a duty affirmatively to get up and correct it right there, right? Because the court said in Richard Glossip, the Supreme Court, 5-3 decision, although it's really 6-3 on this issue. It was 5. Yeah, it was 5-3 because it was 5-3. Yeah, it was 8. And then it was 6-2. I'm sorry, 6-2 on this issue because Amy Coney Barrett, she both agreed and dissented in part. But on the issue of a lie is a lie is a lie, no matter what the subject, I think they all agreed. And the 6 of them agreed. So you cannot, you're close to suborning perjury. As a matter of fact, you may be suborning perjury if you know your witness lies on the stand and you don't correct it. I think that you are suborning perjury on it. And, you know, that's why there was such a discussion in the A$AP Rocky case once the prosecutors knew that there was this tape out there where Relly, if you recall, said that to get, he won $30 million and you go on the beach somewhere, then the prosecution would never find him. But to get the $30 million, to get the bag, he called it, because, you know, he used to get bribes by bagmen, you know, he needed a lawyer to do it, or else they call it extortion. I think, you know, we all saw that, and I think there was a problem with that. And we still are. We haven't had time to do the letter out. We have those questions still out to LADA in my Twitter account as to whether or not there was an ethics review in bringing this case. You know, kind of like you're almost vouching for Relly when you put him on the stand, you know, and we think that the desire to win now has become more important than the desire to bring justice. And I did hear Hank Brennan say something in the court. He said, you know, my duty is the duty of justice. It's not winning. So I hope he sticks to that because that is his duty as a prosecutor. Now, as defense attorney, your duty is to represent your client and do everything you can to get that not guilty verdict within the bounds of the law, right? Here we go. Can you honestly see Lewin doing that in trial? There's no way. He's going to be so screwed by the new rule, and rightly so. I cannot see Lewin doing that, okay? I cannot see Lewin doing that. And we will stand by our reporting in that the judge has in that reporting, the judge asked the prosecutor whether or not they were going to go forward when Relly was being cross-examined based on ethics of some sort, some ethical issues, and that the judge asked them a second time whether they would go forward based on the Relly cross-examination. We stand by that, and that's why we want to invite the LADA on to Mr. Oakman, to Hotchman, I guess it is, to come on our show and talk to us about what kind of ethics review they had. But you're absolutely right. I don't see John Lewin ever standing up there and saying this witness lied. But he'll go after your witnesses, right? He'll go after the defense witnesses for every little thing. Yeah, but you didn't put the word "the" in what you said before. You didn't put the word "and" in what you said before, and all. And while that was great TV for the Durst trial, because everyone hated Durst and believed that he killed his wife, and the body was never found, and all. When the A$AP Rocky case came along, and you had everybody who was pretty likable, and some serious doubts about the prosecution case, that style did not go on at all. But you're absolutely right. I somehow don't see. Not to say he's not ethical. I think that he believes he's ethical. And you know, if he knows somebody was lying, but Relly admitted perjury. So I guess what Lewin would say is, if he admitted perjury, then I'm using him. He's admitting the perjury. So you know, I'm not vouching for him and his credibility in any way, and therefore it's ethical to put him on. I think that is the argument I'm making. I told you, as lawyers, we can make both sides of the argument. I'm making that argument because I think that's what the DA and he would say, right? So but you know, Durst was a different animal. I assume most of you watched the Jinx. Remember, Lewin had that case. Just some inside information, not inside, but inside baseball, I guess you would say. Lewin had the case. He was assigned to the Cold Crimes Unit. He had that case, and no one could actually solve the Durst case, right? And then the HBO movie, The Jinx, came along. And had the bathroom tape where Durst is in the bathroom, and basically, if the prosecution's bent was right, which it seemed to be, was confessing to a crime. Although it could have been interpreted differently too. It could have been that he thought that that's what they were thinking. But so he gets that, and he flies, and he goes and interviews Durst directly in New Orleans. Durst is arrested for the guns and weapons charges. But he gets the case, and then he gets the evidence of the letter. It basically handed to him, not because of anything the state did, but because of what the TV producers did in the Jinx. And then when he gets to prosecute Durst, quite frankly, it's an easy prosecution, and one didn't have to last for like how many days of cross-examination? 20? I don't even remember. All I remember is that when I was hosting on Law and Crime, it was forever. That indeed it was an easy prosecution. You and I could have done it. My pillow probably could have prosecuted Durst and gotten a conviction with that evidence that they then had. So then he became a household name, but I don't think anyone ever heard here across the nation of John Lewin before the Durst case. He may have been known in California, obviously was known in California, given some of the things that have come out in articles now, but he wasn't, obviously he wasn't, he wasn't known as a household name worldwide before the Durst case. Missy says there is no update from Michael at the courthouse, and I'm looking at the court feed also. We have it up and running in our background, in our behind the stage here, and I see that it has not, nothing is happening right there yet either on the court feed. So now we're getting to, yes, we're getting to noon. As we said earlier today, if they get out of court and then they get there, and by the time they get to court, it's it's going to be noon, and then the question is she going to go forward? How far is she going to go forward? What's the series of what she's going to do? What are the other motions that have to be done and desired? All right, so oh my gosh, I'm hearing things dropping behind me in my office kitchen here. So we'll see. All right, so what do you all think on the motion to dismiss? Alan Jackson said he needed about an hour to argue it. I think it could be an hour. I think it could go to an hour and a half and I think Hank Brennan said he needed about a half an hour to argue against that motion to dismiss. I don't see the motion to dismiss being granted. I think the MTD is being made to protect the record. And by the way, it was a very good motion to dismiss, nothing that we hadn't heard before, except for the allegation. And I say except because it's a big except, the allegation of jury tampering. And that had to do with the defense saying that the jury, I guess upon the interviews, had felt pressured by the family of John O'Keefe being in the courtroom, which there's nothing they can do about that. They have the right to be there, and they should be there. But I guess they also, in the way that the court officers were handling them, they felt pressured. They felt intimidated by the court officers and all. It's going to be, it's going to be, I think that's going to be hard for the court to say that amounted to intimidation, specific jury intimidation. Now, but having said that, if you recall, and I don't have I have some of it here, and I have some of it here. I have some of the motion. No sense taking it out. Most of the pages that related to were redacted. They were in black. So if they had juror affidavits and all, the judge has those. And we may get a look-see into some of that redacted material today when they argue the motion. Although the judge may say that you can argue the motion and just say it's exhibit such and such without referring to what the exhibit says in open court. But at some point, the judge has to rule, and she has to rule on it with a written opinion. And a written opinion, I think, could say eventually, because eventually she would issue a written opinion. I reviewed exhibit such and such, and without putting it into the public view, blah, 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 I find that there was no jury intimidation. But when it goes up on appeal, it does go up with the redacted version coming into the appellate courts and the non-redacted version, but we never get to see it. It's kind of like, just think about cases involving children. A lot of times, sometimes now courts are not even putting initials in. It used to be in here, Massachusetts, you still put initials, but some of the courts don't even put initials. They'll say, juvenile sealed number A, juvenile sealed number B. And then the whole record with juveniles then gets redacted in some way, right? Because you don't want people to read what the juveniles see. And then when you go to the Supreme Court, you don't even find if there's an opinion. You find the cases reversed and all, but some of the issues never see the light of day because they still remain sealed. So it's a very interesting process when it happens. Alert One System, do you think the fact that Bev appointed the trooper to cover the jury is a redacted part? I think that it has to do with juror affidavits. I think it has to do with juror affidavits and how they felt. Because what they don't want, although the state will have it, because remember the state gets to see the unredacted and all, and the court gets to see the unredacted versions, which is that we don't get to see it. They don't want somebody going after jurors, and I think that that maybe a juror interview, 2 juror interviews, 3 juror interviews, because they're making the argument that the jury felt intimidated by what was said or what was done to them or how they were handled. We're not sure because, again, all of that is redacted, all right? The defense came back, the prosecution came back and answered some of it and said, well, the officer that they're talking about never only handled them outside, never really brought them inside, never had the kind of contact that the defense was saying to have any type of influence on them. But we don't know what the influence, we're talking in the blue here because we don't know what the influence that the defense alleged the prosecutor had through the court officers or the state trooper or anybody else. What if there was something else we simply don't know about that came across? What if somebody came into the jury room and mentioned something? We have no idea what the argument is from the defense, except for the fact that the state said that the one officer who was assigned to them really never had much contact with them. So, it's kind of hard to answer without knowing what the specifics are. And I don't know whether the specifics will come out today at all. I have a feeling that they're not because I think the judge can say she can decide the case without revealing the specifics to the public, that the public doesn't need to know. And the question is, does the public ever need to know how a juror felt? Now that doesn't mean that jurors can't come out and self-identify. If any juror watching this wants to come on the show and identify themselves, and we can confirm that you were actually a juror on that case and talk about what may be the arguments of the defense here, especially with regard to if you felt that you were intimidated in any way by somebody related to the state or how the state handled the jury or what was done, please, you can talk. You are free. You have a First Amendment right to speak to anyone you wish to speak to. And we'd love to have you on the show because we have people that are truly interested in justice and how it works and how the system works and whether or not one person, Karen Reed is fighting for her life. She said she's not guilty. She said she's not guilty from day one when she pleaded not guilty. People have formed opinions that she's guilty, and yet she is talking. She's doing exactly what most people don't. She's talking. She's saying, "This is my truth, and I'm telling you, and I'm not scared to tell you. I'm not scared to tell you. I'm not even scared to tell you in public. I'm not scared to take an interview. I'm not scared to answer your questions." And she's been doing that. She did an interview with Ted Daniels. That was kind of dribbled out initially, then was set forth in full. And even when she walks to and from the courthouse, right, she talks to the press. And she even said yesterday when there was a question about whether or not her team would be gagged, all right, because it wouldn't apply to her, right, that she would talk to the media, that she has no problem talking. You don't normally find that with people that are so guilty that they want to talk and tell the story. And she wants to tell her story. One of the things I thought that always kind of hung out on me with regard to this case was that, there was an indication that she moved in with John O'Keefe and that she actually took care of his kids. And there were some emails or some indication that they felt that she was great at that time, right? That she was wonderful. But now everybody hates her because they believe that she killed Mr. O'Keefe. But initially, by the way, Michael Bryant says he's uploading an arrival video to our members group. So remember, you can subscribe, is free, but if you want to become a member and get some things early on or before the rest of the group has it, our members have, there's different level of memberships and here in Justice Served TV. And he's uploading apparently the arrival of the defense team and Karen Reed into our members only group right now to let them get to see it first. If you are members, please go watch it right away because we'll try to then later on tonight put it on the main show to show that the group arriving. So at least we're getting some movement here, that we're getting close to possibly getting into a court hearing. I'm sure Judge Cannone wants to get this started because the question then becomes, does she, it's almost lunchtime. Does she wait to after lunch now? Does she start this hearing? Remember, she has certain obligations in running her courtroom in terms of union obligations, in terms of when people would take lunch. But I think that they've probably been in contact. I'm sure they've been in contact and knowing when indeed, there will be arrival. There's a lot of behind the scenes that we, as we sit there, you don't know. But when we're in a trial, like, if we're going to be late, we're calling the judge or calling the other sides that will be there, or we're filing papers, whatever. There's a lot of communications that goes on that you don't think goes on, but goes on behind the scenes in a real case. So I do think the redactions have to do with the jury feeling that they were pressured, the argument that says the jury feels they were pressured. No doubt about that. So yeah, I'm looking at the feed. There is in the feed there is simply nothing. We're not even at the point where we're seeing the fans. I mean, I'd like to see the fans. There you are. That's not even the fans, right? Court TV has the pool camera there, and so we'll be feeding in from that pool into Justice Serve TV. But we're not even seeing. We're not seeing the. I want the fans. Give me the fans. Come on, let's get this party moving here. But again, if you're watching right now, please hit the like button. The subscribe button is free. Please hit that. The notify and all. But if you want to become a member, that is a fee. I forget what the memberships are, and all at different levels. And I will tell you something we will do that's going to be interesting for members. When I think I mentioned to you, we're going to start. We kind of got waylaid by the Karen Reed case, but we will be starting trying to find a case of who killed a young girl named Stephanie, a teenager in Oregon back in 1968. Cases had no media, no press. As a matter of fact, we call her the ghost victim. And I'll let you know how we ended up with trying to do this as we get closer. But one of the things that we want to do is perhaps with our memberships, people who are in the top tier membership can lead certain teams that people are on to do certain things, because there's going to be a lot of legwork, phone calls that will need to be done, and internet research and all. And I know you're all keyboard warriors; you can all do that. And group meetings to say what they've done and to report back to myself, who probably will be leading this, to see what we can find out. And so we're thinking of doing that through the membership to start with, and seeing how that works is that the people that are in the membership get to lead the teams. And if you're not in the membership, you won't get to lead a team. And so we haven't quite figured that out yet. If you have your thoughts, let us know, because we're still working on that. But when you do, you'd be getting yourself involved in a lot of work. But we know you all like that, especially if you can bring justice to somebody who seems to be a forgotten victim. All right, we haven't given you her full name yet. We already have we already have a Google Drive loaded with information that I have been able to find in terms of a death certificate. It's interesting in Oregon. Unless the case is 50 years old, you can't get a death certificate. A member of the public cannot get a death certificate to see what a cause of death is, right? So it's really, really interesting. All right, so you know what? Missy says that if I need a break, which I do, we can replay the 14-minute tape of the interview last night with people on the scene. But but all are in court, so it shouldn't be long. So why don't we try to start playing that tape? And as soon as court starts, we'll go right into the court hearing. All right, and then I will come back and I'll be back at you because I do need a few minutes nature break. See you in a few.
Well, that's what I'm asking. What's your source for the
media-
information?
When the feds come out and they do a press conference, then I'll believe it. But like I said, just because one door closes doesn't mean 3 other doors don't open up off this investigation. As I said, Sandra Birchmore's case is still open, that's still ongoing, and that does have connection to the Karen Reed case, and the players are the same players in it.
So you're saying Karen Reed personally, or the team suggested that it's still ongoing?
Well, they had no comment. So the media called the office in Boston, they had no comment. Why?
They're saying it on sources.
See a trial. How often do you see a trial where the prosecutor or the DA don't make press conferences discussing what takes place? The defendant's attorneys are the ones speaking to the press. That tells you something. It
Well,
tells you.
I will tell you, in my experience, quite often the prosecution says nothing during the course of the trial. That's not unusual.
Well, I think it's unusual because I follow a lot of trials, and I've always seen a prosecutor, whenever there's a big change in the case, there will be some sort of press conference that takes place when there's going to be a second trial. They will discuss in some way, they'll say, we won't discuss the details of an ongoing investigation, but we will tell you we plan on moving forward with this and we plan on moving forward with that. That happens almost every time, especially in a high-profile case, especially if they're trying to win the public trust. But that doesn't seem to be the case right now, and I wonder why.
And you're talking about Hank Brennan, who represented Whitey Bulger. We here in Massachusetts know how crooked the stuff rolls around in this place. And everybody is covering for anybody. So Hank Brennan is on his knees and he's saying whatever he wants to say. We've watched it in open court, him just spill whatever he wants to spill out. And Bev Cannone doesn't say anything to stop him. But yet when the defense gets up to say one thing, they're interrupted 1,000,000 times and the flow of things. So Hank Brennan can get up there and literally do whatever he wants to do, and there's no repercussion. So he can say whatever he wants to say. Nobody here is going to take what Hank Brennan says at 100% because he can do and say whatever he wants.
Does anybody have any thoughts about the fact that Brennan's a defense attorney now?
I want to know how Brennan came up with signing a thing saying he's doing this trial for $75,000 and it's already up to $225,000. Us, the taxpayers of Massachusetts that work, we have this weasel piece of shit up there paying him more than what he even signed on for. Everything that he has said so far just rolls off and there's other stories to it. There's no trust. We don't trust Hank Brennan. We don't trust the prosecution. In the state of Massachusetts, you're innocent until proven guilty. And right now, no matter how you feel about Karen Reed, you should be disgusted at the investigation into this because there's no way they should be convicting her on what they have. There's tainted evidence. The investigation has been foul since day one. And all the police officers here, you take an oath of what your job is, and they've broken so many oaths in here. So nothing that they did. Karen Reed, we shouldn't even be here. We shouldn't have to fight like this because she should have been let off a long time ago.
Amen.
And they're backed up against the wall because they know if one thing they should have had lesser charges on her. They're the ones that overcharged her. And right now they're scrambling. They're scrambling so hard because they don't want any of this to go on the police officers. They're being protected right now.
Let me ask this generally. How many folks are here, and you don't have to raise your hand if you don't want to, but how many folks are here because of Karen Reed? How many are here?
And correct to the best of my knowledge, signed and sworn to under the pains and penalties of perjury this 21st day of February 2025. So the fact, what you state is fact, that Lieutenant Fanning had control over and access to this jury is simply not true, Mr. Jackson. The only people who have any access to those jurors are the court officers in the Department of Security of the trial court in this courtroom. So I am going to ask you what your good faith basis is for that, and I'd like you to start there.
If the court recalls the discussion at sidebar, we were told for the very first time, Your Honor, about this issue concerning the juror and concerning the individual who reported information suggesting that there was some sort of misconduct at sidebar by the court with no additional information.
No, I didn't tell you about the role. I didn't know who it was.
I'm getting to that, because that was the next conversation that we had. When we were told on the day of closing argument to approach sidebar, the court indicated through multi-level hearsay, we'll all agree that it was some sort of multi-level hearsay suggestion that there was some sort of misconduct by the jurors, or by a specific juror. We pressed the issue at sidebar and asked who the source was. At that time, for the first time, we were told the name Lieutenant Fanning. We obviously recognized
You were not,
that.
just so we're clear, you were not told that by me.
No, we were told that by, and I'm getting to that as well. We were told that by Ms. McLaughlin. She's the one that indicated that it was reported, I'm sorry. That's not right. That's not right. We pressed the issue on who was the source. I believe the court then inquired of one of the court officers.
Who are in charge of the jury?
Your Honor, I'm getting to that. I understand that. But if you'll allow me to make the argument and to indicate what as my declaration says, my good faith belief, based on a reasonable belief, this is how we get there. We were then asked, or the court asked the court officer to join us at sidebar. He then indicated that it was Lieutenant Fanning. Ms. McLaughlin then went on to say, and by the way, he indicated that Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time, as the court knows. There was no declaration, there was no report, there was no supporting documentation whatsoever, no recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror where she said, not that I remember, no. That was the initial statement that she said in terms of any misconduct. No, I wasn't talking about the case. Over the defense's objection, this very potentially defense-friendly juror was then excused. During that discussion at sidebar, that's when Ms. McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required, period, end quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that
and
he has...
I'm just going to stop you. I'll let you finish in a minute.
Okay.
Mr. Yanetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
If there is a commander of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up, Ms. McLaughlin told us. We were told he was the commander, not part of a security operation that was outside the court, not part of a security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't. Again, that's news to me.
You were told that at sidebar that day by Ms. McLaughlin.
No, we were not. We were told.
I have the transcript.
Well, Your Honor, what we were told is what his title was. Commander of the extensive security operations of the court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time, in good faith. Both Mr. Yanetti and I asked the court to take evidence from Lieutenant Fanning. The court
I think it was
declined.
Ms. Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue, so I wouldn't have to make reasonable conclusions. I would actually have the information. So of course, that's one of the issues that is attendant to our motion to dismiss, because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals, or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began. Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes. And then his name comes up at sidebar as the commander of the extensive security operations attendant to this case, and he's the source to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court. It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly why we put it in our papers. And without additional information clarifying that, we have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago when you already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February 2025.
Correct. On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors is when we received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned he never had any direct access, he didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed the opposition. That's the first time someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson.
Your Honor,
Well, put it this way. Let's say it this way. So, now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized? Now that you know it's not true.
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors? I don't know that to be true. I mean, I take the court at its word, obviously, clearly.
So we will move on from that, Mr. Jackson. We'll move on from that, so.
Well, the court's asking what is our evidence of, or what's our indication of the impropriety of him being the person that actually reported this misconduct and ultimately leading to the exclusion of a very, very defense-friendly defense-friendly juror, or presumably a defense-friendly juror, and knowing at the same time that he was intimately involved in the prosecution of my client. That's the reason. Because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case, and he ends up, just ironically, who knew he ends up being the source of the information that got that juror removed. That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that that shouldn't have happened. He certainly never, ever should have had any access, even in the orbit of the jurors, directly or indirectly, and the court never even inquired as to why he was the one receiving the report. Why Lieutenant Fanning, of all people, who then reports it to the court officer, who then reports it to the court, who then removes the juror. That's an awfully straight line between Lieutenant Fanning, who has an interest in this case, and the removal of a juror. That's improper in our view. And that's why we put it in the papers, and that's why we argued it the way we did. Because we were working off of extremely reasonable beliefs based on information that was provided to us at sidebar in the court's presence.
All right, so that's your answer to my question.
That's my answer.
May I have a moment to confer with counsel?
Yes.
Hi, I'm adding myself to the stage for a second because we took the break at the right time and this came back pretty heated. Now we know what's basically in those papers that was redacted and all. And that has to do with Lieutenant Fanning. And the court is, what Alan Jackson is saying is that this officer who not only was friends with everybody, turns out to be in charge of the whole security system dealing with this case, not just like, if they were outside or whatever, and reported information.
The court invoked Mr. Yanetti and said, as local counsel, he knows this not to be true. Mr. Yanetti just indicated to me that that's not quite the fact. And so Mr. Yanetti, I think, should be able to at least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Yanetti. So if the court would allow Mr. Yanetti to explain what his experience is, that may elucidate on this issue.
If we have time later, go on with your argument.
I'm happy to, Your Honor, and thank you for giving me the opportunity. The cumulative discovery misconduct by the Commonwealth, as laid out in our moving papers, through their agents has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers, but I want to concentrate my argument for the court this afternoon on the exculpatory Sally Port videos. I'm not waiving any of our arguments in the moving papers, but in the interest of time and focus, I think it bears upon the court at this point to consider most prominently the Sally Port issue, or the Sally Port video issue. The Commonwealth, to start off with, two facts that are true. The Commonwealth cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not deny that untimely disclosure. And they also cannot deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. So what do they do in their opposition? Most of the time they spend saying that the prosecutors themselves did not know. They had no actual knowledge. Well, they concede the unavoidable in their moving papers, which is that the Massachusetts State Police and the Canton Police Department both knew about the evidence and both withheld it. Conveniently, they throw much of this on the back of Michael Proctor. It was sort of to be expected. He's already damaged goods, so why not? And they also bring in a newly revealed sergeant, a sergeant by the name of DG Petro, who's already retired, gone from the police force, and who interestingly retired just 2 days after the Commonwealth's October 2024 disclosure revealing previously withheld Sally Port video.
I'm just going to ask, is he available, Mr. Brennan?
Not today, but he could be available.
I'm just curious, so he's still around?
He is,
Okay.
yes, and he's cooperative.
All right. All right, Mr. Jackson, go ahead.
Our motion illustrates that, and by the way, I'll walk through the videos that we did get and when we received them. Our motion illustrates that dismissal in this case is required because of the cumulative impact of clear-cut discovery violations, clear-cut, inexcusable Brady violations, And from a legal standpoint, the conduct in this case is so egregious, it's so pervasive, and it's so deliberate that prejudice must be presumed. We don't have to prove prejudice, it should be presumed. To begin, I want to start the issue by talking about the condition of Miss Reed's passenger taillight. The condition of that SUV passenger taillight at the time it was brought into the Sally Port at Canton PD is of critical importance. And that may be one of the most important facts in this entire case. It's important because we know as a fact now that not a single piece of taillight was ever recovered at 34 Fairview until after that vehicle was in the possession of Michael Proctor and the Massachusetts State Police. That is the foundation on which this entire argument is built. And it is an undisputed fact, although it wasn't undisputed for years. Other material facts that are not in dispute. The Sally Port video has been in the possession and custody and control of the Commonwealth since January 29th, 2022. That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. On April 4th, and I want to walk through what videos we did get and when. On April 4th, we got 2 videos. One was the Sally Port interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the Sally Port. And we also received a Canton Police Department driveway video with the SUV on the flatbed, which did not show the rear end of the car. On April 23rd, 2024, and by the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd, in the middle of the trial, we received another Sally Port interior back wall video. That was the video that is now sort of famously inverted. On October 10th, 2024, 2 days before Sergeant D. Giampetro retired, we received 4 videos. The Canton PD interior hallway, the Canton PD rear lot main side, the Canton PD rear lot cruiser side, and the Canton PD church side exterior Sally Port. And I highlight the word exterior because it becomes extremely important in just a moment. These are 4 videos, all of which show Brian Higgins in some way, shape, form, or fashion at the Canton Police Department on January 29th, 2022. Then on January 28th, 2025, the Canton Police Department main driveway side exterior Sally Port was given to us. It's a grainy and very wobbly video that nobody can sort of make heads or tails out of. You can see the general outline of a vehicle, but the condition or the quality is so bad that you can't tell what the condition of the taillight is, which is what we're interested in. And I bring this to the court's attention, or I highlight this, because this is the second exterior Sally Port video that we ever received. One on October 10th, one on January 28th, 2025. Then on Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Buchnick dated February 28th, which is 4 days ago, 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony. He goes on to say, quote, at this time, I reviewed the video and I reviewed video made available to me, which included video footage of the Canton PD exterior Sally Port. Exterior Sally Port. That means that the Massachusetts State Police not only had in their possession exterior Sally Port video, but they knew about it and were reviewing it during trial. But we didn't get any of it until, as I just said, October 10th, we got one. January 28th of this year, we got the other. So that was withheld from us for the entirety of the first trial and all the way until at least October 10th, possibly as late as January 2025, and they've now admitted that. But who else knew about this withheld video in May of 2024? during trial. On cross-examination.
So can I just ask, was this of better quality than anything you had had, or was it the same wobbly? Okay.
Same. Wobbly, grainy, can't make heads or tails out of hardly any of it. No. The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th, Trooper Buchnick admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony. Was that the video that they were reviewing together? Was it the exterior Sallyport video? We now know that Buchnick watched some sort of exterior Sallyport video. He admits it in this report that we just got 5 days ago. And we also know that he and Mr. Lally were reviewing video together before his testimony in May of 2024, because he admitted to that on cross-examination during trial. But I didn't have information about what he was reviewing, because we didn't have the videos. So either they reviewed together the inverted video that was then played and knowingly presented false evidence to a jury and to this court, or they reviewed exterior Sallyport video and intentionally withheld it from us. This is binary. It could only happen one of two ways. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally. Either way, the withholding that evidence admitted to now by Trooper Buchnick was obviously egregious. It was obviously in error. It was obviously calculated. Another important material fact not in dispute, on April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Sorry, can I just get back to that, what you were just discussing about May 2023?
Yes.
How is that exculpatory?
Because the videos themselves, as the court will see through the presentation of my oral argument, that the fact that those videos all just happened to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward, all tend to show that the Commonwealth doesn't want the condition of the taillight to be seen by anybody when it's pulled into the Sallyport. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
I will get to the prejudice as I move through
now
my
or no? If you can, if you're going to do it later, that's fine.
I will do it later. I think the prejudice is cumulative. Obviously, we didn't have the information that we needed to be able to cross-examine the witnesses that we needed to be able to cross-examine at the time that it was provided.
Okay.
It just, very obviously, there were certain videos that were clear from some cameras on other days and other times, but these cameras that were late discovery that was provided to us just so happened to all go out. They all find their way to be defective in one way or another at the exact moment that we would need them. On April 10th, 2024, the DA filed its certification of giving us all evidence that they had in their possession, and that they had done a reasonable inquiry. Both of these, that certification was just flat not true. How could that be true, and we're still getting video evidence that is in their possession, custody, and control in October, in January? How could that possibly be true? It isn't true. And it's illuminating when you look closely at the Commonwealth's opposition to our motion. First and notably, the Commonwealth makes these broad statements couched as fact. They're bold pronouncements, and there's myriad excuses in their opposition paperwork. And it's backed up by next to nothing. Not a single exhibit at the time they filed their opposition. There's some exhibits that have been lately provided, including some exhibits just a few minutes ago that they're now adding to their exhibit list and to their opposition. But in point of fact, at the time they filed their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general, the only thing that they had attendant to their opposition was this joint affidavit that doesn't address any of the defense allegations at all. Contrast that with the defense motion, which was supported by nearly 20 fact exhibits. There may be a reason why they didn't support their positions with exhibits at the time. It's because the facts don't support the Commonwealth's position. These are indefensible and indisputable facts that I'm explaining to the court about the turning over of these Sallyport videos. Specifically turning to the Canton PD surveillance video. The opposition says, or reads, the Commonwealth provided the defense with a...
I just always like to read along. Where does it say it? What page
I don't have the page number.
Okay.
It's the point at which the Commonwealth indicates that they provided 90 photographs.
Okay.
Crime scene photographs in support of the vehicle in the Sallyport. That is a distraction. What they don't mention in their moving papers is that the date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when the vehicle was brought into the Sallyport. The only thing we would have would be the videos, the surveillance videos, all of which are somehow, some way defective and which were held in their possession in some instances for nearly 3 years before it was turned over to us. So it's the condition of the car at the time that it was brought into the Sallyport on January 29th at around 5:30 p.m. that matters. That's the only time that it matters. The other evidence referenced by the Commonwealth about a 5 a.m. ring video and Canton police cruiser at 8 a.m. and the independent observations of Dighton police officer Sergeant Barrows, they all corroborate the defendant's contention that the taillight was cracked and not shattered at the time it was brought in to the Sallyport. And we're still talking about the condition of the taillight, obviously, when it was brought into the Sallyport. The Commonwealth next mentions that Lieutenant O'Hara from the CERT team arrives at 32 Fairview Road at 4:56 p.m. They then go on to mention that he was preceded by another trooper at 4:54 p.m. and that the car got to the Sallyport at 5:30, suggesting, obviously, that the search began and taillight pieces were found before the car ever arrived. That would be interesting if it were true, but it's not true. It's a distortion of the truth. It doesn't matter when the CERT team actually arrived and drove up there and sat in their warm cars and waited for other team members. The last team member to arrive didn't arrive until 5:41, 11 minutes, long after the car had already been secured in the Sallyport, long after Trooper Michael Proctor had access to that passenger taillight. The first taillight piece was not seen or found or recovered until 5:45 p.m. after the vehicle's arrival at Canton PD. That was seen. We can see who's got access to the vehicle and who makes access to the vehicle in that inverted video. Once we turn it back around, it's very obvious. That's Michael Proctor milling about at the passenger taillight. These are important details to get right. The timing matters. The opposition claims that the defense theory is quote unquote evolving. They write that the defense quote struggles to establish how the condition of the defendant's broken taillight in Canton, in the Canton PD Sallyport is in fact exculpatory. How is that exculpatory? The condition of the taillight, that it was cracked and not shattered as it moved into the Sallyport. How do we struggle to describe that as exculpatory? Of course it's exculpatory. Of course having those videos withheld from us is prejudicial. There is no struggle. It's on the video, it's on the ring video that establishes that the right rear Lexus hit the back of the Chevy Traverse, cracking its taillight. The Commonwealth, pretty desperate to ignore that inconvenient fact or that inconvenient piece of video evidence, literally previously said in open court that the Lexus only got close to the Traverse, only to be completely impeached when everybody in the courtroom at trial saw that 5,000-pound Traverse jostle, its rear wheel jostle, under the impact of the SUV right at the right rear or the passenger side taillight. Now the Commonwealth, with no factual support, no factual underpinnings whatsoever, says, okay, hang on a second. It did hit it, but it didn't crack the taillight. So whose theory is evolving? Ours or the Commonwealth's? The defense has never wavered. We knew that Michael Proctor, from the very beginning of this case, had been lying about the time he first took possession of that SUV. He claimed that it was at 5:30. The court will recall this. We had litigation concerning this. He wrote it in at least 9 reports that we were able to count. 9 reports or affidavits. Those affidavits sworn under oath, and the Commonwealth repeated that time for nearly 2 years, even going so far as to argue to this court that the defense got it wrong, that we were wrong because we failed to calculate for daylight savings time. So the Commonwealth battled us, and this is something I think the court has to really weigh and balance, the following conduct. The Commonwealth battled us for nearly 2 years on the singular issue of the time that the SUV got to the Sally Port. They finally took their medicine at some point and had to admit to the false time and chalked it up to a Scrivener's error in 9 separate documents, memorialized 9 separate times, some of them under oath. And all the while they were battling us on the time that it got there, no, the defense is all wet, they're wrong, they just didn't account for daylight savings time. Oh, no, this was just a little mistake, it's not a big deal, it was a Scrivener's error. And the entire time they're making both of these claims, they had video in their possession that established unequivocally that that car was in Michael Proctor's possession at 5:30 and pulled into the Sally Port at 5:30. They knew the time. They knew that he had retrieved it at 4:12 in the afternoon and not gotten it to the Sally Port until 5:30. So the Commonwealth was well aware in 2022, the Commonwealth and their agents were well aware in 2022 that the SUV got to the Sally Port, and that was the centerpiece of the defense case. They knew that the videos would directly impeach the lead investigator on this case, and they say that we struggle to explain the exculpatory nature of this evidence. It's not our struggle to explain it, it's their struggle to acknowledge it. Of course that's exculpatory. It directly and unequivocally impeaches their lead investigator on one of the most important issues in the entire case. And that's only one aspect of the withheld videos that also is exculpatory. The other is the point at which it would show the condition of the taillight. In other words, when it's being pulled in to the Sally Port, would it show the condition of the taillight before Trooper Proctor had access to it in the Sally Port? That's what we've been seeking. The Commonwealth is well known from the beginning of this case that the defense has demanded all physical evidence be preserved. That is, this is not a game of Wordle. This is not something that's supposed to be parsed. All physical evidence be preserved. That's pretty straightforward. The Commonwealth shouldn't be in the business of withholding exculpatory evidence by playing some sort of a gotcha game with definitions of words. They knew what we meant. We don't actually know what the Commonwealth has, so we have to be as broad as we possibly can when asking for evidence to be preserved. So all physical evidence clearly includes the entirety of all the Sally Port videos. The Commonwealth parses words by saying, well, we never asked for the Commonwealth to preserve the CPD footage from the Sally Port because the Canton PD is not the crime scene. You asked for crime scene footage, and Canton PD is not the crime scene. Well, first, I think that's a disingenuous argument that plays right into that sort of gotcha that we've discussed. I think the Commonwealth is better than that. That's not what we should be doing in a trial for murder. And second, let's not forget that District Attorney Morrissey actually defended publicly Michael Proctor by explaining that when Michael Proctor said he responded to the crime scene, and of course we knew he didn't respond to 34 Fairview, D.A. Morrissey said, oh, he was talking about Canton PD, which is the crime scene. So they can't have it both ways. They write on page 4 of their opposition, quote, the trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department's Sally Port until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor, end quote. So they've taken the position, look, we personally did not know anything about that Sally Port video existing until we received the federal grand jury paperwork showing that Michael Proctor testified to it. First, the Commonwealth has to know that that is not the state of the law in Massachusetts. Massachusetts State Police and Canton Police Department are both arms of the prosecution actively involved in the investigation of this case. Not one, but two separate agencies not only knew of the existence of the footage, but the lead investigator actually admitted to a federal grand jury that he pulled the footage at the start of the case. He pulled it all. And then he said he reviewed it all because that's what the case agent does. The Commonwealth cannot absolve themselves of the egregious and very obviously intentional discovery violations by Michael Proctor, by the Massachusetts State Police, by the Canton Police Department, by saying, I personally didn't know about it. The cases are legion on that issue. Commonwealth versus Sleeper, 2002 case found at 435 Mass 581, and this is Hornbook law. Quote, a prosecutor's duty to disclose exculpatory information or exculpatory evidence extends to evidence in the possession of the police who participated in that investigation. And then Massachusetts Rule of Criminal Procedure 14A1A, the prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor, persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in this case. Michael Proctor worked out of the Norfolk DA's office, physical plant. There is no question that Michael Proctor and both agencies intentionally withheld that evidence. Let's talk about Michael Proctor's testimony before that grand jury. He was asked the following question. Are you aware whether there are any cameras in the garage or Sallyport where Karen Reed's SUV was parked? Answer, yes. Question, have you reviewed the footage of that garage? Answer, I saw one very grainy video and then another of Sergeant Buchanan and I arriving in the main entrance around 5:30 following the vehicle. Question, when did you watch the video from the Sallyport? Answer, I haven't reviewed it, sir, in quite some time.
So do you have those page numbers for me?
I can get them for you, Your Honor. I
Okay.
didn't cite them in my notes.
Yeah, if Ms. Little can get them for you before you finish,
Of
that
course.
would be helpful for my review.
I haven't reviewed it, sir, in quite some time, so I can't recall what's on there. Question, why did you review video of the Sallyport? Answer, we review every video we pull. We pull a lot of video. It's on the case officer to watch it. By his own admission, Your Honor, Michael Proctor recognized himself in a video along with Sergeant Buchanan. That was likely the video that ended up being inverted by where Michael Proctor was by the passenger side taillight. And that was before any taillight material was ever recovered at 34 Fairview. That is highly inculpatory of Michael Proctor. It is highly exculpatory of Karen Reed. Another point of fact, by his statement, Michael Proctor admitted that, quote, we pulled, end quote, the video. That video is on a 30-day overwrite. The Michael Proctor testimony in front of the federal grand jury is at page 79, lines 1 through 13.
Thank you. Thank you, Ms. Little.
Exhibit C is in Charlie.
Okay.
The video is on a 30-day overwrite, Your Honor. We all now know that. We didn't know that before just a few weeks ago. I don't expect that the Commonwealth knew that either. This is new to everybody, right? But you have to have pulled the video within the first 30 days to even be able to review it. We've been getting these videos in dribs and drabs for not months, but for years. Actually, it's been months. Hasn't been years. He further admitted that it shows the SUV arriving in the Sallyport at 5:30, which means he wrote those reports and signed those affidavits, the 9 that I was talking about earlier, with full knowledge that there existed a video that he had and had reviewed that proved he was lying. It doesn't get any more exculpatory than that. And that was the video, that was the very video that was withheld from us, from the defense, for 2.5 years until the middle of trial. The Commonwealth says the, quote, trial prosecutor, end quote, was not aware. It's becoming a relatively common refrain in the opposition. That's neither a defense nor a justification for blatant and egregious discovery violations by the Commonwealth and its agents. The fact that the trial prosecutor, whoever that is, it's an interesting use of a name, of a pronoun. I don't know who the trial prosecutor is, but apparently the trial prosecutor, according to the Commonwealth, didn't know anything about this. But that's not a defense. Who is the trial prosecutor? Is it Adam Lally? Is it Laura McLaughlin? Is it both of them? And why are they only referring to one trial prosecutor when there were clearly two in the courtroom? They make the statement with no factual support for that anywhere. Again, the only affidavit that was supplied was a type of affidavit I've never seen before, where it's signed under oath by 3 different people. So which sentence goes with which person under oath? The single declaration is odd, to say the least, but it certainly doesn't define who's responsible for what statement in that declaration. We certainly know that it was not Hank Brennan. He was not involved in the first trial, so it can't be him. The Commonwealth writes, quote, the prosecutor had not been alerted to its existence by investigating officers, end quote, but claimed that on April 4th, they promptly presented the defendant with 9 surveillance videos in its possession. The Commonwealth received the federal materials.
Were those all from the Canton Police Station?
I'm sorry?
Were those all from the Canton Police Station, those 9 videos?
My understanding is those were from the Canton surveillance. They're talking about the Canton. I didn't go back and audit which 9 they're talking about because I thought we only received 8, but I believe they're all from the Canton.
Ms. Little, were they all from the Canton Police Department?
Yes, Your Honor.
Okay.
The prosecutor had not been alerted to its existence by investigating officers, but on April 4th, they promptly presented it to the defense. The Commonwealth actually received the materials that highlighted the fact that these existed in February of 2024, probably around February 21st, 2024, because that's when both sides got all the federal materials. That is not prompt. We presume that Mr. Lally has daily communications or had daily communications with Michael Proctor as the investigator, the lead investigator on the biggest case that the Commonwealth, this office of the Commonwealth has seen in a long time. And it took 2 months to produce an incomplete production of these videos. We didn't even get all of them at the time. The Commonwealth writes, quote, the quality of the video is poor in certain portions. However, this is the condition it was recorded in. Says who? That's a fact question, one that needs to be answered. And it's an important question. Who says that the Commonwealth received these, or I'm sorry, who says that this is the condition that those videos were recorded in? We've got no facts to support that whatsoever. And then the Commonwealth goes on and says, and that was the condition in which it was received by the prosecutor. That's also a fact question that needs to be answered. And these questions could be answered with a proper evidentiary hearing. The Commonwealth's representations about Louis Jutras, the technology director for Canton, being subject to cross-examination about the Canton PD video surveillance system is also just not true. They indicate, well, we had access to Louis Jutras and could have cross-examined him on all of these issues. Louis Jutras was called for a very specific reason, the town library video. We had no way of knowing at that time that he had any connection whatsoever with the Canton police video system. We were not told that until well after trial. That was never disclosed to us. And I think Mr. Brennan used this phrase not long ago, that would have been nice to know of Mr. Louis Jutras. The first time Louis Jutras was ever disclosed to as the person who installed the cameras at Canton PD was in a report dated October 10th, 2024. According to Colleen Crawford, and the court's heard her name as well, one of the Commonwealth's experts, Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between January 29, 2022, when the inverted video was actually taken, and July of 2024, because it was quote unquote defective. Interestingly, that's the only video that's clear. It's inverted, but at least it was clear. And that's the camera that, according to the Commonwealth, was replaced as defective. A week after filing its certificate of compliance, after the defense brought to the court's attention that 42 minutes was missing from the Sallyport video that we did receive, lo and behold, the Commonwealth produces a new video that also purports to show the passenger side taillight, except, as the court now knows, that's the one that was inverted. In the moving papers, in its opposition papers, the prosecution says, well, the prosecution had not previously received this video or knew of its existence. This is now the third or fourth time the Commonwealth sort of runs to this argument. I didn't know. We did not know about its existence. No matter how many times they write it, however, it does not change the Commonwealth's responsibilities. It doesn't change the prejudice that the defense suffered. We should have had these videos at the very beginning.
So, Mr. Jackson, I'm just going to ask you how much longer, this is the luncheon recess, but how much longer are you going to be?
Probably 45 minutes, I would say.
All right, so we'll break.
All right. All right. As I'm watching the fan, we took our break before I left you and then came back, and Alan Jackson went right into it. And let me tell you, he initially stepped into a hornet's nest, didn't he? Where he left off with Judge Cannone, not happy with him again, suggesting that because he filed a certification on February, I think it was the 21st, saying that Fanning had access to the jurors. That's the lieutenant for the state police. We're getting an eye into now what was in those redacted papers. Hi, by the way. Hi, Shy Gal. Hi. Let me see who's in the house here before I go on. Yes, Lisa was in the house. You still there? Hi, Loca. Hi, Matilda. Hi, everybody. Hi, Blessed Mom from Texas, staying with it. Hi, Jason Hodges. Yeah, but let me tell you. And she says, well, Mr. Yanetti, we get back to Mr. Yanetti, right? This Mr. Yanetti, he knows that this officer, that's not how we do it here. That's not how we do it in Massachusetts. And he said, wait a second. Lieutenant Fanning was supposedly the head of the whole security detail. He's the one who was involved in interviewing witnesses, and he's the one who made a report to the court officer, who made a report to the court, and then got a juror dismissed who the defense says they believe was friendly to Karen Reed, or would have been a good juror to Karen Reed, right? And so, but Judge Cannone tried to shut him down, saying, well, wait a second, you filed, but now you know that the court officers don't have access to the jurors. It's not Lieutenant Fanning from the state police who has access. And Alan Jackson said, I don't know that, Your Honor. Yes, I filed my certification on 2/21/25. Yes, I understand how Massachusetts did it, but this is not how. This is simply, how did he now, getting access to these jurors, make this report? How did he make this report? She was not having it. She kind of shut him down right there. And I have to tell you, I think that's a real issue, because what I think he wanted to say at that point was that we need a hearing. We need to have Lieutenant Fanning on the stand, a hearing from him to decide how this happened, right? How was it that there was this? And this is where the jury tampering came in. Remember, earlier today, we couldn't tell you what the jury tampering was, but now we're getting an access into things that obviously were redacted here, right? Then she says she wants him to move on. She's pressing him always for time, it seems, right? And he wants to know what's the basis of his motion here for misconduct. And Alan Jackson said it's the cumulative discovery violations that are cumulative, and they give us the prejudice that we're looking at. And she said, well, what are you saying is the prejudice? And he's saying it's cumulative. I want to go through my argument. I want to discuss what happened. So he starts with DGM Pietro. It's a new sergeant who retired 2 days after videos were handed over in trial of the Sallyport, and find out that he apparently is the one who downloaded videos to another drive, right? And and then Alan Jackson gets to it and says, why am I talking about these videos? He says, if you don't mind me going over all this, it happened. He said, the condition of the passenger taillight is of critical importance in this case, right? There was not a single piece of taillight recovered until after the car had been seized by the police and it was in their custody control, including Michael Proctor, who we know was the center of attention here. And now 12922 Canton Police Department has it. So he said not a single taillight was covered. And that's what I'm going to get to and all. And then he says that, we're getting all this stuff. We got in trial. We're getting in trial. I think Michael Bryant is joining us here, right? From outside the courthouse in a second. And then he goes on, and I'm highlighting that he said on May 20 during the trial, we get a video showing the exterior PD of the Sallyport and all. So clearly they had these videos. And then after the trial, we were getting more videos. And then he says in the exterior, it's very clear that either the video in the exterior, the inverted video that they have was either there was something either hidden from them or things were done because they didn't want you to see the back of the car and all the videos coming into the Sallyport. They didn't want you to see any of that. And how the judge says, well, how is all this exculpatory, Mr. Jackson, right? As he's trying to lay out the facts in order to support it. And he says that they all show that that the Commonwealth isn't upfront about the condition of the rear taillight. And then judge says, well, can you explain the prejudice in this? And Alan Jackson says, Your Honor, it's cumulative because the condition of that taillight is basically this case. It is this case for exculpatory material for the defense. And he says, all defective, everything is defective at the same time. All the videos that would help us, hi, Michael Bryant, that would help us, all of a sudden are either missing or defective at the same time. And he, just before lunch, he ended with the fact that amazingly, the one camera that gets replaced, right, is the one camera that gives him a fairly clear video of the car. That's the one that Proctor, the inverted video, and that's the one allegedly replaced because it's defective, not the other ones that either the video is missing or 45 minutes is missing or the videos are unclear or whatever. And right now, he says, and it's all clear also to us that right rear video, if we had gotten the Sallyport, would have showed it's cracked. And we know it's cracked as opposed to take it apart because the SUV hit the back of the Lexus hit the back of the Chevy Traverse, and we saw that. We saw that for our own eyes. Michael Bryant, I'm just going through all the things the judge had started to say here. We have a lot of people asking questions, but I know you were listening, and I haven't finished here, but do you want to finish up as to what she was doing? You want me to do it?
Just a couple of comments. You hear me? You got me all right?
Yes, we have
okay.
you.
Yeah, what a bunch of crap. I've never, I'm an officer of the court. I respect the court. I respect the process. But when I hear a judge ask such insane, idiotic questions, I just have to wonder what the hell's going on. And you mentioned them, the two key questions as Alan Jackson is beginning. And first of all, you're right. It was like, whoa, I just stepped on a rattlesnake here or something. What's our problem? And by the way, I've posted for members only at the moment, but we'll move it on to the arrivals where I was able to shout out a question to Mr. Jackson about whether the court would seriously consider his motion, and his response was this response you should see. Then I also happened to see Aiden's attorney, Mr. Is it Bettero?
Bettero, yes.
Bettero, and just asked him if he's in play now, and he just said, I can't talk about it. So anyway, she asked these two questions related to this video, right? First, right. The first and the most ridiculous was, well, how is that exculpatory?
Right.
I mean, we're talking about the damn passenger light on the rear of this vehicle and when and if it was damaged and by whom. Okay.
Right.
Can't imagine how learning about that could be exculpatory. Well, how is that prejudicial?
Right.
Are you kidding me? What,
Right.
I mean, did you miss evidence when you went to law school It is such fundamental, basic information. What is she doing except looking like an idiot, and a biased idiot at that?
Yeah,
I don't
because
get
I mean,
it. I just don't get it.
She's not even letting us through his argument. I mean, she's kind of like interrupting him on a constant basis, right? And he's going at. I mean, he's trying the best he can, but just to ask those two things, and then interrupts him. Well, do you have the page numbers in that? And he says, just in my notes. And then
and then they got Miss Little to scramble, to get that.
Yeah.
That's just tactical bullshit. There's no reason to be doing that, to be pressing like that, to be attempting to derail. Luckily, Alan Jackson's pretty good attorney, but try to derail the guy, during the course of his argument.
But
why doesn't the judge just say, this is going to be denied? So, go ahead, make your record. I'll be denying this motion, because that's how she comes off.
Well, even coming in with you signed your affidavit. Didn't you learn beforehand that Lieutenant Fanning is not in charge of the jury? And you signed this affidavit. And he said, no, I didn't know that when I signed my affidavit, first of all. And secondly, I still don't know that he had contact with the jury, because he's the one, it turns out, who now we're getting what's in the redaction, right? Basically, who reported whatever it is that he reported, that's still redacted, to the court officer, who then reported to the court, who got the jury removed. So whether or not you have a title of he goes in with the jurors, or he's responsible for all the courthouse security, he's the one we're alleging creates the juror misconduct. And she cut him off and said she wanted him to move on with this argument.
Yeah, and the punctuation was, I'm not satisfied.
Right. I'm not satisfied. Well, you got to have a hearing to get satisfied. You have to have testimony from Fanning.
To suggest that he lied in his affidavit, which is what she's doing,
which she did right off the bat,
based on him not having the information because the Commonwealth hasn't provided it timely, is just outrageous. Why would you do that?
Right. And then
the prejudice is just it's just too obvious. So then she moves on to the Sallyport video. And of course, which is the most important video, and that damn tail light, and when it was broken, and if it was broken, and how it was broken. That's the case. So to pretend that it's not important is it's moronic. I just don't understand.
And Blessed Mom from Texas, who's been with us now for a good month, thank you for the donation. I'm outraged, Michael. Thank you. Bev just showed big bias. This case should have been thrown out a year ago. I had to tell you, I think that her attitude between yesterday and then today is truly one that is coming through. I mean, we see it as defense attorneys a lot of time. We see attitude from judges, and we know they're not with us, and they're usually not with us for some reason. They believe that, as I always say, why don't you get off the bench and put the take your robes off and sit next to counsel table, and sit on some of the prosecution's counsel table, and one of these days it's going to get me held in contempt, I'm sure.
That's all right.
You'll bail me out.
It should happen. It should happen anyway throughout a career. Some of the folks here are so outraged. It's because of the nature of the assigning of the judgeships here. In some jurisdictions, different states, they're elected positions, but they're appointed here. So those who are upset about what they believe is happening say it goes all the way to the top because of the governor, the Morrissey, the Judge Cannone connection. That's the thought here. And when she has a day like we've seen so far today, how do you disagree with that?
This is and you see Alan Jackson's, even though we're pretty far away in the camera, it's not all sunburn. You can see that he's getting red because she's not letting him she's letting, go ahead. And at the very end, how long are you going to be? Okay. Lunch is coming up.
Yeah. But it's always qualified. I'm not rushing you.
Yeah.
I'm not rushing you, but how much time you got left,
Yeah. And then Alan Jackson.
So disingenuous.
All that, everything that could be exculpatory is defective at the exact moment that we need it not to be defective, right? And it's being late, and it's being given to us in dribs and drabs through trial, past trial, even up to just the other day. So, I mean, how could you not have this being against the Commonwealth being exculpatory? And it's, as you said, it's like the Epstein tapes, right? And all of a sudden the tape doesn't work. The lock doesn't
too many
work, the cameras don't
coincidences.
work.
My
gosh.
And again, Jackson distilled it to the key issue, the passenger taillight, right? There were no pieces of that taillight found at the scene until after Proctor took possession of the vehicle. And that period of possession is the big mystery. The 42 minutes missing from one video, the blurry version of another, the inverted video of another. All of those things look like you're trying to hide his access to the vehicle, which would explain what, if anything, created those 45 pieces of taillight that have since been scattered about the crime scene and recovered over a period of time.
Right, exactly. And Micah asked Linda, and Michael, is it an ethical duty for a judge not even to have the appearance of potential conflict of interest? Yeah, the judges are supposed to be free of a conflict of interest, but you know, no one's going to remove her because she's a big deal in Massachusetts. As I said, she just got head of the rules committee that changed the discovery rules. That actually would be more beneficial to Karen Reed, the discovery rules. It's just that for those of us looking on right now, there's something about the defense that has gotten her pissed off, in my opinion. Maybe we're not sure. Maybe she thinks that they're lying to them. But even her trial, her attitude of trial, there's something that's gotten her pissed off. Really, that's how I'm viewing it right now.
Yeah, you know what it sounds like. It makes it sound like the court's defensive. You know, like you're getting too close to finding out what's going on here, and that's not helping. You know, it's not helping my agenda. That's what it looks like. I don't know if it's true or not, but that's what it looks like.
Yeah, that's for brothers. Brooklyn, what was the jury in sidebar issue? I have no idea. And that's why, you know, sidebars are pretty.
The one thing we know about that one sidebar is the one that involved Fanning, right? Because there was that discussion about what was he a sergeant, lieutenant? I don't want to undervalue him.
Yeah.
Was he a lieutenant? I think
Lieutenant Fanning.
Anyway, he was apparently, you know, the more directly responsible person for the jury, but he has somebody above him, right, who's more in charge of the overall court process, and then that person reports to the court. So Jackson is saying, well, we only know what we heard about Fanning and about that juror that allegedly said something that got them kicked off the jury, but we don't know enough about his role. So it's easy for the court to just say, well, he didn't do anything. Well, you mind if we investigate that a little bit?
Or the prosecutor. He said the Commonwealth also said, but there's no factual background. We need a hearing. We don't know what that means.
And so that's been asked for a number of times. It's going to be asked for again here in the alternative in the motion to dismiss, because that's, of course, the goal is motion to dismiss with prejudice. But the backup plan is an evidentiary hearing on some of these issues.
Yeah. And Blessed Mom, Texas, 3 jury members were thrown off the jury. Defense had no idea why. I only know about the one. Were there 2 others that were thrown off? I know that the one they're talking about right now is the one that they're alleging the juror misconduct for. So, you know, that's the one we know. And then so she goes on, and Alan Jackson says, we know that Proctor lied. Hey, he took possession of the car, you know, and then he goes on and he says the Commonwealth has kind of been silent on the issue, you know, about certain things. But we know that the taillight wasn't safeguarded, and the Commonwealth just says, well, you know, you have it. But then we know that Proctor says that to the federal grand jury, he testifies. So this is where it's coming out, I guess, this testimony for the federal grand jury. This must have been stuff that was redacted, that he had pulled all of the tape, right? He pulled all the camera, all of it, and reviewed it, that it was Proctor. It's the Proctor factor. Proctor, who, by the way, just completed his second hearing date as to whether or not he's going to get nixed from the force. Proctor, who's been demoted. Proctor, who had those terrible emails to say. Proctor, who we know hates Alan Jackson. So he pulled it all and he reviewed it. Where did it go?
Well, there was an interesting note that the Sergeant Buchanan, I think that's how he pronounces his name. I pronounce it differently every time.
I pronounce it Buchanan, but I think Alan Jackson said Buchnick.
Yeah. Anyway, Sergeant B. So in May of 2024, and this is mid-trial, right? He says he was provided with a thumb drive with a Post-it note on it, right? And that he looked at what was on there, and it was not provided to the defense. Again, this is almost a year ago, 10 months ago. Was not provided to the defense until just this last recent wave of material.
Right.
How do you excuse that?
Right. How do you excuse that? And then Judge wants the page numbers, by the way. I was talking about, give me the page number of the grand jury reports where Proctor said we pulled it. Okay. Well, right. Hello. And then talking about that, Blessed Mom in Texas points out, oh, why is Fanning around a jury? He's the one who said Sandra wasn't murdered. I don't know if he's the one in jail. I thought it was another, I thought it was some other trooper there. Google that, Blessed Mom. I think it was another trooper who's now in jail and all. Shy Gal 8, isn't this tampering? This isn't tampering. Why on earth would Bev take a risk like that? I mean, well, you can't, what Jackson's saying, we need a hearing to discuss it, right? We need a hearing to know what it was. And she's not going to give them a hearing.
No, not a chance. No, not a chance. Anything that involves the first trial directly and not impacting the second trial, no, she's well past that.
Yeah.
Well past that.
Yeah. So interestingly enough, how is it that Proctor was the one who pulled the video and was in charge of it? And now we have videos here, we have videos there, we have videos.
Yeah, and it's funny about all those videos. The only one that is clear, and Jackson made this point, is the inverted video. All the others have either a 42-minute gap or they're so blurry they're almost useless. And a lot of those were disclosed only recently. What happened to them in the process? Did they degrade somehow? Were they ever in better condition? Were they doctored to make them virtually unusable? Yeah. All of those questions have to be construed against the prosecution.
I think they do. I mean, I think they do. And he made a point that the prosecution is not Mr. Lally. The prosecution is it's everybody. It's everybody involved in this. Just like, it's interesting to me that Judge Beverly Cannone doesn't ask, she asks the defense now, you're all responsible for everybody else. And Alan Jackson made a point of saying that, right?
Right, we all are. Like the defense, just like the prosecution is.
But what about the prosecution?
Of course.
They're responsible for the state police. They're responsible for the Canton Police Department. They're responsible for what the prosecutors say. That's what it's saying. But that never gets asked. It's like,
no.
And
it just, where the extent of outrage is so different for the defense actions versus the prosecution. And I'm not suggesting the defense has done everything squeaky clean, but the prosecution should be chastised just as much as the defense if you're going to go down that road, Judge. There's this one point that Jackson mentioned, and we were talking about it in the moving papers, where the prosecution said, hey, we gave 90 still photos to the defense. That was
right.
That was in response to the initial request, right? Well, Jackson clarified that, those were all photos taken from February 2nd, 2022. Not one from the date of the incident, 1/29/2022. So where are those pictures? I can give them some pictures, too, of my birthday party. Is that helpful? No. You need them to relate to the date. Yeah, maybe those will be interesting. But, yeah, they need to relate to the date the car was impounded and the condition of the car at that time, not 3 days later. And again, none of those photos showing the right rear tail light.
Joey Kane, a.k.a. Lumpy, a.k.a. Ed Eclair. Yeah, serial killer. Okay. Proctor find any nudes yet? That's what he was looking at, right? He was looking for.
He was investigating.
He was investigating. He wanted to see what if they had any pornography on their, on the job site. Yeah, but the problem is that. So the federal investigation will obviously Proctor testified in front of the federal grand jury, but apparently whatever this involved, the feds have closed the investigation, at least into the Canton Police Department. Now, I don't know what else is going to be closed. I mean, maybe everything gets closed right now under the new administration too. It's very possible.
Yeah, it's so hard to tell, especially with the Sandra Birchmore matter still very active. And from what I've learned, not much has gone on at the federal level. They've had some pretrial preparations, some status conferences, and I thought what I heard most recently was an April or May federal trial.
Wow.
In the Sandra Birchmore case. We'll see. There's a lot of things you can derail that and push it between now and the next month or so. And there was one other thing I thought was interesting. As a practicing attorney, you pick up on things that just sound out of whack. For practice. And Jackson mentions this affidavit that is signed by 3 people. How do you have an affidavit signed by 3 people? You usually have, here's my affidavit. I attest to this. I am so-and-so with this firm. I'm representing so-and-so. Right. And then you lay out whatever it is you have attached to the affidavit. You're securing you're giving sworn testimony about that material. So you sign it yourself.
Right.
How do you have an affidavit with sworn statements and then 3 people sign it?
Right.
Have you ever seen that before? I've never
No,
seen
I've
that.
never seen that. Usually it's a separate affidavit.
Well, it
if you
has to
sign.
be. But by nature, it has to be. Otherwise, how do you know who's swearing to which statement?
Yeah.
It's either horrible practice or it's something they allow them to get away with here. I'm not sure which.
So the judge did ask, and I did start this, who says the condition of the video was who's attesting to the condition of the video at the time the camera was disposed of? And so we need a factual hearing to determine why, because they're
Right.
saying that the camera in the Sally part, which is the only one that had the clearest video of
Right.
everything, that wasn't working. And that's why he said that's why we need a hearing as to why is the one that allegedly had the only video that at least had semblance of workability, visibility, why was that disposed? And so I don't. Again,
It was defective, Linda. It was defective.
I'm
So
sorry. And who
it
says
had
that?
to be
Yeah,
replaced. Yes.
yeah. Now this brings me to, if the prosecution by Hank Brennan, special prosecutor, says, well, it was defective, it has to be replaced, and that's what they put for the jury. He doesn't do any further investigation, but he gets, so that he doesn't have that duty that comes up under glossip if somebody gets up and testifies, improperly or testifies to a lie, because all he knows is that they told him that it was replaced because it was defective. And I guess so glossip means nothing. That whole idea that your prosecutor has to correct a lie, unless you have a hearing to find out why, how did it turn defective all of a sudden? And why did it 2 days after all these defective videos get given over, including the inverted Sally port, why did the trooper that supposedly downloaded to a detective drive, why did he retire, Sergeant DP?
Yeah, I mean, that's it's way too obvious to think it was purposeful because it's just too stupid. And it also doesn't take him out of the reach of, those who want to investigate and get him on the stand. It could still happen. The other thing they want to get involved on a hearing for these videos is there's a blanket statement by the Commonwealth that this video is how it was recorded and how we received it. Well, we don't know that. We know perhaps how you received it, if we could believe that, but we don't see a chain of recording to custody to delivery that would support that it is what it was actually recorded as. That's a big question. So, I mean, I can't imagine her ordering an evidentiary hearing on this at this point because she's so gung-ho to make April 1st the day that the jury begins to be impaneled. But it sure seems to me there are a ton of questions.
Well,
so what you do, let's talk about what you do with that if you're defending this case.
Well, before you do that, let me just say one thing. I would have grave concerns over that.
I would definitely have grave concerns.
Sorry, I didn't mean to interrupt you.
That's okay. So what, as a defense attorney, what you're going to do is you're going to the degree she will allow it, which this concerns me a little bit too. I don't know if they're grave concerns, but it's a concern that if you start going into this on cross-examination, that she's going to cut you off at the knees.
Right. I agree with you. I was going to ask you that question. Can she say, well, you can deal with this at trial? I think she's going to say no. She's going to say, because you don't have any evidence. It would be a fishing expedition. Hank Brennan, fishing expedition,
That's right. Yeah. Move on.
Move on.
Next question.
Yeah.
And so, I mean, obviously down the road, if there were to be any level of conviction here, the appellate issues are amazing. They're not little niggling things, which we see in a lot of appellate briefs. They're massive. These are big things. But, the defense going into the second trial doesn't want to really rely on that. They kind of like to get the acquittal they think they deserve, right?
Right. Exactly. Right. And these videos are important. And remember, I guess nothing that the prosecution says in the first trial gets used, but the witnesses' statements the transcripts can be used, because he's right. He said the prosecution said, "Oh, the defense keeps changing." The defense hasn't changed. I said, I've been watching this case,
and the Commonwealth keeps minimizing. Why are they so wrapped up in this right passenger tail light? Well, I guess if that was the shittiest piece of my case, I would be trying to poo-poo it as well, right?
Right.
I minimize it. What's the big deal? Why are they going nuts over it? Yeah, well, it's in the film biz, that's the MacGuffin. You know, it's the thing that's propelling this case from point A to point B.
Right. That you don't. It can be anything in any movie, but it's always some weird ass thing, right? Some hidden thing, some secret thing. And speaking about secret things, and Jackson points out, wait a second, the Commonwealth first said that the car, the Lexus, never hit the Chevy Traverse, and here's this ring camera of it not only hitting, you see the car move. It clearly hit it.
Yep.
Yeah.
I mean, some of the stuff is just so obvious that it boggles my mind that it would be presented in an attempt to suggest to the jury. I understand the zealous representation needed, but you know, if it's daylight, you got to admit it's daylight. You know, you deny something so obvious as a car bumping into another car, and the evidence makes it very clear. You just look desperate and not so bright.
Yeah. Oh, I wish we had a merch store to making a count, Ellen. Please make a grave concern shirt. It'll be the first line of purchase. Very interesting, because that has a lot of double entendre meanings to grave concerns.
Yes.
Yeah, especially when you're dealing with cases. That's actually a great idea. Miss Shorty, are you on here? Miss Shorty,
put that in our merch department.
She's already got her merch department on with Joe Tacopino and Mr. Flexback merchandise, which apparently Joe bought, by the way. I'll let you know some of her merchandise.
That's nice.
It. So unbelievable. I just thought the tone. It's clear to me that something has happened, that she doesn't. The tone of her trust of Alan Jackson is it's shall we say, in play.
Yeah, and I don't know if it comes from, like I said, kind of this feeling that the court's been caught, or that the court feels that the case it is supposedly even-handedly covering is now going a different way than the court expected or would like, or a loss of control somehow. But the interruptions and the attitude is it's concerning, Linda. It's concerning.
It's concerning. And the interruptions are because you have to be. I mean, let me tell you, you start off and you get handed the issue about, well, it's suggesting you lied on a certification to the court, and then she said something also. She said, well, I told you at sidebar. And Alan Jackson said, no, that was not. That's not.
She said, I have the transcript.
She said, that's
yeah.
right. I have the transcripts. I have the transcripts. And he said, but that's the issue is, he still did X, Y, and Z that could have affected the jury. I mean, I don't care what his title is. I don't care who he is. I don't care if the court let somebody from the street in to the jury. You have the issue of jury tampering. You have to look at it.
All we know is we need to know more. That's what we know.
That's what we know. We need to know more. And we're not going to know more. Although there was a question, is he available, right? Who did she ask that about?
Oh, yeah, that was about the retired guy.
That was about the retired guy.
Sergeant D.
Sergeant D, DMPH.
And it was represented that he is. So, we'll see if that was just, a passing thought, or if she really intends to pursue some sort of evidentiary hearing in which he would be a pretty important witness.
Right. Or she's going to say, I'm giving permission for you to speak to him. You have to make him available for an interview, Commonwealth, to the defense.
Yeah, I mean, he's a retired guy, so, he can do what he wants, technically.
Yeah, no, these ethics opinions, though, that technically he's still represented.
Oh, you mean for past acts?
For ethics, so that he'd have to have some kind of lawyer with him, but I think
he should have independent counsel is what he should have.
Right, not only from
conflict counsel. Yeah,
conflict counsel. Right, exactly. That the state has to pay for. Quite frankly,
yeah. I would definitely be making that request if I were him.
Yeah. And Alan Jackson went on to say that all this has to do with timing. That it's very important here about the timing. That the car in the Sally Port at 5:30, right? And the first piece of evidence supposedly not found until 5:45 or something like that, right?
Right.
Yeah. Oh, Michael, you've had milk duds.
I didn't have any popcorn, but I did have the milk duds. So it was like watching a bad movie unfold in front of me. It really, I mean, I really could not believe it. Lisa Lou 7, thank you for reporting on this case. Well, we're happy to do it. It needs to be reported upon,
Right.
and from a perspective that, going in, we're just like on any case we cover. We're going in eyes wide open, and we'll tell you our honest thoughts about what's going right, what's going wrong, why it is, why it isn't, and what we hope will get you to the right conclusion, which we like to call justice served.
Yeah, we like to call that. Yeah, someone's concerned about Michael. Are you Oasis cat? Thank you. Eating more than milk does. It's kind of like we're on trial.
Lunch is always kind of sketchy, right? But I did have the amazing waterfall burger last night.
That's right. You did.
I think I'm still digesting that. It was a lot of hamburger.
I think Timmy's digesting the one that I bought here too. A dog walker mentioned that to me, and maybe I should.
That was your smash burger, right? Smash burger.
That was a smash burger, right? But apparently everyone was hungry as a result of us showing our hamburgers. But when you're on assignment like this, or you're in trial, your diet is for terrible.
It's horrible. Luckily, the adrenaline is usually up, and so it offsets the extra crappy calories that you're eating. That's what I've found anyway. It kind of balances out. In fact, I've lost weight on trials before, so
Right. And you've got another one Friday. You're like the trial man, boy. I tell you.
That one will not be anywhere near as weird and twisted as this one. Pretty straightforward stuff.
No. Can the judge rule out the Sallyport video because the defense's argument? Are they walking a thin line? That's interesting because they don't want the blurry. They don't want the
I think they want it all in. I think they want the jury to see this whole thing so the jury can connect the dots and be asking themselves, why did they get it late? Why is it so crappy looking? Why is it inverted? What are they hiding? No, I think you want that all. You want it all in there.
Yeah. What are they hiding? And that's what led to the whole conspiracy. Everyone thought that initially when Jackson was doing it, it'd be, well, what is he talking about? But I see if you live with this case, as we now have been living this case, how you can come to that conclusion. So I have a real question for you. The Proctor factor, as you have labeled him. Can the state try this case without calling him?
The answer is yes. Will it be as effective? Will it be successful? He is.
You want him called, right? You want him called.
Well, of course, because the guy is a Christmas present, in terms of cross-examination material. And Alan Jackson enjoyed every minute of it last time, and I'm sure he would love it again. But if you don't call him, and it's pointed out he's an integral part of the investigation, he was the lead investigator, and you're certainly going to make the jury aware of that, then they can wonder, why the hell is that guy not here? Why are we filling in blanks from other people if he was the lead investigator?
It seems
so there is no good outcome with Proctor factor.
Yeah, but it seems to me that he wouldn't if there was a federal investigation. He could have gotten immunity in a federal investigation, maybe from federal issues. But does he have, if he thinks he's done something wrong, does he have a Fifth Amendment right then not to testify in this case?
I think we'd have to. We know what he did and what he testified to. The question is, did they go beyond, bad taste, bad judgment to criminal, right? I'd have to look at that a little more closely. It doesn't jump out to me that anything he did was criminal, just inappropriate, unprofessional, the tweets, if we had some video of him taking a hammer to the rear tail light to get the pieces that came from it, now we got something.
Yeah. Like we've seen you do, like we've seen you do with it. That's how you broke our exemplar tail light.
Those things don't break easily.
No,
I used a hammer.
Right.
They're designed not to break easily.
You kept hitting it too. It wasn't like it was just.
And that's
one
a
hit.
very, a hammer is very concentrated force on a very small spot. If a car is backing up into a soft human body, I don't know. We had this conversation many times. It always boggled my mind. How hard would you have to hit that body with a car to shatter a taillight, assuming it was done that way, into 40 pieces? It blows my mind. I don't know how that would happen.
Yeah,
I didn't do great in physics, but I'm telling you, I don't see it happening.
Well, I'm sure the jurors are lay witnesses. They kind of know, they know.
It's common sense. It's just common sense.
Yeah, I mean, I've seen.
And there was no experts. We didn't have any experts on polycarbonate, polycarbonate fibers, and the force needed to break them. I didn't hear any of that.
No, that's interesting that you didn't have it, because that's what you think to go. Okay, what's the force needed to break the plastic in that light, right? What kind of force is it? I'm surprised that no one went there. Maybe they said you can't tell. I don't know. Who knows? But that's what if the judge does it? What if the judge did exclude the videos? That's not, the defense is not asking for that.
No, they're not. And for the reasons we've talked about. Of course they're not. They want it in. They want to be able to point out that what we did get was dribbed and drabbed and hidden and distorted and inverted. And why would they do that?
Oh, this is something, because Dr.
This came out of today.
Yeah, Aiden Kearney has a 2:00 hearing, I thought.
Oh, no, this is looks like a new one. And this Creed M is clearly from Europe or a different country. Why do I say that? Because the date they've listed is 3/18.
Yeah,
we would say here in the States, we would say 3/18. I haven't had a chance. I didn't see him arrive today. He may have still been in federal court when they finished up and came here, but he's supposed to be in court in about 20 minutes here.
Yeah, I know you want to pick your head of a turn. We got slapped with a new witness intimidation charge. Tell us some more, Creed. Micah says that Micah thought that ARC could testify as the amount of force to break the taillight.
Yeah, if they did, it was lost on me. I do know we got testimony based on the vehicle information.
Oh, here we go.
Oh, there he is right there. Speak of the devil, or speak of the turtle.
Speak of the turtle. So are you going to try to peek your head in at 2:00, see what happens?
Now, I'll tell from the back. Is that Bedero, I think?
Well, we lost you. You're going in and out when you turn around.
Bedero was. Oh my! Am I? You still got me? Am I back?
I have you now. Right, you're back. Right.
Am I back? Hello.
Okay. Yeah, we've got your front. And you're back. You're back. Your front is back. All right. Speaking of the turtle, but because he has a 2:00 hearing in that big. When are they supposed to come back now? I know. Missy said they're on lunch break.
I think 1:45 is what I heard.
Yeah.
A little shorter. Yeah.
So maybe when they go back arguing, you can try to peek your head in. Are the courtrooms close? I guess the courtrooms are pretty close.
Well, they're upstairs. Yeah.
Yeah.
I can take a peek in there and they'll either let me or not.
Or they'll either let you or not. Right. And all that's the large courtroom. So that should have allow a lot of members of the public. And that's the big courtroom that they go. Any indication of why they're keeping, Judge Cannone's keeping all of this in the small courtroom? Does she not want a lot of people in that courtroom? Does she like the small courtroom? To maybe minimize the crowds and to have control over this?
Certainly easier to control, and you can use that as an excuse because it is tiny and they can only handle so many. I think it's more telling that they don't have an overflow. That tells me they're trying to control the crowd, the spectacle. The courtroom is small because it's small. That's just the way it is. But you should have an overflow for a case that demands it, like this one.
Yeah. Now, interesting, we talked about how it seemed that Alan Jackson stepped into the Hordenses, or as you said, on a rattlesnake, here. One of the things, that motion with regard to whether or not the defense had violated discovery or whether it was Rule 14 or whether it was an ethical violation is still pending. Do you think that her attitude towards Alan Jackson today and her attitude towards the defense yesterday about what you say binds every single one of you indicates that she's holding on to this, but that perhaps after the trial she intends to do something?
I don't know. It could be result oriented, depending on how she sees this thing play out and the ultimate result. She could circle back to that. And today was very accusatory as well. You signed this affidavit, Mr. Jackson, saying that Fanning had control of or some sort of contact with the jury, and it led to jury misconduct. You attested to that. You didn't know that at the time. So she's basically telling him he's a liar.
Right off the bat. Right. I mean, I was like, whoa. And no, I didn't. We didn't know that. But Mr. Yanetti, who practices here, knows that. And therefore, you should have known that. Well, we need a hearing to know what Fanning did. He still did it, whether or not you say he had control or not.
No, we still don't know exactly what happened.
Shy Gal 8, how's the ground, Michael?
Well, right here it's cement, so it's hard as a rock.
Hard as a rock. Alert One Systems, can the defense file a writ of mandamus to force at least a different judge to oversee Bev's recusal? They won't. They won't unless this gets really bad. I mean, the argument to be made, though, is that all of this accusatory conduct in front of the cameras seems to indicate or lessen Karen Reed's, I would say, due process rights for a fair trial by suggesting that her defense team is not acting proper. I mean, that's really the argument, right? It's Karen Reed's argument more than anything.
Yeah. Oh, yeah. So it would have to rise to a level. It would have to rise to the Al Pacino level. You know that level.
You know about that?
I'm out of order. You're out of order. This whole court's out of order.
There he is. It's in my poster.
There it is. I don't think it's there yet. Could be, but it's not there yet.
Yeah. That was what movie was that? For those of us who didn't watch it.
I just heard. Did I just hear?
Yeah.
That's from Scent of a Woman. I believe, right? Was that the Hoo-Ah? Why do I keep forgetting the title of that film? I'm not sure why.
Dog Day Afternoon?
No. That would be Attica. And then I'll be pacing up and down the streets here yelling Attica. I know. I forget. I remember the judge was Walton, the actor Walton. Anyway, great film, great line. Hey, what I think I should do is hang up on you and see if I can wander in.
Yeah, absolutely. Okay. I'll handle this until we get back.
It should be back any minute, but I'll report. Bye.
Okay, we'll see you after. So Michael Bryant's going to report after. He's going to try to go into the courtrooms there, especially Turtle Boy, who's we did not know. I did not see, because I've been busy with you, that he had more charges for intimidation of witness, and the defense and Karen Reed can't get a hearing on whether or not there was some kind of jury tampering on what they have filed, which is, as Alan Jackson likes to say, full-throated. It was pretty all-encompassing. Kind of like what we used to call as an omnibus motion. Lisa Lou 7. Is there anything in writing as to the actual wording of the assertion of the federal investigation is over? It wouldn't be the first time Brennan misconstrued facts. I think that they mentioned yesterday something that there was some letter that came in to Brennan, and then he called Yanetti to tell him. I think that there was something, and I'm sure that's one of the reasons why they're talking about the Proctor, what Proctor testified to at the federal grand jury, able to talk about it today because of that. But we don't know what the scope of the federal investigation was. See, that's kept secret. Was the scope Proctor? Was the scope Canton? Was the scope the Canton Police Department and their actions in the Karen Reed trial? What actually was the question that was posed for the federal investigation, and what was the question that they answered? And in any event, given the new administration, as you read, that almost every federal investigation that involved the police department has been nixed and been ended. So they just unilaterally terminated that. So we don't know if it's terminated on the merits, because the letter came in after in January, at the end of January. So we don't know if that was terminated on the merits or was terminated just because of the new administration. So there's going to be a lot we don't know here. What we do know is that there is a memo or an email that we have not yet seen, where Proctor, State Trooper Proctor, expresses his absolute disdain, apparently, for Mr. Jackson, that we have not seen that, to add to the TV realm of this case going on. You just can't make this stuff. Now, Missy is monitoring the court feed and we'll probably see the fans, although who knows, they can go right into court. And Justice for All, by the way, is the movie. We should text that, Missy, if I get a chance, maybe I'll text that to Michael, that he keeps forgetting it. And Justice for All, Al Pacino and all. It's funny, I showed you the poster, David Mamet's Glengarry Glen Ross is opening in New York, and I'm going to go see the dress rehearsal on Saturday night with Kieran Culkin, who is taking the role that Al Pacino played when he was in the play. So it'll be interesting to see Kieran Culkin do that. One of the funniest acceptance speeches I think I've ever heard in an Oscars. In case any of you do other stuff besides crime, like watch the Oscars. I mean, I have friends that watch the Oscars for like the fashion. Some watch it for the movies and all. But it's. But I don't know. Do you any of you else know? We're just honed in on Karen Reed here, obviously, and I see everyone thanking Missy. Yes, Missy. Thank you, Missy. This is an interesting comment. I'm going to show this. Lisa Small. If Judge Cannone was smart, she dismissed the case. Pandora's box is opening for the world to see the corruption in Massachusetts. And I've said something to this effect that the jury, the reason why maybe this whole idea of corruption has taken hold is that you have jurors who live in this jurisdiction. They live there. You always have to remember, we don't. We see what's in this case. We see what we're allowed to see, basically, right? All right. But the jurors, they live there. They have a feeling of what's happening. They have day-to-day interaction with the people from the police department. They know some of the people from the police department. They may know of some of the people from the police department. They may have had good relationships, bad relationships, but when you get that jury in the box, they're not going to come with of like, okay, you and I come into this case, we see it, we call it as we see it because we didn't know anything about it. But they're going to all come in, yes, to give Karen Reed a fair trial. But the question that doesn't really get asked in their mind is really back in their mind, how do they, not how they feel about the Canton Police Department, back in their mind, how are they going to respond to how the receipt of the evidence, knowing what they know about living in Canton, which apparently from Michael's interview with some of the people that were there last night in the clerk's office waiting was pretty bad. And I think I told you we're going to try to get some of representatives of those people to do, it's not going to be a mock jury because it's not really a jury, but to have them on at nights when the trial starts to see how they took of the testimony during the day. Hopefully that we can get that done and people won't be camera shy. I don't think anyone in this case seems to be camera shy, right? By the way, did we find out what the new witness intimidation charge is for? Whoops, guess what? I think there may be something happening. No, it's just kind of it looked like there was a re-rack of the camera maybe in court TV, but not in the courtroom yet there. So we'll see. But anyone get any more information on what the new, Dr. Turboy, Aidan Kearney is supposed to have intimidated this time? Because certainly would like to talk about it. Let's see. Let me see if I see anything else here. Michael Bryant did post a number of signs, by the way. Also, I don't know if he had them for you and all. We should be getting, by the end of the day, we'll take everything that he posted in the members, hopefully, and maybe able to run it on the show tonight or tomorrow night when we do a show, because we are planning, poor Michael Bryant, after we finish our show tonight, he has to then drive another 3 hours back to Connecticut, right? And then go back. And then tomorrow night, we plan to do a show. And Friday night, we plan to do the answering all the questions that we found that you have that we didn't get to answer, especially on some of the days that we missed the questions. And I apologize. You're all so into this case, and these questions go back very quick and fast. And I think it's great that you're putting Q in front of your questions, and some of you are capitalizing. As I say, we know you're not shouting, so we can see them. Both Missy can see them, and it's hard, especially for Michael Bryant when he's out in the field, because he's not working off his computer to see the questions. I am anchoring, so I can see it. Literally, now I know what an anchoring position is versus a host position. I was kind of you kind of lolly the eye, ask a few questions. But here, as we sit here for Justice Served TV, and we do plan to grow with all of you who are growing with us. By the way, again, 234 of you hit that like button. Please, if you're watching and you haven't hit that like button, please hit that like button for Justice Served TV today. we're one of the few content creators, streamers, that is actually on the ground in Canton. I mean, Missy's coming. Missy actually had a little StreamYard glitch right there, trying to follow this court TV feed. And again, of course, the court is late. They have not started yet. They were supposed to start at 1:45, and they have not started yet at all. But injurious personalities, thank you for posting, and justice for all. But anyhow, so hit that like button. Again, we get into the algorithm, we get pushed out to other people that are looking at the Karen Read trial so that you can see our viewpoint. And you see our viewpoint here. We call it as we see it. Michael Bryant thinks that Alan Jackson had to fill an area about what he knew. There's the fans, by the way, and when he knew it in terms of the arc of people. And but we all think that the prosecution does not have a case with regard to these videos, that these videos are really, that's the case. I mean, that's the case. And then that leads to everything. And also, how do you prove murder when you can't prove you can't prove a manner of death, right? The prosecution cannot prove a manner of death here. The two state forensic pathologists said there's no evidence that an SUV hit John O'Keefe. And then the ARCA comes in and says, based on what they did for the feds, there's no evidence that the SUV ever hit John O'Keefe. If it didn't hit John O'Keefe, how do you prove a homicide here? How do you prove murder? How do you prove a vehicular manslaughter and all? And those were the two charges that supposedly the jury had found Karen Read not guilty of, that didn't get reported out in the first trial, leaving just the manslaughter. And what is that theory? Is that the theory that she scared him and he fell, or that she left him alone and he was drunk and he fell and hit his head? Is that the theory that we're going on? Because that's a pretty slim theory, if that's the theory that we're going on, to put somebody in jail for a long time. But I think that without that cause of death, how do you can't get there. And that's what maybe the defense didn't focus enough on that in the first trial. Maybe they didn't. Could he have hit his head on that rock hard surface, being drunk? Sure. I mean, yeah, we've seen it happen, right? You've been with people falling backwards, and then you read about them. They fall backwards, they hit their head, and they die of a subdural hematoma or a cracked skull causing injury to the brain, some brain damage or whatever. So, but without that, I mean, how do you show if the SUV, the prosecution can't prove without a reasonable doubt that the SUV hit John O'Keefe and caused the death? How do you convict Karen Read? I mean, to me, that's the seminal question in this case. That's the seminal question. Not that the taillight isn't important, because that can help answer the seminal question. But even if you don't have the videos of the taillight, even if you don't have that taillight, right now, all the experts for the state, and these weren't ones that were hired by the defense to come to the original conclusion. These were hired by government. None of them could find that the SUV caused the death of John O'Keefe. Even if the videos were thrown out and you never had the video of the car bumping, the Lexus bumping into transverse, or you never had the inverted video, you still have to prove that. And all the other stuff around it becomes a fluff, in my opinion. I don't know. Maybe I would try a more straightforward case. But again, I don't know all the facts. I'm not trying the case. I'm just here as a commentator for what I see, to give you my best opinion about what I see, as both having been a prosecutor and now a defense attorney. And since you all know the kind of cases I have tried, you know that I'm usually pretty good at my job. I also, at being a defense attorney, especially when it comes to forensic evidence, which I love, since you also know that when I was a prosecutor, I was actually assigned, they called it they didn't call it the crime scene unit then, they called it the evidence unit. And that's what I was assigned to. I was assigned as the only prosecutor to the evidence unit, and that's how I developed this love of forensics, because I was the only one in the office really doing it at the time. Funny war story. I feel like Bob Bianchi now. When it became time to buy a new evidence unit truck, the evidence people wanted the back door to go up so that you could pull up to a crime scene, put your lights, have your truck there, not affect anything, and you didn't need to have that gap in between that you may not want. And of course, the people in charge of the budget said, no, that adds another, whatever it was, $10,000 to the cost of the truck. We needed the back door to open up like a back door of of some SUVs that open like that instead of go up, right? But the evidence is that that's not good for us. That, you know, that destroys the lights, that we can go move to the one side, the lights can move to the other side. Well, guess who won? Guess who won, right? It was the people that control the budget won over what was good for the evidence unit. As I said, then that's what it was called, not the crime scene unit or crime scene response, or what TV shows have made it into what our everyday knowledge, right? Missy Mayhem, yes, YouTube, our hobby is quickly becoming our second job. I have to again thank all of my partners who I have to. When I check my emails during this, you know, and I see my partners are answering on a case that's mine, a big high-profile civil case, are answering everything that I should be doing because they know I'm on the air with you today. Unexpectedly, we've had these all-day streams, but we thank you for watching. And since you are watching, we are doing it. All right. And hopefully even more of you will come back and watch as soon as lunch is over. You know, you're chatting and your questions are always so insightful. They're always so amazing. And they always show you devote the time, not just the highlights, to watch a whole trial and listen about it. And we're the place you can talk about it. We're the place you can answer all your questions and talk among yourselves, right? We're it. If you just want to watch a trial stream, that's fine, but then you'll be alone. With us, you get to talk and have all of your questions answered. So please hit that like, subscribe, and share button here as we watch. The fan is not moving this time. It's just a dead fan. I'm not sure what I like more, just the fan on the ceiling or the dead fan. Anything moving? I know there was a little bit of a crash there. That's probably when we saw that Court TV reboot, Missy, by the way. When, you know, I don't know what they're using, but we did see that little bit of a crash. Luckily, it didn't affect because they haven't come back for trial. So we are still live on the air. We're still waiting for everything to happen, you know. This is going to take, I know the judge wants to be finished by 4, and I think she wanted to get through all the motions today. But this is going to take a while, it seems to me. If Alan Jackson has 45 minutes, which means an hour, 3, then they'll take the mid-afternoon break for the court reporter. Then there's going to be Hank Brennan, and then there'll be maybe some rebuttal. And we're already at 4 before we've done anything else, any other motions, unless she wants to keep people there to finish, okay? Unless she wants to keep people there to finish. I don't know. But we'll see. We'll see. Any other amazing questions that you had for me before this starts? Because I know this is going to be some hearing, right? There's going to be some afternoon. If this morning was pretty crazy with Karen Reed, but we'll see whether Alan Jackson, when he steps up to the plate, so to speak, this afternoon, steps back into that hornet's nest, or as Michael says, steps on the rattlesnake. But it's something has happened. Something has happened there that we may know about, we may assume about, but that the judge is just not happy. But I don't think that she should be showing that displeasure, in my opinion, when the client is there. It's just like judges should never show their displeasure about a lawyer in front of a jury. You know, you can take the lawyer to task all you want as soon as the jury leaves. Take the lawyer to task, but never, ever castigate a lawyer or show displeasure of the lawyer while the jury's there, because it affects the client. One of the teams I was on once had a judge apologize for that and instruct the jury that anything the judge that he said should not be taken against the attorneys. You know, basically admitting that he was wrong, and you know, we all enjoyed him for that. But yes, Missy Mayhem said Bev came in hot. Judge Cannone came in hot right out of the gate. She most certainly did. Absolutely. She really came in hot out of the gate. And the question is, why in the last 3 days? It started with this, I have grave concerns, right? That's what we first saw. It started with this. I have grave concerns. Lisa, Miss Shorty is still here and listening. I don't know. We told you to promote your channel, Lisa. We were saying there was somebody had another great idea for a shirt. Grave concerns, Lisa. Listening and driving. So for your merch store, because you have a merch store up and running, you could do this. Have put grave concerns on a shirt and sell it. You know. Your merch store is fabulous. And if you haven't seen Lisa's interview with our friend Joe Tacopina, she really cornered him for a long time. He gave her about twice as much time as he gave us, but it's okay. It's all right because we were the first ones to get the interview with him before he was committed, before he then committed himself to TMZ. So we love Joe Tacopina, as you know, and hopefully he loves us for our fair treatment. Remember, we started that case again. We didn't know anything about it. But Shorty says they're on it, right? Have a coffin on it. Well, I don't know. That gives it less than a double entendre if you have a coffin on it. But grave concerns. Yeah, it's really interesting. Miss Shorty wants to give a shout out to Matilda, who did a fantastic job on the website and the merch store. We're working on ours. We're working on ours slowly, but we're working on it. We'll get it because I know that we're going to have to. We wanted to have an episode when we hit 5,000 subscribers. We're way over that, and so maybe when we hit 6,000 subscribers to give away some of our cups. But we're getting there. Yes, your merch store is great. And Lisa actually does a whole episode of her show going through her merch store. And you're riveted. If you think you're riveted by watching Karen Reed, you'd be riveting by Lisa Shorty going through her merch store. It's like, oh yeah, look at that. Oh yeah, look at this. Look at this. It's pink and green. Oh yeah. Oh, I'm hearing sound. So that means we're about to go to court. There we go. Let's go.
All right, Mr. Jackson, go ahead and continue.
Thank you, Your Honor. When we left off before lunch, we were discussing the inverted video. In the moving papers, the prosecution indicates that, quote, the prosecutor had not previously received this video or knew of its existence. This is I don't know, it's the third or the fourth time that the Commonwealth sort of runs to this argument about not knowing personally about the existence of a particular video, but that it doesn't matter how many times they argue that point, it still doesn't change the fact that it prejudiced the defense by not having it, and one of their members, whoever that agent is of the Commonwealth, was lying about having it and not disclosing it. Somebody knew, and the question before the court is, who was it? Who did know? Perhaps it wasn't Mr. Lally, perhaps it wasn't Ms. McLaughlin. Was it Chief Rafferty? Certainly Proctor had it. He watched it. Who else knew about it? Members of the prosecution knew of the existence of this and other videos, and they hid them, and that's the galling issue. Then the Commonwealth writes that the defense altered, their word, the defense, quote, altered evidence to correct the image, as if we were altering something to deceive the court. When in point of fact, the Commonwealth well knows that that altered video was altered by them in some way, shape, form, or fashion. When it was played inverted. What we did is recorrect it to the proper orientation to confront Sergeant Buchanan with it. They indicate that they played the entirety of the video, of the corrected video, to somehow suggest that the Commonwealth, during this debacle, had clean hands. And that's just not true. Over the course of 2 days, the court will recall 2 days worth of testimony. Day one with Sergeant Buchanan under direct examination by Mr. Lally. Going into the next day, still under direct examination by Mr. Lally, they played that video completely inverted. They talked about it, they discussed it, they described it. Not once did Sergeant Buchanan or Mr. Lally inform the jurors or the court that the video was actually altered, that the video was actually backward. Not one hint to the court or the jury members. When the defense stood up and began questioning Sergeant Buchanan about that video, that was the first time that he admitted that it was inverted. He used the phrase mirror image, and that he knew that it was inverted. Amazingly, that was the same time that Sergeant Buchanan started having trouble with his memory about who was actually depicted in that video. The court will recall before I stood up on cross-examination, under direct examination by Mr. Lally, Sergeant Buchanan was very quick to point out that the individuals on that inverted video were himself and Michael Proctor. And they made the point that Michael Proctor never approached or had any access to or didn't manipulate in some way, shape, form, or fashion. This was the intimation by the Commonwealth, that passenger taillight. The Commonwealth has now conceded that that person was, in fact, Michael Proctor. It's notable that the Commonwealth went to great lengths to state that, quote, Trooper Proctor, and this is in their opposition, Trooper Proctor is standing feet away from the defendant's vehicle and never touched the right rear taillight, end quote. That's a statement made in their moving papers, specifically on a fact that is of great material importance to this case. The three of them signed, the three prosecutors signed an oath and a declaration, and the court just called the defense out on signing a declaration or an oath. And the court's intimation, at least, in its initial comments to me was, you may have said something that you don't have a factual foundation for. I think I have done my best to disabuse the court of that we were drawing from reasonable inferences. I wonder if the Commonwealth is going to get the same treatment for saying that Trooper Proctor was standing feet away from the defendant's vehicle and never touched the right rear taillight. That's a very bold statement for the Commonwealth to make, and it's also completely untrue. It's not supported by a single fact. It's not supported by a fact or evidence before the court. The problem with this unsupported motion, because it's unsupported and the declaration is signed by three different individuals, you can just sort of say whatever you want in the motion, and I guess get away with it. The video speaks for itself, Your Honor. It shows Michael Proctor walk behind the car directly to the position of the passenger taillight. He positions himself right on the other side of the camera view, not feet away. And it certainly does not show, and there's no evidence before the court, that he, quote, never touched it. As a matter of fact, we would submit.
Does it show that he does touch it?
Well, of course it doesn't show he touches it, Your Honor. He's on the other side of the car. That's not the point. The point is, a reasonable inference is he could have touched it. He was standing right there. Nobody forced him. Nobody was holding a gun to his head. He walked around the other side of the car and obviously was standing there for a reason. By himself, in a corner, out of the view of a camera, and then when the Commonwealth plays the video, it switched, and the intimation to the triers of fact was he never approached the right rear taillight, that passenger taillight. And all of that
and
was
you
untrue.
cleared that up.
Right. But that is the galling part of this entire thing. The court has asked me a couple of times, and I'm going to get to it a little bit more in detail, what the prejudice is. If that's not prejudice, I don't know what is. It's literally propounding false information to a trier of fact. That is not a small thing. Even after the trial was over, it was concluded, and the mistrial was declared, we're still getting videos that we can't get a straight answer about their source. Where did these videos come from in October? That surveillance feed is on a 30-day deletion loop. That's what we've been told. I said a few minutes ago this morning, I said the Commonwealth may not have known that it was on a 30-day loop. What I meant was actually the prosecutors sitting in this courtroom. The three, my brothers and sister, may not have known about that 30-day override. I don't know. I don't know what they knew or didn't know. I'm certainly not going to cast aspersions and put that on them. But someone from the Commonwealth darn sure knew that was on a 30-day loop or a 30-day override. So who's had those for all this time? How were they stored? Why wasn't that information revealed to our expert when we went all the way to Canton to try to download that DVR? Where's the original? Where are the copies? These are questions for which we need some facts. And the fact that those have been withheld from us is exactly the kind of bad act and bad faith that demands that the court presume prejudice in the case. A few minutes ago, the court asked me before lunch, what is the prejudice? There's plenty of actual prejudice, but I'll get to that in just a second when I speak a little bit about the law at the end of my comments. We don't need to prove actual prejudice because the law presumes prejudice against Ms. Reed because of the bad conduct on behalf of the Commonwealth. And yet again, when it comes to this same issue, the Commonwealth recites this now worn out sentence, the prosecutor was unaware of the existence of these videos, end quote. How many times are they going to try to excuse away a blatant discovery and or Brady violation with the sentence that the prosecutor was unaware? It just doesn't matter. And that brings us to the October 10 videos that we got in 2024. The Commonwealth claims that they received these videos on or about August 21st, 2024. They sort of vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this, quote, letter. And it actually wasn't a letter, it was more of an informal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them at the time. But she did write on that little pad, quote, that is how it records, LOL, no tampering, end quote. LOL, laugh out loud. So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations and
what was the
discovery
date?
violations.
10/10/24 you received that? Was that the date?
10/10/24. That's correct. By the way, the Commonwealth claimed in its opposition papers that, quote, the prosecutor requested that both Massachusetts State Police and Canton Police Department produce all relevant and material surveillance video, end quote. And that was sometime unidentified between April 17th, 2024 and April 24th, 2024. I laud them for that. Good. I'm glad they demanded finally, in the middle of trial, quote, all relevant and material surveillance video. So why didn't we get this from Canton PD until October 2024, well after trial? What was the delay? And why did we get another video in January of 2025? What was the delay? How could this be seen as anything other than intentional? We know now that Sergeant Buchanan, we know that Proctor, we know that Chief Rafferty, and now through another report, we know that this officer, DGM Petro, all had access to and knew about the videos. And then we have on top of that, in the middle of trial, I think it was Mr. Lally, it may have been Ms. McLaughlin, someone said, it's unclear from the opposition, that all relevant and material surveillance video be turned over immediately, and it still wasn't done. That is an intentional withholding of evidence. And then we get these new reports. What's probably most troubling is what's in the reports that we got on Friday, this past Friday. Additional reports from the Commonwealth in a report from Sergeant DGM Petro. He reveals the following. He writes this report on the 27th, which was last Thursday, and then we got the report on the 28th. He says that in February of 2022, and I'm paraphrasing, in February of 2022, Proctor requested Sallyport video of SUV inside Sallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested in February of 2022 Sallyport video of the SUV exterior footage that he downloaded it from somewhere and gave it to him. Assuming it was February of 2022, that would have been before the override, I presume. Because I think the math in my head is It's 28 days in February. If it's in February at all, it's within the 30 days from January 29th. So it has to have been. Then he writes that in June of 2023, Proctor requested Sallyport video again of the SUV exterior footage. Quote, this is from his report, "I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station," end quote. He goes on to say, quote, "Due to the large size of the files at that time, I had to break it down into 6-hour blocks for ease of exporting." This is the first we're hearing of any of this last Thursday. How is that? Sure. Ms. Lewis just handed me a clean copy of the DG and Petro report. I would like to have this marked and appended to our motion to dismiss if it's okay.
Sure. Did I get that attached to your motion to change the scheduling?
Yes.
You probably did.
So I've seen it.
Okay. May I approach?
Hold on. What, Ms. Little?
We'd still like to make it part of the record if that's
Sure.
all right, Your Honor.
I just wanted to know whether I needed a copy because I have a copy. I've seen it.
May I approach?
Yes.
Thank you. No, thank you.
So are we marking it? So we need it if we're marking it.
Oh, I'm sorry. My mistake.
Exhibit 1 so marked?
Okay. Go ahead, Mr. Jackson.
Thank you, Your Honor. The question is, how in June of 2023, now I'm going to go a little bit slow here just because it's linear. The argument is linear. In June of 2023, according to DG and Petro, he downloaded every single bit of video of that car while in the Sallyport or while at Canton PD in Sallyport. How is that possible? How could that be? As of February 28th or maybe March 1st, those videos are gone. So how could he have access to the whole thing? It's because someone at the Commonwealth downloaded the whole thing. They saved it. Or the only other explanation is that DVR was not at the time on a 30-day override. It's the only two explanations. Again, this is binary. So in April of 2024, as the court knows, we got additional video, and that's the inverted video. In the spring of 2024, while trial was being held, DG and Petro, quote, it says, quote, "I downloaded some video recordings that you and I believed may be needed to refute claims being made by the defense." The "you and I" is him to Chief Rafferty. That's who this report is to. And it includes footage of Higgins. So now we find out, for the first time, that Chief Rafferty and this sergeant had been talking and strategizing about how to defeat some defense arguments, presumably, by use of videos that had never been turned over. And the Commonwealth uses a phrase in its moving papers, I believe in this motion, about ambush. That is the definition of an ambush. So DG and Petro admits that he, Rafferty, and the Canton Police Department had Sallyport video that was material to the case. Remember, his quote was that "you and I believed may be needed to refute claims made by the defense." They were strategizing about how to defeat certain of our arguments, and they didn't turn it over. Specifically, he downloaded video and presumably gave it to Chief Rafferty. But then the interesting thing is Chief Rafferty held on to it. She never turned it over. Probably because they didn't help the prosecution. They showed Higgins engaged in conduct that is, at the very least, highly suspicious and clearly exculpatory because it impeaches his other testimony. It shows him on the phone when he testified that he didn't make calls in the middle of the night. There's no question that with this example, that is an intentional withholding of evidence. That is the legal definition of bad faith, and it's unconscionable to do that. Now put in context what we eventually did receive during the trial and then after. We received the inverted video that was falsely presented as the right passenger side of the vehicle, or the passenger rear side of the vehicle. Number two, we received several videos of Brian Higgins at Canton Police Department, clearly using his phone at approximately 1:35 or so a.m. And we received exterior footage that would ordinarily show the condition of the passenger taillight, which all happens to be corrupted, like every other video of the rear passenger side of that SUV. This is stunning. It's not like the Canton Police Department and the Massachusetts State Police were sort of blissfully incompetent or blissfully ignorant and unaware of the existence of these exculpatory videos. It's quite the opposite. Multiple officers, Proctor, Rafferty, Buchnick, O'Rourke, DG and Petro, these individuals, we believe, O'Rourke may not have known, but we know that the others did, and have now basically admitted it or been caught trying to hide it. They were all variously actively engaged with these videos. They were searched for, they were discussed, they downloaded them, they saved them, they copied them, they labeled them, they transported them, they reviewed them, and they strategized about them. These videos were top of mind for all of these folks. We know there were hours and hours and hours of footage that was so large it had to be broken down into 6-hour blocks. All of that was pulled. And none of this footage was disclosed to the defense before April of 2024. And most of the files that have been turned over so far have been turned over after the trial was over. We had no idea this footage existed, and to this day, it continues to be, the bulk of it continues to be withheld from the defense. And then we move to Sergeant Buchnick's actual report. As I indicated, he wrote a report last Friday as well, dated the 28th. Quote, in furtherance of the John O'Keefe Canton homicide investigation, sometime in early spring of 2022, I was made aware that a request had been made by Trooper Proctor and then fulfilled by Canton PD for surveillance video as it related to the arrival and storage of the Lexus SUV belonging to Karen Reed. This was the spring of 2022. He knew. At Trooper Proctor's request, I proceeded to Canton Police and picked up the digital media storage containing said video and transported it to the Canton, Norfolk District Attorney's Office and turned it over to Trooper Proctor. I did not review this video at this time.
What date did he do that? The same date?
He says at this time, but it's the sometime early spring of 2022. That's the best he can do in his report. Paragraph 2, in July of 2023, so this is a little more defined, I was once again made aware by Trooper Proctor that a request had been made to Canton PD for additional video and that it was ready to be picked up. Since the Canton Police Department is conveniently located on my route of travel to work, I stopped by and picked up the CD from the front desk of the police department, which was labeled Trooper Buchanan with a yellow Post-it note. I further added Canton PD 12922 and then the case number, which is, or their case number, 2022-112-33, to note to more accurately identify the item and transported it to our office, subsequently turning it over to Trooper Proctor. So there's a second CD, now in July of 2023. I did not review that video at that time. See the attached copy of the Post-it note. Final paragraph, in my preparation for trial in May of 2024, I was provided with a thumb drive and the CD labeled with a Post-it note on my desk. What's interesting is that the CD with the Post-it note on his desk may or may not have been the same CD that he transported in July of 23 because they seem to be labeled a little differently.
So I haven't seen this report. Does he say from whom he received that?
I'll finish reading it, but I don't believe he does. No. No, it's pretty vague. It's passive voice and it's pretty vague. I was provided a thumb drive and a CD labeled with a Post-it on my desk to review prior to testimony. So it does not say. At this time, I reviewed video made available to me, which included video footage of the Canton PD exterior Sallyport. Exterior Sallyport. This video was labeled with a Post-it note on a CD, and it contained a video of the interior of the Sallyport, which was grainy and had a camera vantage point from the front of the Sallyport. I also reviewed the Canton PD driveway footage. In review, I also viewed video of the back wall Sallyport camera vantage point. I had not seen this video prior to my May date review. I later learned that this video was provided in an inverted manner. After I reviewed all the provided video, the thumb drive and the CD were returned. It doesn't say to whom they were returned. Your Honor, if I could mark this report as well.
Sure. Do you have an extra copy for me?
I do. It does have one highlight on it. May I show it to Mr. Brennan?
Yes.
The two still marked?
So you do have an extra copy, Ms. Little?
I do not have an extra copy, Your Honor.
I thought Mr. Jackson just said he had an extra.
Oh, I'm sorry.
Yeah. Mr. Jackson, do you have an extra copy?
I think I might.
I've got it right here.
You have an extra copy? Is that one clean?
Not clean, but.
Hang on a second. No, that was the only copy that I've got.
May I approach, Your Honor?
This one has highlights on it. I apologize.
It's okay. Thank you. All right, go ahead.
Thank you, Your Honor. The court asked probably the most important question about this report, which is, who was it that supplied the video or the thumb drives or the CDs to Sergeant Buchanan? Who's at the center of all these Sallyport videos? Who does he say was requesting the Sallyport videos that he was acting as the courier for in other particulars? Every one of those answers is Michael Proctor. So who do we believe most reasonably would have supplied the information to Sergeant Buchanan to review? It stands to reason it could have been Trooper Proctor. Seems to be reasonable. But I don't know because Trooper Buchanan doesn't say, but that would be another question that would be open to answer if we had an evidentiary hearing. Michael Proctor was receiving the footage directly from DG and Petro, dating all the way back to February of 2022. He was the one receiving the footage directly from Buchanan, dating all the way back to the spring of 2022. Michael Proctor was receiving footage from both sources multiple times through the years. Proctor was the one who clearly had possession, custody, and control over the exculpatory footage. It was his, every bit of it. And now let's recall what he said at trial when asked about all this footage, because he was confronted about footage. And keep in mind, Your Honor, when I'm asking these questions, I know none of this. None of it. Michael Proctor lied during his testimony, but he knew that we couldn't impeach him. There was no way I could impeach him. I didn't have any of these videos to impeach him with, because we didn't have any of the evidence that had been secured concerning that Sallyport. Question. There's surveillance video from Canton Police Department's Sallyport garage that wasn't turned over, right? Answer. That video was discovered later on and then handed over. That video was discovered later on.
So where in the transcript is that?
I can get you the page and line number, Your Honor.
My guess is Ms. Little can get it pretty quickly.
I'm guessing she
I'll provide that to you
can.
in just a moment, Your Honor.
June 10th?
It was either June 10th or June 12th, but let me double check.
While she's looking for that, Your Honor, may I proceed?
Please go ahead, yep.
Okay. The only thing it's important to remember from a date standpoint, we'll get the date that he actually testified to this, but from a date standpoint, the only thing that had been handed over at the time that he testified to that was a single video with 42 minutes missing and a flatbed and the flatbed driveway footage outside the Sally Port that doesn't show much of anything. It's now been proven, that testimony, that video was discovered later on and then handed over, suggesting there was either only one video or all of it was discovered later and turned over. Both of the clauses in that sentence are a lie. The video wasn't discovered later. It was discovered in February, at the latest, February of 2022, just days after this incident. He asked for it, and he received it, according to Sergeant DJ Petro. And it wasn't turned over either. None of it. But at trial, we didn't have the truth. I couldn't impeach him with this. He made sure that all the footage was delivered directly to him, starting days after this incident. And he controlled it, he hid it, and then he lied about it. That is the definition of bad faith. That is the definition of withholding exculpatory evidence. That is a definition of suppressing Brady evidence. There is no other way to define this. He fooled us, and it's egregious. Is it possible, with all this sort of years-long flurry that we've just talked about surrounding these Sallyport videos, that the actual trial prosecutors were completely unaware of their existence until Proctor testified before the federal grand jury? Is that possible? I suppose it is. I want to give the prosecutors the benefit of the doubt. I do. Is it reasonable? That's another question. To believe that they just knew nothing about this. We know Proctor lied to us. Could he have lied to them? I suppose. But as the law mandates, Your Honor, it just doesn't matter. In the eyes of the law, Proctor is the prosecution, and the prosecution is Michael Proctor. And then we move to January 28th, 2025, this year. We're still getting additional videos at that time. This new camera angle, which is blurry and grainy and wobbly, it does, however, show the passenger side rear taillight as it's towed into or driven into the Sallyport garage. The footage is so grainy and so blurry, however, it's so corrupted that once again, the true condition of that taillight is completely obscured. At a certain point, it begins to defy logic. And the reason I wanted to talk about each one of these videos in turn is because it absolutely defies logic that all of this footage magically cuts out, blurs out, becomes grainy, becomes obscured at the precise time that the SUV is pulled in to the Sallyport. The question then becomes, what's been happening to these videos that have been in Michael Proctor's possession since that time, for the last 2.5, 3 years? And again, I've lost count how many times the Commonwealth makes the claim, quote, prosecutors have never seen this video, end quote. The entirety of the Commonwealth's defense on this issue is the indefensible, which is, it just wasn't me. Okay, fine, it may not have been you, but it was the Commonwealth, in quotation marks, capital. The Commonwealth then claims that, quote, after directing a review of all physical evidence and data files, after directing a review of all physical evidence and data files, this video was located within a paper case file of the investigators, end quote. I believe that Mr. Brennan, when he came on the case, he's the one who directed a review of all physical evidence and data files. I would have to guess. Again, I would applaud that. Should have happened years ago. What's most curious about this video, however, is that the prosecution now admits, quote, after inquiry it was learned that an investigator obtained this video from Canton Police Department in 2022. and it was placed in a physical case file, end quote. That's a direct quote from their opposition. They don't name who the investigator is. They don't indicate whose case file it was. They don't tell us where that case file had been, who had control over that case file, just a paper case file somewhere, mysteriously. Whether it was CPD or MSP, we don't know. Which investigator, we still don't know. What can we learn from this admission by the Commonwealth that investigators did in fact download the Canton PD videos in 2022 before they were overwritten? That's the only way these videos could exist. We've talked about that. And what we don't know is where the rest of them went, and why we don't have them, and why we didn't have them for the first trial. The Commonwealth basically concedes that it is in direct violation of its discovery obligations not to have turned over these videos that were in their possession. But it makes the claim that it doesn't matter because, quote, the poor quality of the video makes it difficult for either party to benefit from the video, end quote. In its opposition, it sounds like more of a desperate argument than anything else that these cumulative, that these egregious errors don't justify the court taking any action because they claim, quote, there's no evidence of bad faith. I would take issue with that. But the quote goes on, there's no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved by the poor video quality and inability to obtain a forensically extracted copy of the surveillance video. Equally aggrieved. First, in that sentence, the Commonwealth admits that the defense is aggrieved. They say they're equally aggrieved, however. Aggrieved means wronged or unfairly treated or suffered harm or injustice. Merriam-Webster defines aggrieved as suffering from an infringement or a denial of legal rights. You bet we're aggrieved. But the Commonwealth can't claim that they're aggrieved when they're the ones doing the aggrieving. It doesn't work that way. The Commonwealth concedes that there's irreparable harm. They acknowledge that the forensic videos were destroyed, or at least they claim now that they're destroyed. We can never obtain the information necessary to establish the validity of any of these videos or whether and by whom they may have been manipulated, if at all. The Commonwealth can't shift the blame because the videos have literally been in their possession the entire time. It was their actions and the actions of their agents that caused this irremediable harm. Your Honor, this is, as I said, this is the definition of bad faith, and this goes back to the court's original question this morning, which is, can you describe the prejudice that Ms. Reed has suffered? And I think we've done a pretty good job of describing that throughout this argument, but the definition of bad faith means we don't have to prove actual prejudice. Prejudice is presumed under the law. If we're to believe the declarations that were submitted by ADA Lally and ADA McLaughlin and ADA Brennan, then at the very least, there is no other conclusion but that Michael Proctor and other investigators intentionally secured these videos. They withheld the evidence from us, and they withheld the evidence from the prosecution team. Let's take them at their word. Even after being explicitly instructed to turn over that evidence, that is bad faith. And how many times do they have to say, we didn't know about this? It just doesn't matter. Like I said, let's take them at their word. It doesn't absolve the Commonwealth of its obligations, and it doesn't reduce the prejudice that the defense has suffered. This was a pattern engaged in by the Massachusetts State Police, by the Canton Police Department, over and over and over again. And now we know, through this new revelation, that it was intentional. The prejudice the defense has suffered is legally presumed, and it's also factually proven. And thus the only remedy is dismissal. When is dismissal warranted? And this is, I'd like to talk for just a couple of seconds about the legal standards. Where there is misconduct that's so egregious, deliberate, and intentional, prejudice is to be presumed. That means that the defense is not required to show Ms. Reed suffered any actual prejudice because dismissal is necessary to prevent the repetition of this type of misconduct. And that comes to us directly from Bridgman versus District Attorney for Suffolk District at 476 Mass 298. It's a 2017 case. even if the court does not, and this is secondary to that, even if the court does not presume the prejudice and find that these myriad violations were somehow inadvertent or a mistake, the result of some accident or negligence, this case still has to be dismissed under the second scenario and the second prong, because Ms. Reed has suffered actual prejudice by the Commonwealth's violations. We could not cross-examine these witnesses the way they should have been cross-examined at the first trial. The repeated and flagrant discovery violations were not an accident. I think we've established that at this point. They weren't a mistake. There were too many people looking at them, strategizing about them, to then say, I didn't realize their import. They were designed specifically, the fact that we weren't provided the evidence was designed specifically to obtain a strategic advantage over the defense and to get a conviction at all costs rather than to pursue the truth. There are obviously additional Brady violations and prejudices that Ms. Reed has suffered. I've detailed those in our moving papers. And I want to incorporate all of those arguments by reference here as well. But relating to the surveillance footage itself, there's no question that the Commonwealth intentionally withheld it, and they've been withholding it since January 29th, 2022. The Commonwealth can't really seriously claim, Your Honor, that 4 or 5 or however many different law enforcement officers were aware of and withheld the surveillance video or the surveillance footage, and who were supposedly specifically instructed by Adam Lally or his team back in April of 2024 to turn everything over, and it was just inadvertently withheld. This was intentional. And the Commonwealth then compounded those violations by Michael Proctor lying on the stand about his knowledge of the video footage and his turning it over to the defense. It was literally a fraud on the jury. And now, well after trial, the Commonwealth has been forced to admit that even more exculpatory evidence or surveillance evidence from January 2022 is in their possession, and it was also entirely withheld from the defense throughout this litigation and throughout their first trial. In addition to the presumptive prejudice, Your Honor, there has been actual prejudice. This was, some would say, a close case when it ended. The court recalls that. The jury was hung on some charge or charges, and the evidence suggests that they voted in her favor on others. The court needs to ask itself, what would the jury have done had they had all the evidence to which they were entitled, to which we were entitled? But they didn't. Every one of these videos was in some way compromised, even the videos that we did have. And the compromise always conveniently obscured the truth and obscured Ms. Reed's rights. This is an exculpatory fact that we should have been able to explore during the past 3 years, and certainly we should have been able to explore it at trial, but we did not have the videos. The Commonwealth did, though, and it's the cumulative effect of all these gross and repeated violations that undermines the Commonwealth's argument that this is just about a broken camera. It couldn't be further from the truth. We're to believe that all these cameras just spontaneously became defective at the exact same time. Like I said before, it defies logic. For the Commonwealth to have all this footage for a solid 3 years and hold it back from us the entire time, it makes one question what was going on with that evidence. And I have to say, in terms of lesser remedies, Your Honor, what's interesting is that the exclusion, obviously the exclusionary rule exists.
I understand that does not help the defense.
It doesn't help the defense. I appreciate the court finishing my thought on that. It's the opposite. The only remedy that can prevent this kind of repetition, this kind of misconduct, is dismissal. That's the only remedy available. And that's what the law, and that's what justice demands. As a final thought, if the court, even in the face of all this overwhelming evidence of gross misconduct, declines to dismiss this case at this time, we would urge the court to grant us an evidentiary hearing so that we can make an actual factual record of the myriad of issues brought up here. This will give the court a much better understanding of the facts supporting dismissal, and it'll perfect the record on these critical constitutional issues. And with that, I'll submit.
Okay, so thank you. I have a question for you. So go back to the podium, please, because you may need your notes. But Ms. Little, did you find the proctor testimony?
I did, Your Honor. It's June 12th, 2025, the reporter's transcript at 1-148. And that's from the copy of transcripts with sidebars, just for the court's reference, lines 8 through 12.
Great.
Thank you.
All right, I have a question, Mr. Jackson, just about, so you argued obviously the importance of the Lexus arriving at the Canton Police Department. You argued a distinction between a cracked taillight versus a shattered taillight.
Correct.
In your pleadings, and again, you just saw, I want specifics where I can find something. On page 28, you talked at the top line, cracked, not shattered, when it arrived at the conflicted CPD on January 29, 2022. If the taillight was largely intact and only cracked, rather than shattered and missing 47 pieces, as Dayton Police Officer Sergeant Barrows testified he observed earlier that day, after the Commonwealth claimed Ms. Reed had struck Mr. O'Keefe, the evidence would establish Ms. Reed's innocence and be case ending for the Commonwealth. The 47 pieces I'm having trouble finding. I just took a quick review of Sergeant Barrows' testimony yesterday upon being prepared for this. I didn't see it in there. Ms. Little, do you know where that 47 pieces is?
Yeah, the 47 pieces is not related to Sergeant Barrows' testimony.
Well, it sounds it from this, so I'm not to read it this way.
What Sergeant Barrows clearly testified to was that he observed a taillight that was cracked and not broken.
Okay, the 47 pieces, I read that to mean it was from Barrows' testimony.
No.
As Dayton Police, Barrows testified. All right, where do I find that 47 pieces?
The 47 pieces, I can get multiple transcript sites, but those were the photographs the Commonwealth presented at trial, that there were that many pieces found at the crime scene.
It's the number of pieces that were booked into evidence.
Okay.
Yeah.
Great. Yeah, if you have trial transcript of that, I don't need 47 points, but if there's something that summarizes it, because I took that to read as I see it reading.
No, Sergeant Barrows specifically testified about his observations of the taillight earlier that day.
Right.
It was uncontroverted that there were 47 pieces of taillight recovered at the
That's not clear to me the way this is written, so I'm glad I asked you. Okay. All right, so with that, now, Mr. Yanetti, I'm not going to hear from you now about the court officers not being in charge of the jury. I'm going to hear from Mr. Brennan, and then we'll get to you, and hopefully we'll have time. But Mr. Brennan, I have a question for you. As I started with a question for the defense, so I'd like you to explain to the court, please, what efforts the Commonwealth made to comply with the Rule 14 obligation regarding the Sallyport videos, and why the dribs and drabs of the way the discovery came in.
It may be most helpful if I give the court a history as I've learned it about the production of video in this case.
Okay.
And it will explain in context the production of video and will help create the foundation so the court can understand, and perhaps the defense can best understand.
All right, and just like I did with Mr. Jackson, if I need to, I'm going to interrupt you
Of course.
to clarify some of this. So know that that's what I'm focused on.
I understand clearly. In November of 2024, the defense asked me to see if I could provide a chain of custody regarding the production of video in this case. And so I agreed that I would do that and made best efforts to talk to as many witnesses as I could, review the discovery, and speak to the attorneys. Now, when I started sometime in late September, I had found the letter from Chief Rafferty with the production of video in August. The letter or note was dated in August. So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the Sallyport area. There was nothing about it that was particularly relevant to them. The defense theory did not make it clear to them that that was important. There was no motion filed by the defense.
At what point in time?
This is leading up to trial.
Okay.
At that point, there had been no request by the defense for video of the Sallyport area. What I learned is that Trooper Proctor had requested Sallyport video from the Canton Police Department. And the person who was the custodian of Canton police video who would download it from the DVR was Sergeant D.G.M. Petro. He made a request shortly after this event on January 29th, 2022. Sergeant D.G.M. Petro downloaded video from the front wall camera, which was later characterized as the blurry camera, and he left it at the front desk. Trooper Buchanan, at the direction of Trooper Proctor, picked up the video and he brought it to Trooper Proctor. Trooper Buchanan did not look at the video at that time. It was given to Trooper Proctor. Trooper Proctor did not provide it to the prosecutors. So Trooper Proctor was aware of the video. The prosecutors were not aware of the video. That video is the same video that Sergeant D.G.M. Petro says that he downloaded the video in 6-hour segments, and that contained the front wall blurry camera inside the Sally Port and camera in front of the police station. That remained with Trooper Proctor for some time. In June, around June of 2023, Trooper Proctor then made a second request from Sergeant D.G.M. Petro.
Even though we already had it?
For different cameras. He wanted cameras, camera angle of outside the Sallyport area, so when the tow truck dropped the car off, leading into the Sallyport, which is now characterized as the exterior Sallyport video. Again, Trooper Proctor asked Trooper Buchanan to go to the Canton Police Department and pick up a copy of the downloaded video. Trooper Buchanan went to the police department, picked up the CD at the front desk. That CD had a yellow sticky tab on it with Trooper Buchanan's name, and Trooper Buchanan wrote in the case file on that yellow sticky. He brought the CD to Trooper Proctor. Again, Trooper Proctor in June 2023 had a copy of the exterior Sallyport video, but did not provide it to the prosecutors. Both of those videos remained dormant. When Trooper Proctor was called to the federal grand jury, essentially he testified, was asked about video, and said that he reviewed video. Now, this was not evidence that the Commonwealth intended on introducing or had any specific interest in. There was no particular discovery request by the defense, and there was no order. But upon reading that grand jury testimony, ADA Lally reports that he then inquired about the video. This is
Inquired of whom?
Trooper Proctor.
Okay.
This is shortly before trial. ADA Lally was given a copy of one of two of those productions. He was given the copy of the front wall video, which also contained video of outside the front of the police station. That was quickly turned over after Attorney Lally received it on April 4th, 2022. So what we know at this point is Trooper Proctor has this original production on April 4th, 2022, shortly after January 29th, 2022. I'm sorry, it was provided April 4th, 2022.
2022 or later?
No.
It was later, right?
It was
Because
later.
the federal grand jury was later.
He provided it on the eve of trial, so it was April 4th, 2024. So we know this production on April 4th, 2024 was in the hands of Trooper Proctor shortly after January 29th, 2022. At this point, the prosecution team is still unaware of the June 23 production, which has Trooper Buchanan's name on it, which shows the exterior Sallyport. As trial began, there still was no specific order or request. The chief of police saw something about the trial, and let me rephrase. Prior to the trial, it's reported that Attorney Yanetti was discontent because the video of the front camera Sallyport was so grainy, intermittent, and not continuous. And that's an accurate description of that video. Chief Rafferty, in response to seeing Attorney Yanetti's concerns, then asked Sergeant D.G.M. Petro to see if there was another camera or to produce any other video from the Sally Port. Sergeant D.G.M. Petro then downloaded video from the DVR, which is the second camera that is inside the Sally Port, known as the inverted camera, or now characterized as the inverted camera. That was produced April 23rd, 2024, given to ADA Lally, then given to the defense. And so at that point, there are 3 video productions that exist. The first turned over to the defense April 4th, 2024, the second April 23rd, 2024, and the June 23 production of the exterior Sally Port has still not been turned over. It's in the possession of Trooper Proctor, and the prosecutors do not know about it. After the trial, one of the employees from Norfolk County, Colleen Crawford, went to the Sally Port and looked at the DVR system. And when she looked at it, she saw that video still existed on that system. Although there was a 30-day overwrite on that system, the system had a number of backup hard drives, and because of the backup hard drives, the video existed longer than 30 days. She wrote an extensive report that was turned over to the defense, and this is after trial. The report notes her investigation about all the different videos, and it summarizes everything that she saw in that July 2024 visit. As I mentioned earlier, in August, Chief Rafferty provided video of the hallways that included some video of Brian Higgins, and she accompanied a letter or a note. I learned that that video was copied during the trial, and it is noted in the sergeant's letter. The chief of police and the sergeant were downloading video, not in response to a motion to compel or produce, but rather because they had concerns about accusations that were being made about the department, and they were saving video, in their opinion, or from their perspective, to help defend against future false claims against them. They downloaded a number of videos that were then turned over in that August 2024 production. When I first learned of that August letter and note, I turned it over to the defense immediately. The issue came up regarding the DVR in November, and as we've litigated extensively, so I'll simply summarize it, I invited the defense to come to the Canton Police Department. Given the intermittent or spotty production of video, I thought it best they have an opportunity to look firsthand, although I didn't know if the video would exist, as I've said. And then when they came in December, I think it was December 12th, if my memory serves, and learned that there was no longer video stored because it had been overwritten, I then went to the Canton Police Department so that I could have a closer look at the video cameras to see if there was something missing. I toured the entire station, I learned about the videos, and then as a consequence, I spoke to the chief, other officers, and the sergeant unexpectedly. The sergeant told me that he would click and drag copies of video when he would download them from the DVR. Inevitably, we had the litigation about whether the defense was going to download in person or not. And then as I tried to finalize my investigation into the tapes and realizing there was no actual written chain of custody, I wanted best to memorialize it. I had been reviewing all files, data, hard files, but I had not been on the case long enough to review everything, so I asked that the parties of the Commonwealth look through all files, all databases, so that I could help facilitate my review. At that point, I was provided by Trooper Tully the June 2023 CD with Trooper Buchanan's name on it. That is the exterior Sallyport video. And within 24 hours, I provided that to the defense. I then asked both the sergeant and Trooper Tully and Trooper Buchanan to write reports. Since there was no chain of custody, I wanted best to give as much information as I could and document the history of the video. That, Your Honor, is a summary of everything that I had learned, the investigation, and the production of the videos.
Do you know which investigator's file it was found in?
Trooper Proctor's.
Okay.
Your Honor, I have 3 separate arguments. I will proceed with the videotape argument since we've lodged into it.
Sure.
Okay. Now, the defense has made a number of conclusions that there was somehow videotape that was tampered with. There's absolutely no evidence whatsoever, none. It's not even speculation. There's no evidence that any videotape was ever tampered with. They say it, but there's none. I have seen none. They have produced absolutely no evidence that any video was altered or tampered. The defense lodges the idea of bad faith, that there was some type of advantage in that this video was withheld from them on purpose, and again, that is a baseless claim. If the government was going to hide video from the defense, they never would have got it.
Are you sure?
Maybe they would have got something after I came in and looked. They would have not got this production in April 2024. They would not have gotten the production if the government was looking to hide anything. And so the idea of intentionally withholding or bad faith is just characterization by the defense. The words Brady have meaning. Now, first, Brady needs to be exculpatory, and that's going to be something I think I can demonstrate does not fit this case. And secondly, in order to compel the court to conclude there was some type of remedy that should be issued, they want the court to conclude, like they do, that there was some type of tampering or some type of destruction of evidence. There was none. There was none. Now, Trooper Proctor had this video from June 2023 in his file. And I think the best evidence that this was not intentional is if you review Trooper Proctor's trial testimony.
So do you have a volume? Is it at the same place that Ms. Little gave me?
Well, I have the same volume. They gave you a fragment of his testimony, which was about 3 sentences, but if you actually read a number of pages of his testimony that deals with this video, and it begins on page 133. What you will see, and I won't spend a half hour reading it, but what you will see is that Trooper Proctor was aware of the grainy video, which was the video that was provided right after January 29, 2022. He was unaware of the inverted video until it was produced right before trial or right during trial by the Canton police. And you can also see that he in no way was hiding the June 2023 video, because you can see the confusion between all the parties at trial. Attorney Jackson is asking Trooper Proctor about video, and Trooper Proctor is explaining there is a Sallyport video, and also there's an exterior video outside the Sallyport. And it is clear that Attorney Jackson does not have that June 23 exterior Sallyport video because he's very confused in the questioning of Trooper Proctor. And Trooper Proctor continually tries to explain that there is both the Sallyport and there's the exterior video. So clearly, Trooper Proctor was aware of the exterior Sallyport video, but it will be clear from the reading of his cross-examination that there was no intentional withholding. He should have, since it was in his possession, whether it was relevant to the government's case or not, he should have provided it to the prosecutor, and then it would have been properly provided. But it was his oversight. There was nothing intentional or advantageous about it, because he struggled to try to explain to Attorney Jackson. And so it's also notable that Attorney Lally never has an opportunity to ask more details about those. Well, he has the opportunity, but he doesn't ask more details about that misunderstanding because he's wholly unaware that it even exists. It's a confusing moment, but it clarifies that there's nothing intentional whatsoever about this course.
Can't handle the truth!
And so it's important that although the defense now suggests there's something exculpatory about it or something about it that's important, it is important to note that the defense never filed a motion for the production of the Canton Police Department video. It is not incumbent or assumed that the Commonwealth is going to obtain every video from every part of a town during an incident. It's not assumed that they will do that. The Commonwealth seeks evidence that they think is exculpatory, they seek evidence that they think is relevant and material, and when they receive it, they are supposed to provide it. There are many cases where video from a police department is never provided to the defendant unless they ask. Or many cases where it may be a video of the booking, but not the hallways, not the bathrooms, not the back parking lot. Put in context that the defense theory was an evolving theory throughout this case to this day. The defense theory was that it was some third-party culprit, unidentified, who committed this act that led to the death of John O'Keefe. In fact, if you see earlier interviews, the defense position publicly was, you know exactly who did it, intimating that there was a specific person. Now that recently has changed. If we see the recent interview 2 weeks ago on Fox 25, the quick answer was, we have no idea who did it. We don't have to know. And so this fluid position is not noticed to put the Commonwealth on notice. They're supposed to chase down every potential idea or creation that the defense has. It's important to look at the motion that has been presented to your honor on behalf of the defense where they claim that they moved to preserve video evidence. And when you look at that motion, the best it says is that they moved to compel physical evidence. That does not put the Commonwealth on notice of video evidence at the Canton Police Department.
Was this the Stoughton District Court motion?
It is.
Okay.
And I know that the Superior Court did not adopt it. However, I think the Commonwealth being on notice is the point. Even if it's in district court, I think it's the Commonwealth's responsibility.
I agree with that.
Okay. And so, Attorney Yanetti, and I've mentioned this before, was very prolific in his pretrial discovery motions, very meticulous. And when you look at his meticulousness, if there was a need or a desire for video, he certainly would have asked for it. He didn't. In fact, when you look at the perspective of Attorney Yanetti, you don't have to look much further than his characterizations of how he sees the difference between the crime scene and the Canton Police Department. I've attached, for your honor and for the defense, exhibit number 4, trial testimony of Trooper Nicholas Garino. And when he cross-examines Nicholas Garino, he is pretty clear that there is a difference between the Canton Police Department and the crime scene. He cites on page 75, but you'd agree with me, the Canton Police Department wasn't the crime scene, correct? And Trooper Garino says, I never said crime scene in my report, I wrote scene. And Mr. Attorney Yanetti iterates, okay, well, Canton Police Department was not the scene of any crime, was it? So the defense is hard-pressed now at this moment where they are trying to create prejudice that doesn't exist, to try to convert a motion that they filed with very specific intentions for physical evidence to now suggest that includes Canton Police Department because the Canton Police Department is somehow the crime scene. It doesn't convert. In argument, Attorney Jackson characterizes not only Trooper Proctor's testimony, and I encourage the court to look at that because when you read it in context, I think it clearly screams that Trooper Proctor is hiding nothing whatsoever. But if you look at Trooper Buchanan's testimony, on June 6, 2024, if you start at page 103, Attorney Jackson, and to paraphrase, I'm not quoting him verbatim, suggests that there's something about Trooper Buchanan that is lying about his position or about what he saw, or that Trooper Buchanan admittedly saw the inverted video. Not the case. Trooper Buchanan reported that he did not see the inverted video until after Canton produced it, because how would he see it before Canton produced it? And that was in his preparation in May. And he did not say that he sat down with ADA Lally and watched the inverted video. He was asked, were you shown any of the videos that you see in anticipation of your testimony? Now remember, there's not just Canton Police Department video at that point. There is video from Ring, Town Hall, a number of different places. And he said, not during the first meeting, I did review video during the second time. Question, okay. And that video that you did see the second time, was that the interior video of the Sallyport that we saw yesterday, correct? He says, Trooper Buchanan, I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meetings. That is what he put in his report about reviewing in May, not with ADA Lally. So I don't remember exactly what video Mr. Lally showed me. That wasn't the characterization that was provided in argument. This is very different. Question, but you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You've seen that one before. That's the inverted video. The answer, yes. I'm on page 104. And that was with Mr. Lally, correct? Trooper Buchanan, clearly. That is not correct because I do not recall when I saw that video or what video I saw with Mr. Lally. That sworn testimony is not only in stark contrast with the characterization that was offered by the defense, but it directly contradicts the conclusion they asked you to reach, that Trooper Buchanan watched this video with ADA Lally in preparation for trial. Therefore, it is a lie that the Canton Police Department provided the inverted video sometime earlier. That's sworn testimony. Now, again, trying to assert some type of relevance, the defense suggests there is something in the federal materials that would show relevance because Mr. Higgins said in the federal materials that he does not believe he made any phone calls. If you were to look at that testimony in the federal materials, you would see there was an enormous amount of conversation about the period in which he was sleeping. And there were dialed calls between him and Mr. Albert. And so you have to look at it in context rather than say it's an unequivocal denial and there's an aha moment. There is no aha moment. So,
do you have the grand jury cite? I think I might have got it from Ms. Little earlier, but the grand jury testimony of Brian Higgins, I have it. It's just easier if you have a cite to that.
I have a tab, but I don't, perhaps Attorney
I'm sure
McLaughlin
Ms.
does.
McLaughlin can get it
I'll
from.
provide it momentarily.
All right, thank you.
So what really arises from the subterfuge is that the defense did not ask for video. There was video provided when the prosecutors learned about it. There was video that was in the hands of Trooper Proctor that should have been provided to the prosecutor that wasn't. There was nothing done to alter or taint the video. There was nothing destructive about it. There was no tactical advantage. There was no benefit to the government. And clearly from Trooper Proctor's testimony, there was no effort whatsoever to hide it. It should have been managed better, no doubt. But there was nothing about it that was prejudicial. There was nothing about it that showed tampering or altering. And so ultimately, the import of the defense's argument is that this evidence, this information, is exculpatory. It's exculpatory because what they claim is that it would show that Miss Reed's taillight was cracked, not missing a piece. Now, first thing we look at is Nick Barros's testimony. And if you have an opportunity to look at his testimony on page 12, line 1, the defendant told you part of the story. I saw there was some damage to the rear taillight. To my best ability and recollection, that taillight was not completely damaged, it was cracked. But they forgot the next part. And there, pause, a piece missing, but not completely damaged. That's exactly how we see Miss Reed's car later on, after it is at Canton. The entire taillight is not missing. There is a piece missing. That piece, where the fractures of it are found at 34 Fairview, right near Mr. O'Keefe's body. The same parts of the taillight fragments that are found in the sleeve of his shirt. And so it's not simply cracked. Even the witness they tried to lean on, Mr. Barros, says more. And so if that taillight is not just cracked, if that taillight is missing, then there is nothing exculpatory whatsoever about the Canton video. It's a red herring. Because there can be no plant of fractured taillight if it's already gone before it gets to Canton. There can't be. And so when looking at the evidence, it is unequivocally clear that piece of the taillight is missing well before that car ever gets to Canton. And so we can quibble and we can dispute and we can go back and forth all day, but the best way is to just show you the evidence. And so when we look at the evidence, let's start first with the fact, the claim that the Sallyport videos were tampered with. Canton went back before January 29, 2022, and they took samples of the video to see if it was in the same condition, inverted for the back wall and fuzzy for the front wall. And we have those, and we've turned those over to the defense, and I just want Your Honor to see a small clip of that to show this condition, these conditions existed before this case was even a moment. So with the court's permission, I'm going to ask to put up exhibit number 2. Exhibit number 2 shows the inverted camera from January 1st, 2022. Now this is 28 days before Ms. Reed's Lexus hits the Sallyport area. Now you can see, if you stop that please, thank you very much, on that wall, on that garage wall, there's a 4, it is backwards. This Sallyport video was not doctored by Trooper Proctor. It wasn't altered by Trooper Buchanan. It was in existence well before Miss Reed's car showed up to that Sallyport. Similarly, front wall camera, could you please put on exhibit 3? Exhibit 3 is from January 28, 2022, a day before Miss Reed's vehicle makes it to the Sallyport. And you can see the quality. It wasn't distorted on purpose. It wasn't manipulation by the state police. This is the way the camera worked in Canton.
Are you sure?
And so the idea of tampering, we can claim it, we can assert it without fact, but we can prove it did not happen. Now, what we know is that missing taillight was not tampered with because it was gone hours before police even touched Miss Reed's vehicle. At 5:08 a.m., she left Meadows Road. That's John O'Keefe's home. And when she left at 5:08 a.m., that taillight part was already missing. If we look at exhibit 6, please. This is from the ring video of John O'Keefe's home. This evidence directly contradicts the idea that the Sallyport video is relevant to show break or planting of evidence. As Ms. Lee nudges into Mr. O'Keefe's car, she will pull forward and we'll stop the video in 2 spots so you can get a clear look of that rear tail light missing. Forward, please. Thank you. And then ahead one more. You can see the white light shine. Stop. You can see it clearly missing. You can't plant something that's already gone. And the reason why you see white, it is a red taillight cover, and when the red is missing or gone, as it is in this case, the white bulb still shines, and that's why it shines white. The defense position is also contradicted by the ARCA witnesses. If we look at Dr. Wolf's testimony, day 31 of trial, it's noted as Exhibit 10.
Are you sure?
Page 36. ADA Lally asks the good doctor, now doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th? He says, I'm not aware of that. And then if we move to page 124, line 1. Now, line 2. Now, as far as you're aware from your review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case? And Dr. Wolf says, at that speed, no. We provided notice of our own expert. And there's one thing, many things, but one critical thing the experts will all agree on. That nudging did not cause the damage to that taillight. The defense position is also contradicted by dash cam footage. Sadly, an officer went to the O'Keefe home to check on his niece and nephew on that tragic day. And when he did, he had a dash cam video further reinforcing that that taillight is missing well before that vehicle makes it to the Sallyport area. If we could play Exhibit 7, which is the dash cam footage showing Mr. O'Keefe's car in his driveway at 8:22 a.m. If you could close up from the court, please. If you compare the right side to the left side, although covered and impacted by snow, if you could more close up, please, you can see that taillight, just like the detective from Dighton said, just like the 508 ring video shows, is missing. Is missing. There's no plant. The defense's position is also contradicted by the Alarm.com video that we received pursuant to Rule 17. There are 2 videos, 8 and 9. If we could play Exhibit 8, please. This is the defendant's car arriving in Dighton in the driveway. The defendant on the passenger side, and you can see them walk to the back of the car near the right taillight and stop. And if the question is, what are they stopping for, we can play video 9. And this is when the car is being put on the tow truck before it makes it to Canton. And just like 508, in the driveway of Meadows, John O'Keefe's home, you will see that right taillight shine white, showing the missing taillight cover on 2 occasions. If you have an opportunity to stop the video at the important points, please do so.
Can you lower it?
We cannot.
Can you zoom in on it?
Your Honor, I would encourage the parties to look at it on the computer. The clarity is much better, and it's very clear, the white light missing video. I cannot see it clearly on the screen.
So will you give me a flash drive of all of these exhibits?
Oh, there we go.
Okay,
If you look at it on a small screen, see right there?
I do see it.
Yeah, and then you'll see it again. So the alarm.com video contradicts the defendant's position that there is anything exculpatory about these Sallyport videos. In fact, this whole idea of third party or plant doesn't come to town until 9 months after Ms. Reed is indicted. Perhaps the best evidence that contradicts the defense's position that there's any relevance to the Sallyport video, that there's any type of plant by anybody, is from the defendant herself. Ms. Reed spoke to Gretchen Voss on June 20th, 2023. And in that testimony, or in that interview, she said, when my car was seized, there was a few small pieces of taillight missing that I had picked out at John's at 5:45 before we drove over to Fairview. I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red plastic is missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway.
I can't see shit in there.
And so I say to the court, the production should have been sooner. It should have been cleaner. There should have been a log or an entry. The failure to provide was inadvertent. It was unfortunate. It shouldn't happen. But it's not Brady. It's not exculpatory. It's not intentional. It's not tampered with. It was inadvertent and inconsequential because the evidence is overwhelming that that light is missing before the car makes it to the foot of the Sallyport, so there can be no plant. That is my argument regarding the Rule 14 issue. I would like to have time to speak about the claim of jury tampering. I understand the temperament of the court. I'm not tone deaf. But it is a claim that was lodged that has collateral consequence. And I think it's important for me to be able to address it. May I?
Yes.
The claim of jury tampering is probably one of the most serious claims that one can make because it's not simply an attack on a case. It questions the fabric of our entire judicial system. If a good juror comes to court and believes there is no integrity in the court or in the judicial system, it is impossible for a fair-minded juror to even consider evidence because they do not trust the system to begin with. And if a government actor or a trooper or a police officer tampered with a jury, that would be one of the biggest, most abhorrent transgressions that could happen because of the collateral consequence of tampering with the jury. It would take away the community's belief in our system. On the other hand, if there is a claim of jury tampering and it's baseless and there is no evidence, it is not only a direct attack on the judicial system, it would seem to be an effort to try to undermine the authority of the system in court before a trial to impede the ability to have a fair trial. It is an extraordinary claim, and it's notable the defense motion to dismiss. It's not just a motion to dismiss, it's a motion to dismiss for extraordinary government misconduct. So when you make an extraordinary claim about jury tampering, there should be extraordinary evidence. There isn't even ordinary evidence. There is no evidence of jury tampering in this case. Now, I don't want to belabor this, but it's important because of the consequence of what happens when a claim like this is lodged. There is damage. And why I'd rather sit down, as I said before, a lie unchecked becomes the truth. And so, how does one propagate a claim of jury tampering when there's no evidence? Well, first you need to plant the seed of corruption. And all you have to do is whisper it and hope the poison goes out there and is resonating in the potential community. And so what happens in this case? The defense finds a willing partner who covets an opportunity to meet with the defendant. They find a time, like after the Super Bowl, so there's this national exposure, and they just seep the information. They just seep it into the public and let it resonate. There can be no retort. The government can't respond. No facts, no evidence. Just saturate the public. Now, it's important to see or hear or read what is said, because this really is the acorn that is being planted that cannot be rebutted. And it's not insignificant that this same information before this interview is being disseminated by Mr. Kenney. This idea that there was tampering by Lieutenant Fanning. Not a coincidence. And so during this interview that the defendant and the attorney have, the question's asked, I don't know why it's asked, but it's asked, there have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed. Really? And Mr. Jackson says, right. The question, is this a real concern that you have? Is this something that you were looking at, or have you just dismissed it as a rumor? Answer, I never just dismissed that as rumor. Something like that, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence that there was jury tampering? I don't have any specific evidence of it. And yet we have a motion filed 2 weeks later. Do I think there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed and who was dismissed very specifically? And then it continues on page 13 of the transcript. Question, one of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury? Not sure where these questions come from. Answer, right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was direct supervisor over the individuals that were testifying and over and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination in the presentation of our case. That person, that supervisor, we found out well into trial. As a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors. That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest. Question, is that standard in Massachusetts for just the DA's office to assign whoever they want to be sort of, supervisor of the jury? Yeah. Is it standard in Massachusetts? I hope not. Never seen that in my life. But if I had a nickel for every time I said I've never seen this type in my life as it pertains to the Massachusetts justice system, the criminal justice system, I'd have a lot of nickels.
So I didn't see that interview. I don't have the transcript. I'd like a copy of that transcript.
Your Honor, I understand. I may be mistaken. We produced all of the exhibits to the court, and you should have a transcript. If not, I will get it to you immediately.
Okay.
Okay. So after step one, finding a vehicle to plant the seed, and they did that very effectively, the next step is they have to identify a target. Who are they going to blame? Who's going to be the villain? In this case, a villain goes from anybody that gets in the way. It could be a soccer mom. It could be a police officer. It could be a good Samaritan. Anybody that crosses the path is a target. And now they decided they were going to identify Lieutenant Fanning. Lieutenant Fanning is one of the most conscientious, dedicated, admired state police officers in Massachusetts. After having his name attempted to be sullied all over social media, attacking his integrity and his name, I can dare say that Lieutenant Fanning is in a different position than many. His integrity is so reputable, none of that will break him or his reputation. But it happened. When you look at the motion filed by the defense in this case, and they found their target in Lieutenant Fanning, you look at this motion, page 15. It's important when they made this public pleading, getting back to my request for your honor the other day. You look at the bottom of page 15. It talks about Lieutenant Fanning and tries to align him or associate him with Trooper Proctor because Trooper Proctor's text message was on a chain that included Lieutenant Fanning. Lieutenant Fanning did not reprimand or otherwise correct his subordinate's disgusting and inappropriate behavior. As a result, he was investigated by the Office of Professional Integrity and Accountability for allegations of inappropriate correspondence between department members. True. But then they leave off the punchline. They put this in a public document. They try to smear him, degrade, demean, dehumanize. But what they leave out is that after this thorough investigation by the Office of Professional Accountability, where they took strong measures, very strong measures when they found something that they were not in agreement with, they concluded that these complaints were not sustained.
So we were all aware of that. I received verification of that through the Pleadings Council, was all aware of that. I just need the date. When was he cleared? When was that made public?
We'll have to provide that to you.
Was it prior to this? Was it prior to the motion being filed?
Yes, it was last year, last fall. I can provide the date right now.
Okay.
Trooper Lieutenant Fanning is not in a unique position.
If I may, Your Honor, sorry. It was July 17th, 2024.
He is similarly situated to the many first responders and witnesses in this case. And then, without any basis, the defense then distorts that Lieutenant Fanning was in charge of juror security. He had control of the jury, and he had access to the jury. Think about what those statements say to our community, who are going to pile in here in less than a month to try to give a fair trial to both sides. Think about what those words mean. After selecting their target and trying to dehumanize him and degrade him, they then try to create an illusion of this grandiose havoc that is running amok. Trying to get the community to think Trooper Fanning controlled, had access, and tampered with the jury. Think about that concept. Not only is it an attack on Lieutenant Fanning, it is an attack on the integrity of the trial court. I've walked a lot of hallways in the trial courts over the past 30 years. And the heartbeat of trial courts is the court officers who take their duty so seriously. They help, they assist, they guide, and they have solemn pledges. They are charged with the responsibility of the jury. To suggest this is to suggest that the hardworking men and women in our trial court system who come here every day for everybody else's benefit, it is to suggest that they would cede their authority to the state police and abscond from their duty and responsibility to protect that jury with no basis whatsoever. That is the concept that they are promoting in this motion.
It's been
the trial court personnel
84 years
are steadfast and dedicated. I've tried a lot of cases, and I think most of the lawyers in here have. It is without a doubt in Massachusetts that these dutiful men and women of the trial court protect and are sworn at the end of every case in jury instructions to protect the jury. And these trial court employees, especially here in Dedham, some of the finest, would never abscond that duty. And yet it is now in the public domain, this suggestion. The only way that you dispel innuendo, suggestiveness, unsupported claims, and the poison that can seep into the community, the only way you can stop that is with fact. So I'm going to list a few facts for the record. Fact: Lieutenant Fanning was not in charge of juror security. Fact: Lieutenant Fanning did not have control of the jury. Fact: Lieutenant Fanning did not access the jury. Fact: Lieutenant Fanning was part of a multi-agency cooperative effort to ensure the safety of the public and court participants, which required numerous local police officers and state police because of the bedlam that was created outside. Fact: Lieutenant Fanning never, ever, ever met with or interacted with any juror. Fact: at all times, Lieutenant Fanning worked from a remote location, jointly managing operations for the safety of the public. Never setting foot on this property when the jury was here. Never meeting a juror, never looking at a juror, never being seen by a juror. Fact: no evidence any trial court personnel ever ceded their obligations and duty and handed them off to Lieutenant Fanning. Fact: Lieutenant Fanning heard numerous rumors from various sources about a juror who expressed potential bias. Fact: Trooper Fanning never investigated, approached, or inquired. He heard the information and provided it to the trial court as is responsible, dutiful, and proper. And I'll repeat one more time, Lieutenant Fanning never, ever, ever interacted, controlled, or met with any juror. Your Honor, these claims in the motion to dismiss have a theme. Different issues, same theme, same pattern, same effort. Your Honor should dismiss it outright, and we should move to trial. Thank you. If I may, thank you.
We're going to address in reverse order some of the statements made by Mr. Brennan. And I want to talk first about this issue of juror interference, which is what we called it. These words matter. We've claimed that there's interference. He indicates that that would be an abhorrent transgression if there were interference with a juror or a jury. We agree. It would be an abhorrent transgression. The information that we have in front of us is not the information that Mr. Brennan just recited, which is interesting. I'll get to the facts that he very dramatically stated in just a second, because this is a fact-based inquiry, one that we asked for standing right over there at sidebar and didn't get. But Mr. Brennan, with no support to back it up, and I'm going to ask a couple of pointed questions about that, recites these facts after facts after facts that he claimed absolved the Commonwealth of any transgression as it pertains to the jurors. And when I say Commonwealth, I'm talking about the Massachusetts State Police. Very clearly, in a clever, almost too cute by half argument, Mr. Brennan talks about the good court officers that are populating this courtroom and this courthouse, about whom we have made no allegation, no claim, nothing. We have nothing but the highest respect and regard for the men and women who wear that uniform and perform these duties. None, zero. And he knows that. But in an effort to create an enemy where there isn't one. He acts like we've insulted the court officers, which we haven't. He also said that Lieutenant Fanning stood up here and gave basically a CD, a resume for him, and said, the greatest guy on the face of the earth. I don't know Lieutenant Fanning. I don't know if he knows Lieutenant Fanning. Not really the point. It's in the personality contest. He said that we identified somebody with an unassailable reputation. We identified him. We didn't identify anybody. We were standing up at sidebar, fat, dumb, and happy, not knowing what was going to happen when somebody else identified him. It wasn't us. And by the way, everything that we filed concerning this was under seal. We didn't disclose anything in any court document. It wasn't a public document, it was under seal. Mr. Brennan then states that he was also a subject, this person with this unassailed career, was the subject of an IA investigation for his conduct on this case. It's not even about something tangential. It's about his conduct on this case, his supervisory role as it pertains to Michael Proctor and his, and I'll repeat it, disgusting conduct as it relates to my client and his text messages, etc. When he was asked about those text messages, his claim was, I was on vacation and I didn't read them. And ultimately, the Massachusetts State Police investigation cleared the Massachusetts State Police officer. We've seen that happen before. The question, or questions, if I could, that surround this inquiry, and the reason that we included it in our motion to dismiss, is because it appears that Ms. Reed did not get a fair trial because of this juror's dismissal. How would the person who's unidentified, to this day, unidentified, how would this person know who the juror sitting in one of these seats was if she was at a private location? I won't mention the location. How would they know? How would they know to identify her? How would they know what she said? How would they know to record her illegally, potentially, if that happened? How would they know these things? How would they know that if she was a juror, that she was a juror on the Commonwealth versus Reed matter specifically? And how would this unidentified person know of all of the authority figures to go to Lieutenant Fanning, of all people, who is then described to us after the fact as the, quote, commander of the extensive security operations that this case has required. And I went through that with the court this morning, but I just want to reiterate it one more time. Of course it makes perfect sense that we would presume that if he's the commander, I don't think it gets much bigger than commander. If he's the commander of all security operations, he's the commander over operations that are attendant to the courts, the actual court's security, the personnel security, the party's security, to whatever degree that is necessitated, but maybe most importantly, the jurors' security. That is a reasonable next step to conclude, a reasonable inference from the facts that we were given. But we do know this. He was this same Fanning that was just randomly picked to go report this to, was also the person that was in Miss Reed's house seizing her phone just months before the trial. He's also the person that was interviewing witnesses or supervising the interviews of witnesses in this trial. He was also the person that was on the text messages between Proctor and his buddies at MSP talking about her and trying to find nudes. We know all of that existed. And yet, we were denied an opportunity, Your Honor, an important opportunity, to simply inquire before this juror was dismissed. That's all we asked. Let's get Lieutenant Fanning in here, let's find out what the source of this is, and let's figure out, is it even remotely true? Remember, the juror never said it was true. But lo and behold, minutes before I stood up to give my summation, that juror's removed. That's the problem. This isn't about court officers and besmirching court officers' reputations. That's not what this is about. This is about what happened at sidebar in the matter of minutes that denied Ms. Reed her constitutional right. There's a couple of other points that I just want to make. Mr. Brennan started his comments by talking about the Sally Port video and how unimportant it is. How unimportant that video is. I'm not going to go through all my points again. The court doesn't need to hear that. But I do want to make this point. He says it's not important. There was nothing to see here. We don't pull videos normally. Yeah, of course you don't pull Sally Port videos if you're investigating a bar fight. This was the purported murder weapon. This truck is the thing that the Commonwealth suggests was used to kill a cop. You think the video of it being pulled into the Sally Port might be of some evidentiary value? I don't know. Can't imagine why that would be important. Can't imagine why that might have some evidentiary materiality. But I do know this. I do know this much. There's one guy who thought it was important. The lead investigator. He pulled it all. All of it. He was super, super convinced it was important. And he's the guy that once pulled it, hid it from us for nearly 3 years. Mr. Brennan spent some time talking about the difference between cracked and missing. Interesting point. I'm not going to go through a bunch of videos and audios. The court has seen all the pictures and photographs that it needs to see, and the court has a very, very good memory. We've never, ever disputed that the light was cracked at 5:07 or so a.m. That's how it got cracked, is the point. It got cracked on that traverse. And a piece was missing. A piece was missing. Not according to me, according to another agency's sergeant, Barros, who said a piece was missing, but it wasn't completely damaged. Recall that when that light was completely reconstructed with the 46, 47 pieces that were purportedly found, well, they were found at or near 34 Fairview, and then they were reconstructed. Does the court recall what that reconstruction looked like? That taillight was put together almost in its entirety. Almost. Except a piece was still missing. There was a piece unaccounted for. There's a big difference between a crack and the condition of that taillight, which we've now seen, where literally the entire lens material is basically gone. There's a few shards left on some edges, but the entire lens is basically gone. So yeah, it's relevant. And it's exculpatory. The condition of that light when it pulled into the Sally Port driveway. And with regard to the inverted video, again, Mr. Brennan says there's nothing to see here. We've got inverted videos dating back days earlier. Then why, if that's such common knowledge, then why did Mr. Lally and Sergeant Buchnick, in front of a jury, present that video as a true and correct presentation of what that car looked like and where that car was? Mr. Lally actually asked the question. I don't have a page and site number, but I remember it because I was sitting here. He asked the question, did you see Mr. Proctor? It was something, I'm paraphrasing, something along the lines of, did either you or Trooper Proctor approached that right passenger taillight? And the answer was no. Because on the video that was being played, it looked like the right passenger taillight was the one closest to the jury. And of course, Cooper Proctor walked right around that and went over to the other taillight. Except when you reverse it, you realize that's the right taillight.
Is there a copy of the reverse, the one that you played? Is that in the exhibits for today's motion?
No. The one that's been corrected?
Yes. I'd like a copy of
I
that.
don't think I have. Sure. We can get that for the court immediately. Also, he played a video of the grainy video, showing, hey, look, some of these cameras are just grainy in other particulars as well, at other times and places. Maybe, or maybe not. What's interesting is the grainy video that we saw, if my memory serves me, and it's my memory, and it's being taxed at this point, but my memory is the chyron on that video, in other words, the running numbers, was at the bottom. Yet the video he just played is at the top. That's the exact same video. If it's apples and apples, oranges and oranges, why is that different? That's interesting. And with regard to Ms. Reed's actual statements in that interview that was played, or I'm sorry, it wasn't played, it was recited. She said, some of the red plastic is missing. Some of the red plastic is missing. In other words, a piece is missing. It's completely consistent with the condition of that taillight before it was at the Sally Port. With regard to the facts that were recited by Mr. Brennan at the very end, every one of those is unsubstantiated. How does he know all that information? Who has he been talking to? And why don't we know about it? If in furtherance of this motion, there was an interview done of Lieutenant Fanning that laid out all of this information about not having contact with jurors and not doing this and not doing that, but yes, doing this and that and the other thing, why is the first time I'm hearing about this when he stands up and tells us? That has been the pattern of this Commonwealth's presentation to this court and in front of the jury consistently. That is the punctuation mark at the end of the sentence. Why am I just now getting that? Why wasn't that appended to his motion? Was there a conversation Mr. Brennan had with Lieutenant Fanning that we need to know about? This is exactly why, Your Honor, exactly why. If this court is not inclined to dismiss this case, and it should, the maladies of the Brady concerning the Brady violations and the discovery violations are so manifold in this case. They cannot, it's
Alrighty then.
Referring to that comment that was a court comment. And so I intend on remedying that record. There was also a conversation after with court TV.
All right, so provide it to Mr. Yanetti. Mr. Yanetti, I'll give you an opportunity to respond once you get that. But go ahead, you can tell me what you want to tell me now.
Right now, it's out in the court of public opinion that I made this extrajudicial statement. I said specifically I did not. He contradicted me, and that's where we left it, and he said that he would produce the receipts. Now he's admitting he does not have the receipts. There was no court TV interview where I said anything of the sort. That was a Zoom hearing, excuse me, where I was arguing before Your Honor. I would just note, Your Honor, I don't think it makes sense that Mr. Brennan would have done this on purpose because it was so easily disprovable. It's troubling that he would make this damaging accusation without properly vetting it to see if it is true before he attacks opposing counsel. So that was disappointing to me. And I would just point out, and again, I only need 30 seconds, that
you can take your time, Mr. Yanetti. You're not going to be 45 minutes.
Right. I certainly will not be. This new false allegation comes after my colleague, Mr. Alessi, co-counsel, Mr. Alessi, on February 25th, detailed 9 or 10 false statements that Mr. Brennan has made to this court. And I want to make it clear, I don't need an apology from Mr. Brennan. I don't expect one. But I think perhaps he should apologize to the court. He said today, a lie unchecked becomes the truth. And I just would hope, Your Honor, that you hold Mr. Brennan to the same standard that you hold the defense team. And that's it.
I certainly do. So, Mr. Brennan, if you do not have a cite, then I need you to let us all know that as well.
I will. It's convenient to retort that there were 10 lies by the court that Mr. Alessi lined up. In fact, I looked at the transcripts. Some of his suggestions that I didn't read the paperwork properly were just wrong. I didn't try to shame him today. It was part of advocacy, and I accept that. There was a conversation, and if you remember, when I related Mr. Yanetti's remarks, it wasn't in relation to 3.6, it was in relation to the fact that they were using the federal investigation to create innuendo that could not be responded to. But I will provide...
For your request for the gag order? In support of your argument for the gag order?
In response to how they had used federal materials that were under seal that couldn't be rebutted to make suggestions. It directly relates to that point, not 3.6. But I will provide the videos. Mr. Yanetti is right that the exact statement that I used was from a court hearing, but then there were subsequent statements made. And so my regrets to Attorney Yanetti, but it wasn't in the fashion of a 3.6 violation. That wasn't the intention. It was to show how they've used these federal materials before the case was closed to their advantage.
All right. So if you have the site, I'll give you until tomorrow afternoon to find the court TV site.
Very well.
If you have it, supply it to all, Mr. Yanetti. So I'm ordering the Commonwealth, if they have that court TV site, to provide it to all of us. And if you don't, provide that as well. Provide that information.
Thank you.
Thank you. All right, that's it for today.
All right, support, please.
You are muted.
Well, there we are. Okay. Boy, that ended with some fireworks there, huh? That was Hank Brennan, who initially I was going to say I thought did a pretty good job today on behalf of the Commonwealth, until this last piece here, where apparently, hi, Shy Gal 8, hi, you all, I've been watching, apparently, and all the feeds were down. Michael Bryant actually was at the courthouse, and he was able to hear what was going on and all. but all the feeds were down. But apparently he accused him of making an extrajudicial statement in violation of the ethics rules, right, on a court TV interview, an extrajudicial statement that later Mr. Brennan, after Yanetti got up and said, absolutely wrong. This was a televised Zoom hearing that I was arguing a position on that probably was on court TV. And then Hank Brennan had to take that back. He had to walk it back and say, yes, he is right. He is right. The judge still wants to see the court TV interview in terms of the Zoom hearing when it was on. It's just like it'd be a hearing now. If you took a hearing, if you took something that occurred in court and you said that that it was stated, by the way, I think I'm inverted, okay? Come to think of it, look at that. I'm inverted. I've got an inverted video right now. But you said something on the court, right? And you would say it and argue that Mr. Yanetti said something, but then say it was extrajudicial and therefore it violated the ethics rules. That's exactly apparently what Brennan did. Now, I don't know if he was given the wrong information by people that are preparing this for him, but that's the second time now we've seen this happen. It happened first when Brennan accused the defense of not giving him the appropriate discovery in violation of ethics rules and Rule 14. That was what that whole hearing was, grave concerns, right? And it turns out that simply was not true. That documentation was given, but we had the whole poll over the defense team about how they were doing something improper that inured to the disastrous unbenefit of Karen Reed. And then we just had it done again. So the fact that that hearing ended on that, to me, and Yanetti obviously has a lot of, he has a lot of support around Massachusetts. So judges don't take lightly when you accuse that. Michael Bryant should be on soon. It was not Yamoto Michael Bryant, I was saying. It was Yanetti. He's talking about my typing to him, of course. All right. Yeah. Am I now back? No, wait a second. Am I inverted? Am I not inverted? I'm not inverted. Wait, I'm not inverted. I thought I was inverted for a second. Boy, I tell you, my eyes just, I thought I saw a flash. You know what it is? I'm watching two different feeds here. I have to watch myself on a different feed, and on the one I'm looking at, I've inverted my iPad. Okay. All right. Oh my gosh. No, I am not inverted. Thank you very much. My brain may have been inverted for a second because I'm watching over here. Oh, very good. Right, here's my right hand. Okay, put your right hand up, put your left hand up. Okay, here we go. Anyhow, so I don't know what you all thought, but I thought until then, I said, wow, because that tells me that perhaps maybe the first time that Mr. Brennan did that in front of Judge Bev that caused a whole grave concern in the hearing and this whole obviously distrust by her of Alan Jackson, that was not done in error, okay? Because now you have this. And that's pretty bad to accuse an attorney of an extrajudicial statement that was actually made in a court hearing. And because it's televised on, let's say, Justice Served TV or on a court TV, let's say maybe it was Julie Grant, Julie, our friend, who's our friend over on court TV, right? And Vinnie Politan, who's Michael's friend over on court TV. I mean, that's pretty bad. Pretty bad. Yeah, and I was thinking to myself, I had actually texted to Michael Bryant earlier. I said, well, I see why they brought Brennan in now, because when he was discussing the whole federal investigation and looking for the videos, it looks to me like they brought him in because they didn't want to have their office tainted in any way by the smell of being involved with possibly, I'm talking about the district attorney's office here, the smell possibly involved in maybe hiding these videos. So they brought Brennan in so that that office wouldn't be impacted, or perhaps they were witnesses in the federal investigation too. Perhaps Lowley was a witness and all. But I think there that may have, I don't know whether Hank Brennan maybe lost some credibility with the judge. I do think that Alan Jackson, and I'm going backwards here, when he got up on rebuttal, he said he would never, because Hank Brennan made it sound like the defense had castigated all the people that work for the court. And the one thing you don't want to do if you're trying a case in a courtroom is tee off the people working in the court. They work very hard. They're usually your friends. They try to be helpful. I know when I was in Boston, they were incredibly helpful. They were terrific and all. And he said, I wasn't casting aspersions on that. He said, and I wasn't the one who identified Lieutenant Fanning. Somebody had something in here that Lieutenant Fanning was also involved in calling the Sandra Birchmore case a suicide. I think I Googled that, and I think you're absolutely right, even though obviously maybe Hank Brennan doesn't know anything about that. But he got up and he kind of, and I don't know about you, but Alan Jackson, I thought, did a fabulous job. And he said, he wasn't even identified. He was identified by a third party there at sidebar, Your Honor. Now, did you all know that there was the juror was dismissed just before Alan Jackson's closing argument? Either I didn't know that, or I'd forgotten it, or I hadn't paid attention to it. And so what they asked for a hearing at that point on the issue of why the juror should be dismissed. And apparently it was somebody else, a third party who stood at sidebar. We'd have to go back and look at the tape to see who went to sidebar, right? In the first trial, all of you probably have it. You can back and look at it, and said it was a third party, and he didn't mention the name, but obviously the judge knew, who gave them the name of Lieutenant Fanning as being the one who reported to the court officer, who then reported it to the judge. And then the judge dismissed the juror moments before, and I did exclamations point. He said just a few minutes before my summation. And he said, that's why I wanted a hearing on it, because he also was involved. He said, I didn't bring this up. He said, you just brought it up. You, the prosecution, that Fanning was involved as part of the investigation, an IA investigation on Proctor, because he was a supervisor. And he said, and then Alan Jackson said, well, but it's no surprise that the Massachusetts State Police investigating themselves would say that he did nothing wrong. All right. You don't need a weatherman to know which way the wind blows on that. Okay. So there we have that. That was how Alan Jackson ended up his. We obviously lost some signal in there. Hopefully Michael Bryant can fill us in. But we lost some signal in there about what else Alan Jackson did in rebuttal there. But he also in rebuttal, and I know I'm jumping back and forth. Okay. He also in rebuttal said, the court, by the way, released today the Voss interview. That was the first time we're hearing it, had been the seal, that Hank Brennan had said that the Voss interview that Karen Reed gave, that she picked up some small pieces of light from the backlight because she had bumped into the car. She had bumped into the car at John O'Keefe's house and all. And Brennan made it seem like that was a death knell to the defense case. But Alan Jackson, no, he said that's exactly what we're saying. He's saying that it was cracked. Maybe if there was one piece missing, or what appeared to be one piece, but then there turns out to be 46 or 47 pieces. 46, I think he said, were logged in to. Was it 46 or 47 that were logged in? I don't know, Michael Bryant, where are you? I told you I'm getting text from him. He's on his way. He's trying to exit. That there were pieces logged in, and that's exactly supportive of what the defense was saying. That, yeah, she bumped into the car. She broke a little bit of a piece, but that the rest was it was cracked, and the whole light wasn't out. It wasn't, like when Michael Bryant took the hammer and kept hammering and hammering and hammering on our exemplar light. That Prince Lover is the first time hearing that. First time I'm hearing a lot of things here in this. Okay. Michael's trying to get the interviews, by the way, our Michael Bryant interviews of the lawyers evening, of the lawyers leaving. And he also did attend the Aiden hearing, by the way, this afternoon. He has some interesting thing to report here and all. But it's what can I say? Alan Jackson, that proves our case. That's exactly what proves our case. And he says, he says, what do you mean? We asked for all evidence that may be relevant to the investigation, right? No, we specifically didn't ask for the Sally Port videos and all, but you knew they were relevant and you had to know they were exculpatory. Why? Because Proctor downloaded them immediately. And then he asked for more. and you all were keeping them. And then 6 hours of there's one that's 6 hours and more 6 hours and more 6 hours. But yet we don't see like 24 hours of video. We see dribs and drabs that have been given out. So he said this was not just an investigation that somebody's booked for marijuana, right? Possession or something. This is an investigation that you have charged somebody with murder, and the weapon is the car, the vehicle, the SUV. This is that. So if you don't think we want any and all relevant physical evidence, you have, and that it wouldn't come to mind that it could be cameras, all right? When you got cameras, when you got Ring cameras, right? From O'Keefe's house, that wouldn't come to your mind. Of course, that wouldn't come to. Of course, that should come to your mind. Because I think what Alan Jackson's worried about is Judge Beverly Cannone is going to say, well, you didn't specifically ask for the Sally Port videos that you didn't know exist, by the way, because you weren't told they existed, by the way. And therefore, that wasn't in the request for discovery. So they gave you what they had the first time they have it, and therefore there's no discovery violation, no Rule 14 violation. That's what I think he's concerned she's going to say. That's probably what she is going to say. But I think that last thing by Hank Brennan kind of took away all the goodwill that maybe he had built up with her going against Miss David Yanetti. Alert One System that doubt her judicial immunity would protect if the allegation of her being involved in jury tampering were proven to be true. Well, you'd have to show that she was the one who unfortunately was actually doing the jury tampering. She has total immunity. I mean, there was a case that went up to the U.S. Supreme Court about a judge having total immunity on something on a crime, and it was the Supreme Court said no, absolute immunity here for a civil case. But dismissing a juror based on what a trooper came and alleged, and what Alan Jackson says, we asked for a hearing then. Well, who told this trooper? What if it was something Proctor had said, right? What if it was something Proctor had said to Fanning, right? That ended up getting the trooper dismissed. We want to know who was the source. We asked for a hearing right then, Your Honor, and you didn't give it to us. You didn't give it to us, okay? So why don't we go circle back now after lunch, because there were some interesting things after lunch. I mean, I got all wrapped up just as you did in the ending of this hearing, because whoa, what a way to end it, so let's go back to after lunch, where Alan Jackson did come back and start talking about some reports. And the judge didn't report the report of Buchanan. The judge asked to see it. She hadn't reviewed it yet. And what Alan Jackson basically was saying was, look, Proctor had all this. He was getting all this. He knew it was all important. Proctor. And it was going here and it was going there. And we also learned that at some time, some part of an USB from the chief of police of Canton, Rafferty, came with a note attached to it, though this will something like it'll quell any notion that there's been any type of impropriety. That the defense is alleging LOL, as if a murder case should have an LOL on it, unless it's between lawyers in the same team who need to sometimes blow off a little bit of steam. But he said he went back on, and he says, and then we have this notation that Buchanan was picking things up and picking this new report, and it doesn't say who he picked up the USB drives from. It doesn't say who he brought the USB drives back to, and also Alan Jackson went on that, and the judge and at the final one, Alan Jackson said, Judge, there is presumed fraud on the jury here. Presumed fraud on the jury. And we don't have to show it. We also have actual harm. We have actual prejudice, but we have presumed prejudice, and it's fraud on the jury because we didn't have this all this information that's now being dribbled to us now. And even in that, it's not being dribbled completely. And then, but I don't want exclusion. The judge said something that we talked about before lunch. I understand, Mr. Jackson, that exclusion does not do you any good. That exclusion is not what you need, and for the reason Dr. Bryant and I discussed, that they need these videos in. And I'm going to stop right now because that's when Brennan took over and made his arguments, kind of blaming the defense for not specifically asking for the Sally Port. then blaming the defense for allegedly blaming the court officers for jury tampering, and then talking about Yanetti making extrajudicial statements, which he got slapped beside the face for when Yanetti went back up and got up. But Michael Bryant, I just quickly went through Brennan. We were discussing it like, wow, I know you've been doing a lot of other things. So I'm going to turn the platform right now over to you to let you talk. And by the way, the movie was And Justice for All.
That's right. That is exactly right. It is the whole court's out of order. So yeah, a lot going on this afternoon between the case we're here for. Oh wait, the bad phone is ringing. I just want to make sure I can turn it off so I'm not.
It wasn't me. I have mine. I wasn't calling you this time. Uh-oh. You're losing your signal. That's not good. You're losing your signal. I may have to take this back over from you. Yeah, you're losing your signal. Okay. Michael Bryant has lost his signal. Okay. So let's go. Let me go back while he probably reboots. I don't know if he can hear me. Yeah, let me text him. Maybe he'll get it if I text him. Oh, are you back?
I can hear you now. We've definitely got some signal issues.
Yes, we have some signal issues. We lost you.
I'm back.
Well, you're not really back. You're not.
Signal issues here, and I don't know if that's.
Okay, let me text him. We have signal issues. You are not back. I think maybe you need to get the Elon Musk Starlink back up. Okay, so in the meantime, why don't we talk? The rest of us talk while he's understanding that we have signal issues. I think what he's working off right there, he still was working off the court Wi-Fi and not the Starlink. Okay. Yeah. Glitches. Well, obviously, they had a glitch from the courtroom in the actual streaming, right? So they had an absolute glitch in that courtroom from the streaming. So it must be a lot of it. And I'm sure everybody is on that Wi-Fi right now. And so the more people on that Wi-Fi, the more it's going to glitch and the more we have that issue. But Michael Bryant will be back, I am sure, because he did do a lot. So let's go into Brennan's testimony. I'll just sum it up. Brennan basically said, you didn't ask for it. I went and tried to get a review and investigate where all these things came from and when they came from. You didn't specifically ask for it. Therefore, it's you bad, defense. You bad. You didn't ask for it. Therefore, it can't be anything that we did wrong. And secondly, even if you did get it, it's not Brady material because it's not exculpatory because of Karen Reed's statement to Gretchen Voss. And by the way, here's a video of the car backing up, and therefore we see that the red is shining through, the white is shining through. So the tail light obviously had been broken when she hit John O'Keefe. That's what he's suggesting, that it was mostly broken then when she hit John O'Keefe. And therefore, anything that we didn't give you, it would not be exculpatory. He concludes that. And then and by the way, we learned, that he admitted that the camera system had backup, right? Those camera systems had backup longer than 30 days. What have we been hearing? And if I were the judge, I would be gravely concerned about this. We have been told that the reason why we don't have those videos is because there was no backup system, right? There was simply no backup system. And then we told last week that there's a detective drive, right? A detective drive. That's where all this stuff has been coming from as it dribs and drabs out. And then we learned, Hank Brennan says that, hey, wait a second, there's a hard drive backup that existed longer than 30 days. When did that come out? Just now? Just now? All right. So then he's got to go back to the fact that the reason why it can't be exculpatory then, because if all this existed and it wasn't turned over and Proctor had it and Proctor was garnering it and Proctor was somehow dribbling it out, dribs and drabs, he's got to go back to that it can't be exculpatory in order not to have this case dismissed, because that could be some pretty bad stuff. All right. And if I were the judge, I would be concerned about that. She may have said something. She was going to hold him to the same standard as the defense when the defense got up there, but she didn't say anything about the system had a backup longer than 30 days. What? Let me repeat that. The camera systems had a backup longer than 30 days. What? All right. When the defense sent their person out, they were told that it was overwritten over 30 days. What? Remember that? Didn't I just hear that? Didn't we just listen to that all this week? I mean, unless something wrong. But so there was a hard drive system, and indeed these videos were downloaded, and they were found. And the judge did ask a question. She said, "Where were they found?" She said, "They were found in Trooper Proctor's file." Wait a second. So the detective file is now Trooper Proctor's file that the USB videos were found. Of course, if they were dragged and dropped, then they weren't properly forensically preserved. That's why you have probably the videos being kind of, shall we say, not clear. But the police would know that you have to properly forensically preserve a video. I mean, you're talking about the Massachusetts State Police here. This is just not a group of people playing in the garage of kids, and actually kids playing in the garage. I shouldn't say that because they probably know more than we all do, and all. So that's kind of an interesting. To me, that was like I did a double take. I don't know about you, but I did a double take about that the videos were. That there was a complete backup, right? There was an absolutely complete backup on this. So that was one thing. And then, of course, his final argument was that Karen Reed has implicated herself with her statement in the interviewed aggression of loss, which the judge released today. She unsealed it. She unsealed for the first time so we can all see it. We can probably get a full copy of that exhibit now. She didn't unseal everything that was attached to the motion under seal. And as Alan Jackson pointed out, hey, Judge, we filed everything under seal. If it's being revealed here, it's being revealed because Hank Brennan has just revealed it, not because we have revealed it. We filed things under seal. And so then, but the judge did release the boss that Brennan could rely on. So that was basically what I got from the hearing. And could the judge just say, you didn't ask for it? Yes. Could the judge just say, it's not exculpatory? Yes. Could the judge just say, well, you have bits and pieces of it and you have enough to show it's exculpatory by the inverted video? Yes. Oh, and that was another thing. What Hank Brennan did, he showed two videos, one 30 days before, one I think a day before, of the Sally Port to show that it was inverting other videos and not just the one in Karen Reed's case. However, there's a big difference. You ask, what is that difference? The difference is that Buchanan, depending, it was pronounced both different ways today by the attorneys. Buchanan got on the stand and was on the stand for a full day under direct examination and then started to be under cross-examination and never told anybody the video was inverted. When he asked, was this a true depiction of what happened? Yes, it was. Any indication that Proctor had ever gone near that right rear headlight? Absolutely none. The video shows that no one touched that right rear headlight. And then it turns out, wouldn't have said it on direct. It turns out in the middle of cross-examination that Alan Jackson points out that the video is inverted and that indeed Proctor was near the right rear headlight. And then behind the car, you couldn't even see what he was doing at one time. He was shielded at the right rear headlight. And yet Buchanan had testified that Proctor, that no one was near that right rear headlight. No one. I mean, that to me is a major problem here, and how you can then credit Buchanan or any of the testimony as saying that was accurate or this Sally Port video isn't important is beyond me. But those were the arguments that Brennan made. I don't know if Michael Bryant's been listening to me talk on and on about what's been going on.
Well, I could only hear a little bit as I was running from the police, apparently, as I was running down the block to hook up the Starlink because we couldn't count on the court.
Yeah,
Wi-Fi
you know what I figured,
longer.
Michael Bryant, I think that there was so many people on the court Wi-Fi at this point that leaving court, that it's just too many people to get a good signal.
It also could be 4 o'clock or so they start shutting things down. Who knows?
Right. They
Anyway.
turn down. Like we've had that happen. I think in Orlando. Remember they turned the Wi-Fi off
I
for
remember that.
for the reporters at 4
That's
o'clock.
That's why we got the Starlink. You got me now. You got me.
Yeah, I have you. I got you. You got me now. I got you.
You got me?
I got you
Okay.
now. Yeah. Do you feel me?
So I don't want
Do
to
you feel
interrupt.
me?
I don't know. Yeah, you feel me? I don't want to interrupt. So finish whatever your thought was, and then I'll try and jump back.
All right, so they basically were. And I talked about Alan Jackson. I talked about some of the issues that if I were the judge, I would be gravely concerned with. And I talked about the fact that I think when I left you, I was talking about the fact that I gave Hank Brennan. I think he's a good attorney, and I thought, wow, he did a nice job until I learned that the video, there was backup video, and actually he's the one who found that out and revealed it. There was backup video. The videos weren't just erased in 30 days. There was a backup, and we never heard that before. But then when he accused Yanetti of violating ethics rules by giving an extrajudicial statement, which it turns out it was nothing more than a hearing that had been done in open court that was broadcast on Zoom for Court TV, I said, okay, I don't give him any breaks anymore. That means he did what he did to Alan Jackson, in my opinion, purposely back then when he accused the defense of not turning stuff over, because he just did the same thing now. And whoever gave him that information, that to me, if I were Judge Beverly Cannone, I'd be pretty pissed.
Yep. She's got a lot to chew on because here's a shocker. She didn't really make any decisions from the bench. Let me give you just some highlights of what we'll be posting in a bit as I was scampering around. First of all, I've had an interesting interview with a guy who, not unlike Turtle Boy, Aiden Kenney, was accused of intimidating a witness. And so you'll find that story interesting in how stupid it is and how the Commonwealth, through law enforcement, has done everything they can to shut down any sort of pro-Karen Reed speech. Really, it's truly a First Amendment issue. Which
Has
is
he
really
been charged? Has he been charged?
He was charged, and you'll have to watch it. You'll have to watch it, Linda. He was charged, and then ultimately.
Do I have to watch the
Seven Members page? I have to be a member.
So, all right. So let me tell you all, the Michael Bryant. I told you can hit like and all, and that's all free. But to get these videos early on, you have to be a member, and then I guess I'm going to have to join because I can't get in since
no breaks for you.
I don't run the account.
So it's relevant because Aiden Kenney had just had his hearing, which is basically 16 counts of witness intimidation, based on all kinds of really dumb things. I think I may have written that in my notes. These are dumb, but that's going to be the interview with this gentleman. Will be thrown up there as soon as I get a chance. I waited around for the attorneys to leave. Primarily, it was Alessi and Jackson, and of course Ms. Reed, and the new attorney. Speaking of Aiden Kenney, that's either in the case or not in the case. He was nice enough to stop and chat for a few minutes about the situation and the hearing that we attended at 2:00 this afternoon. Still not committing to being in. He said still premature, and I said, well, just tell me your thoughts on how the hearing went.
That's Mr. Betterow. That's Aiden
Mr. Betterow. And there was an incident. This is so weird. I feel like I'm jumping around a little bit, but this is so weird. I'm in the court. They're going through these different counts, and some are just so ticky-tack. Things like telling the folks outside the courthouse, okay, you're with me on this? Here's Turtle Boy. He's outside the courthouse, 25, 30 people just hanging out like they are in most days. And he is shouting things like, tell the truth. Tell to certain witnesses that were going in, right, during the trial. Tell the truth. And that was interpreted as witness intimidation. Yeah. So that's
you got to be kidding me.
Yeah, so that's one of the 16 current counts. So guess what happens then? They get done, and they're basically he's going to rule not from the bench. Shocking. I thought the judge did a fine job. I can't remember his name. I apologize, but he was fine. He was asking, I thought, the right questions about the First Amendment and where does this satirical type commentary end and some sort of criminal activity begin. Where is that line? So I think those were all fine questions. That's where we learn more about the different counts. And he took it under advisement. He's going to make a decision. Then they have a quick sidebar. Got the white noise blaring. Shh, nobody hears what's going on. They come back out, and the prosecutor says, I was just made aware this morning, and there's a Justice Serve TV connection to this, which is bizarre.
Okay.
I was just made aware this morning that last night at McCarthy's, McCarthy's, we've been there. It's right on the main street, right.
Where you got your burger.
The waterfall. No, that was the waterfall.
Oh, the waterfall. Sorry.
Right behind me, where I got the waterfall burger, and then just up the block, 2-minute walk, is McCarthy's. And again, for those who may have forgotten, those are the two watering holes that were the subject of the partying, drinking that took place the night of the subject incident. So, right next to, and you may remember this from the first trial, right next to McCarthy's is the pizza joint. Okay.
Right.
And it's operated by the Higginses.
Right.
I'm sorry, it's operated by the
not the Higginses.
The family, Colin, and there's another guy I got him in my notes here, but I'm trying just to give you a broad brush. So anyway, this pizza joint has a surveillance camera, right?
Right.
Apparently, at some point,
the Albert family, right? Thank you.
Yes, with Colin Albert and the dad's name. I got to look that up now because it's bugging me. There's a camera, and apparently it's noticed by Aiden on the way out or on the way in. But at the end of the night, when they've left McCarthy's, he and a friend, and I'm going to just describe him as a friend because he was not identified in court. I know who he is. I talked to him just before this happened last night. And Aiden decides to go up to this camera, it's just a camera inside the pizza joint,
right,
and start saying things that I really want to get this quote down, so bear with me here.
Take your time. You've been running around all yesterday and all today because I know we're going to put a lot of things together.
Okay. Oh, okay. So he goes he's looking at the camera, right? And he says, "What have you done?" He's emoting into the camera. Was there alcohol involved? I can't confirm or deny. What have you done? I wish he was alive today too, Chris. Chris being the one working at the pizza joint, not at this moment.
Chris Albert, Colin's dad, right?
Exactly. And he's the guy who's going to look at this video the next day. So you have Aiden talking into this camera to send a message to
What
Chris
have
Albert.
You done?
What have
That's
you?
it?
Yeah, like what have you done? I wish you were alive today too, Chris. I know you didn't do it. Colin did it. Okay, so that's the message he leaves, and this is from the court's recitation of the statement given to him by the prosecution. Okay, so that's the incident. That's the whole incident. Okay, what do you think the prosecution wants to do with that?
Charge him with intimidation?
Yes. Another
Are you
count.
kidding me?
Now, Mr. Betterow was in court, but not doing the arguments. Mr. Kenney has a second attorney, and again, his name was spit out quickly, and I don't know who it was. Very familiar to the court, though, I could see that. And he said, well, Judge, first of all, where's the investigation? Where's the report? How are we supposed to even address these allegations? And you're thinking of charging, or at least recognizing the potential for another charge from the prosecution. They've done nothing. This happened, 14 hours ago, and there's been nothing to advise my client that there's something else pending and give us a chance to rebut any witness statements, any investigation. You can't just throw this in the mix.
So this is a new charge that we're talking about that they.
This is for the new. I'll call it the pizza charge, the pizza cam charge. And so the court said, yeah, okay, I understand that. I'm giving you 24 hours. So they got to come back tomorrow at noon and basically be ready to address this video statement. And
this is intimidation of a witness? Are you
I'm telling
kidding
you,
me?
there are 16 now, maybe another 17th count that have those same kind of feelings. And there was one where
tell the truth.
Aiden told followers to follow him in, they had a motorcade, right?
Right.
And they went over to I think it was, I don't have this one in my notes because they were talking kind of vaguely about the charge, but it was this motorcade in which everybody followed Aiden over to a witness's home, witness unclear to me, and basically were intimidating by just being there. Okay.
Okay.
Yeah. That's the nature of these different counts that are now pending.
I have to say, this may be the first intimidation or tampering with the witness I've ever heard, that you can tell somebody to tell the truth, and that's charged with, intimidation. I mean, what do lawyers tell witnesses all the time
I
before they
know.
get on the stand? Just tell the truth.
So here's what
Right?
the judge did. In addition to saying come back tomorrow, he set bail, and the conditions are no contact, direct or indirect, with any witnesses of any kind that are subject to be testifying in round number 2 here, or officers. And he's not to be within 100 yards of the victim's workplace or residences. And he's got to
So
come
he
back
can't go
tomorrow.
to court.
And that's an interesting.
How does
I
he
think
go
this
to-
was, and he told him, quote, as to the D&E pizza. I think it's called D&E pizza.
Yes, it
Maybe
is.
B&E, but I think it's D&E.
No, it's D&E.
He said, just stay away. So the court told him, stay away from the pizza place and stay away from all these other folks. I think that's going to be refined tomorrow when they finally do have that hearing. But it looked, in my opinion, as I'm listening to the arguments and the judge's interaction, I thought it was going well for Aiden Kearney. I thought the judge is asking the right questions. He sees that a lot of these are stupid, and he pinned the prosecution down a couple of times by saying, you consider this, and he would recite the facts, some of which I've told you. You think this is, what the law is about, and this is truly intimidation? Isn't this free speech? And so the prosecution said, well, that one might be, a little bit thin. Yeah. So it looked like the judge was, at the very least, and this was in the context of a motion to dismiss, as everything today seemed to be in the context of a motion to dismiss.
So, and this is the same office that brought the charges against Karen Reed.
Oh, yeah. And so the judge will probably, in my guesstimation, dismiss a number of these and maybe leave some that have better facts to go forward to whatever the next level might be. So anyway, that was that story. And then I ran into the gentleman who really had been charged with a similar violation, and they let him twist for about 8 months before it got in front of the court. He had to hire an attorney. He did say that people chipped in. There were a couple of people, I think he said 8 or 9, that were all charged from this same protest demonstration, all as witness intimidation charges. They were at a Walgreens, like holding signs that said "Free Karen Reed."
Oh my goodness gracious!
Yeah.
I mean,
So,
oh my goodness, great! I mean, that's unbelievable. We reached out to Aiden Kearney to have him come on the show, and I know he's been a little bit busy.
He's been a little busy.
Yeah. I didn't realize it was that many charges of intimidation.
Yeah.
And to tell somebody to tell the truth, I quite frankly, I've never heard of that before. I mean, I've never heard of that.
Yeah. And so the connection to Justice was, remember last night I was on the sidewalk there broadcasting across from the waterfall, and this friend who I had talked to earlier in the day came by, saw me, and said, "Oh, hey, how's it going?" So we chatted again. He said, "Oh, I'm going up the street to meet Aiden." And it was that meeting and the following activity that led to what is now apparently a 17th charge of witness intimidation, potentially.
Let me tell you, the Oasis.
I had nothing to do with it. I was not the friend. So
Chris
wasn't
Albert.
me.
Chris Albert is the brother of Bryant Albert, homeowner of 34 Fairview.
Yes.
Judge Beverly Cannone's brother represented Chris Albert years ago when he killed a man in a DUI. Chris is Colin's dad, and they own the pizza parlor D&E Pizza.
Yep. There you go, in a nutshell.
Oh my goodness gracious! It's really good that you were there. It's interesting that both motions to dismiss were going on at the same time, but it seems to me with that order that he can't then go to court to support Karen Reed. He can't be in the courtroom.
Hey, let me try and share something right now, and I say try because on the road like this it gets weird. But I've shared it earlier for the members, and I think if it hasn't been already, it's going to be opened up wide. It's just the intro video, when trying to catch people as they go into the courtroom, right? So let's see if we can play this out. And again, this is, you can see there, everybody's arriving. I'll turn that down a little bit. And it's weird. It's like, it's like a rock concert kind of thing. So you see across the street. If you're looking at the courthouse, behind me here, it's on the other side where this street is.
Okay.
And so they've parked their big SUV on the other side of the adjacent street. my goal, of course, is just to respectfully pounce and squeeze a question each before they zoom on by.
Right.
So you can see there's cameras behind me, and there's obviously a couple in front of me, and so it's a very weird process, this moving mob, as they go really from this side of the crosswalk, 100 feet maybe, to the steps that lead into the courthouse. It's not very far. You don't have a ton of time. I'll let you listen to this.
Go get him, Jack.
Mr. Jackson, do you think the court will seriously consider your motion?
I hope so.
Hey, right here.
Are you officially in now, sir?
Can't talk right now.
Okay, so that's Mr. Betterow.
Good job with Alan Jackson, Michael. Got a statement.
Yeah, he was hesitant, and then he did respond. Yeah, he was hesitant.
And he hopes so, and we all hope so.
And then Betterow just happened to be there, and again, he would not confirm whether he's in or not. The interview I just did was there's right there, that stuff that dead. So it's a little more substantive.
very interesting and very. Was that the woman that we interviewed last night?
That is the woman with the glasses. Her name is Dina, and I've recruited her for our alt jury.
Oh, that is fabulous. We were talking about that. I was talking about it with our chatters that we want to have that jury panel, and then we're hoping to get her. And,
she's all in, and we're going to try and get a couple other folks, so we have a few of our alternates. Anyway, so I basically re-asked the question to Alan Jackson. I said, Mr. Jackson, now in retrospect, after the fact, do you think the court's going to seriously consider your motion? And he responded a little more full-throatedly, not quite like a full-throated motion to dismiss, but with a little more insight. So that I'll post that as soon as we get done here. And then I had the interview with Mr. Betterow. So it's all kind of.
Oh, that's great. So that's fabulous. So you're going to try to post that. Now, what is your plans? Are you going to drive home and then we're going to do a show, or are we going to?
I don't know. Is there anything we need to talk about
maybe they want to see some of the interviews, but we're going to post them tonight, and then maybe I would like to get them out to our members and then get them out to everybody.
I will since I've got the Starlink up here and it's so fast. I'll upload them to members just now,
maybe for the next hour.
Whenever we're done, yeah, and then I'll have it triggered for public after that.
Yeah, well, we do that.
I like
just
to give the
now.
members a little
heads up
for being a member.
Yeah, right, absolutely, for a heads up, but maybe then after that we can see, because people have been with us all day. There are people with us since 9 o'clock chatting all day on this. Now we lost some of you who went to other channels and all, but then came back for the chat. But yes, so now we have Dina. And I'm glad that you're the only one asking questions out there of the defense.
On the way out, Matt, my friend from Court TV, we first met at the Alex Jones trial in Waterbury. In fact, Court TV wasn't even covering that, and then we were there for a long crime and saw that people are kind of crazy about this case, and so they jumped in. Nice guy, good guy. So he was there, and he was asking questions. And there's a local reporter. Woman, I don't remember who she's with, but one of the Boston stations. She's usually there asking questions. I think in the case of today's schedule, they didn't come in the morning because it was sort of wishy-washy, right? Nobody really knew for sure.
But we were there.
I was camped out, so it was fine. But they probably had, other assignments. The world's largest cookie in Boston, or one of those stories. Who knows? But they were here in the afternoon, and they were asking questions. But I got mine in.
Get yours in for Justice Served TV. That is great, and we have our jurors going, and it was I would say a full-throated day. I don't know. I know the judge is probably going to deny all this, but I really think that she should have something to think about here, because things that we're learning and things that were done. This was not as easy, and I thought Alan Jackson did a remarkable job. I actually had thought initially that he did, for whether we like him or not, because he represents the state. I thought that Hank Brennan did use the arguments that he had. Those were the arguments that you had to make, and he made them.
I did, and I'm sorry, go ahead.
In the process of making them, to learn that there was a complete backup system for all this, which I think everyone's been misled on that.
You know what bothers me most, and he certainly is advocating for his client, the Commonwealth. There's no doubt about that. And again, having met him this morning just briefly, seems like he is getting all the venom he could possibly get from the local folks, but he seemed like a decent guy. And, you know, he's doing his job. Okay,
Right.
They just don't like the job that he's doing, and I get that. So one of the things that bothers me, though, is if you say things with enough conviction, maybe you'll blow past what seems to be ridiculous. And he's talking about the lack of production of some of these videos, right?
Right.
And he describes them. Well, it was not intentional. Lally, didn't intentionally hide them. It was Proctor. Proctor became the fall guy yet again. It
Right.
was Proctor who learned about them and didn't tell anybody. So please don't hold that against the prosecution. We didn't do that. So even if you're willing to go there and say, okay, wasn't your fault. You got some loser named Proctor who's trying to do whatever he's trying to do. Why wouldn't any reasonable prosecutor ask for that information? Specifically ask. They're trying to get off with saying, hey, it's not a crime scene. That wasn't the crime
Right.
scene. Well,
Right.
who knows? Maybe it was a secondary crime
Maybe it
scene.
was a secondary crime scene, right?
But my point is, if you're taking the murder weapon to the Sally Port, don't you think that location becomes important? Don't you think, as the prosecution, you got to ask those questions? There must be surveillance video here, right, guys? And then if you've provided 90 photos, it just begs the question. There must be more, and we
Right.
need to provide to the defense whatever that more is. So I just don't let him off the hook for saying, we didn't know it was there.
No, I don't either. But judges tend to leave them off the hook, right?
Oh, yeah.
Let them off
No,
the
I
hook.
get
and
that.
that's what we expect. Although, at the least, I think Alan Jackson should get some kind of jury charge out of this, and that should be the next thing, because he's not going to get a hearing. She's not going to delay it. She's going to say you can ask those questions. She may say that you can ask some of those questions during the trial, and I'll give a jury charge as to the fact that this wasn't produced, or this was hidden by the state. But the state becomes a Commonwealth. Okay, it is the Commonwealth. I mean, whether you like it or not, So
Yep,
anybody
as she
have?
said, they're all on
Go
the
ahead.
same team, so they
That's
live or
right.
die together.
Yeah. That's why.
Oh, I had one more
so-
comment.
Yeah.
Pull up some questions. Go ahead. I just want to make one
No,
more
no,
comment.
no. Everyone's been watching. I just want to say I just want to tell everybody what time we'll be on tomorrow night. It'll probably be 6 o'clock for, we'll go through all this again, and I'm sure things are going to happen tomorrow. I had that feeling.
Yeah, and we may have a guest. We'll see. It's kind of soft at this point. We may have a guest that's been involved in some of the activities around here. We'll see how that goes. So Buchanan, he's been absolved because he said he didn't look at the video, that he knew it was there, but he didn't look at it. So he's somehow absolved of the mysterious inverted video. But it still doesn't answer the question: how and why is it inverted? And then we hear that the camera is tossed because it's somehow, it's defective. It still doesn't answer the question: does somebody somewhere build a camera that just inverts video accidentally? Is there a switch on the camera or the recorder that switches it to inverted? I just think there's too many questions. You can't just say, "Oh, he didn't know, therefore who cares?"
Well, except that
still
in fact he
wanna know.
testified that it was a depiction of the actual scene, and that's where I think he's in trouble, right? He sat there testifying to that jury, and then he said he knew it was inverted. He testified to that jury, unless Alan Jackson brought it up.
Yeah, once he was crossed. Yes, once he was crossed. But their position still is, whoopsie, we didn't know.
Yeah.
It just seems to be the camera caught everything inverted.
And it's your
That's
fault.
not a very
and it's your
satisfying answer, to take the words of Judge Bev.
And it's your
not very
fault, offense, because you didn't ask for it in the first place. And by the way, even if you did ask for it in the first place and we didn't know about it, it's your fault because your client's guilty. That's what.
And if you look at the protective request, it goes beyond just scene of the crime. It says things reasonably connected to. I mean, it's very clearly designed to encompass the unknown, right?
Because one time we get in cases we don't know what exists, so you have a broad request. But they knew because they downloaded it. That's the.
Yeah, but again, here's a retired guy and here's a disgraced guy. Proctor and
DM Pietro.
Yeah, Mr. D.
DMGM Pietro.
Yeah,
Everyone had trouble today.
He's now retired.
Right.
And so those are the folks that are being, thrown into the cauldron, and that way all the other folks have clean hands. I just don't buy it.
I don't buy that either. But we're going to have to see what Judge Beverly Cannone does, because I do think she was upset at the. She did ask to see the court TV video. I do think she was upset at the allegation against Yanetti. You throw shade on the local guys who everyone likes. That's what gets you in trouble. You throw shade on us out-of-staters, and people say, so what?
Yeah.
So.
Yeah. They're what's the word I'm looking for? Disposable.
Yeah. And by the way, Lisa Lou asked the question, Michael, isn't Brennan's ethical duty as a prosecutor to seek the truth and not to make stuff up?
Yeah, I think is that a rhetorical question? Yeah, I think the answer there is pretty darn straightforward, and we like to go in hoping people don't do that, and it's not good when we find out they did or it appears that they did. But yeah, that would be what I call doing the right thing.
Okay, and one other one before you go. Alert One Systems, who does this, as you know, he's emailed us. It's an installation oops feature if the technician put it in upside down usually. Interesting.
Yeah, I mean, that's why I don't understand the technological. How do you get from here to inverted? What's going on? Is it purposeful? Is it just a machine that's broken? It just makes no sense without further investigation.
Yeah. So maybe as Mrs. Cap points out, there's not one photo on the damage to the 6,000-pound vehicle. Maybe they'll find those. Who knows? We got a month of trial. Things just pop up.
Yeah. Or where are we now? We've got what is today? Today is Wednesday, so we've got less than 4 weeks now before it launches, and who knows what's going to happen between now and then.
Yep, and of course we're going to be there to cover it. So Alert One System also said there's really no reason to have to flip it horizontally and not usually a feature. So I mean, something doesn't make sense.
And here's what's interesting about that, because we've done that with videos we post. Sometimes you have to go and edit them and maybe rotate them, right?
Right.
But this is a capture issue. If you believe the prosecution, it's captured in inverted. That's not a normal tweak that you would make to video.
Right. It doesn't make any sense at all. So what else do you have? I know, because you've had 2 very long days, and you've still got to upload the videos and have a long day going home. So
that's all right. I like the reference. They got to the jury tampering. That was the last thing they talked about. And of course, Brennan gets very ominous about it, and very, very scolding, and it's a very serious allegation. And so you just, as this theory, you plant the seed of corruption, and that spreads, into, in theory, the jury pool. And then he talked about the interview that was given most recently to Boston 25, which included Alan Jackson and Karen Reed. And Alan Jackson in that says, quote, "I have no specific evidence of jury tampering." And obviously in his affidavit in support of the motion to dismiss, he's, going after Fanning and suggesting that, in fact, there was jury tampering, although he clarified it in his response saying, "I call it jury interference." So whether it's tampering or interference, Jackson's position is we didn't know everything. All we knew is Fanning, and that he had talked to somebody who talked to somebody who talked to a juror. And so, we think that gives the appearance that something ain't right. And we're concerned about that, and the court should be concerned about that.
Yeah, and they asked for a hearing at the time, which we didn't even know this has all occurred, and she denied it.
Yeah.
So there we are.
Too surprising.
Welcome
okay, then.
to
That's all I got from here.
All right, so you're gonna upload the videos to our members, and about an hour after that, they get to see them first, and we're gonna post them because you have some interesting stuff.
Then, on the way home, when I stop for a bathroom break, I'll convert them to public. So get ready for that.
Yeah, and Missy and Disney will be on this, so they can tweet them out, X them out, share them out to everybody, because you're there. Why not? You're one of the few streamers that's there, the content creators that are there. Covering this now, getting these interviews right now. So for Justice Serve T, as I said, we're small, but we're mighty, and we are committed to our viewers. So I'm going to let you get on the road, and I guess we'll see everybody at 6 o'clock tomorrow night for our full show.
Yep, that sounds good. I will hit the road. In the meantime, I'm going to do the right thing.
I'm Linda Kenney Baden together with Wendy Michael Bryant. We are Justice Served TV. And please hit that like button right now before we go. Hit that like button if you haven't done it. Subscribe. It's free. Share us. And of course, notify with the all button. And you'll get notified tomorrow at 6 o'clock. Or if we go on sooner, if there's some breaking news. Stay with us and we'll see you tomorrow.